Every day in the USA, people find themselves in court.
You just let me know when you're done yelling. I'm just signing these orders.
Oh, I'm ready.
Oh, sorry, I thought you marked this up. All right, let's go on the record in the matter of the state of Michigan versus Jason, is it Fontaine or Fountain?
Fontaine, Your Honor.
Fontaine, 25507. And appearance for the people, please.
Good afternoon, Your Honor. This is Governor Matherly for the people, P number 87297.
Good afternoon.
The state of Michigan versus Jason, is it Fontaine or Fountain?
Fontaine, Your Honor.
Fontaine, 25507. And appearance for the people, please.
Good afternoon, Your Honor. This is Governor Matherly for the people, P number 87297.
Good afternoon, James Parker, on behalf of Mr. Fontaine. My P number is 53832.
All right, thank you. And Mr. Fontaine, your name for the record, please.
Jason Fontaine.
All right, please keep your hands out of your pockets. Today is the date scheduled for the preliminary examination, and are the people ready to proceed?
Yes, we are, Your Honor.
Is the defense ready to proceed?
We're ready, Your Honor.
All right, are there any preliminary matters that we have to address?
Yes, there is, Your Honor. There's been a stipulation to the Wyandotte Police Department Controlled Substance Preliminary Field Test Analysis form. It was the arresting and field testing officer, Kyle Cox, who at this incident recovered 6.52 grams of crystal rock-like substance, which tested positive for 6.52 grams of methamphetamine.
All right, Mr. Parker, you're stipulating to that, correct?
We'll stipulate for preliminary examination purposes only.
Okay. Thank you. All right, and anything else?
I have nothing else.
Anything else, Mr. Matherly?
No, Your Honor. The people are ready to call witnesses.
Okay, and so the people's first witness.
The people call Officer Kyle Cox.
Okay. And you may go forward, thank you. All right, if you could please raise your right hand. You solemnly swear or affirm the testimony you have to give this matter with the truth, the whole truth, and nothing but the truth.
I do.
All right, thank you. If you could please have a seat and state and spell your first and last names as loudly as possible so that we can make sure we're getting everything recorded.
Officer Kyle Cox, Kylecox.
Okay, can you speak a little bit louder, please?
Want me to repeat myself?
Well, I need you to speak directly into the microphone then, because
Okay.
you have a little bit of a softer voice. All right, so, Mr. Everly, you may proceed.
Thank you, Your Honor. Are you employed?
Yes.
Where are you employed?
The Wyandotte Police Department.
All right. What capacity are you employed at the Wyandotte Police Department?
Police officer.
All right. And were you employed in that capacity on April 14th, 2025?
Yes, I was.
Okay. And on that day, did your duties take you to the area of Goddard Road and 13 in the city of Wyandotte in the county of Wayne?
Yes.
All right. And so what were you doing in this location at that time, on this day?
I was just on general patrol
Okay. Do you know what time this was?
around midnight, 12:15.
So these were like the early hours of that day.
Correct.
Okay. So while on patrol out there, what, if anything, did you observe?
I observed a male walking on the north side of the street on the sidewalk.
Okay, and so let's kind of get a layout for this area here. So what kind of area is this?
On the north side of the street, there's no residents, no buildings, businesses, or anything like that. There's a
I
park.
need you to keep your volume up, please.
Correct. There's a park to the north of Goddard Road. No houses, no residents or anything like that. And then there's a bridge that goes over a creek beside Goddard Road that 13th Street leads into.
Okay, and then you saw the man doing what?
Walking along the sidewalk, hoodie up, hands in their pockets, and then just head down, walking beside the park.
So what did you do upon this observation?
Well, I patrol this area regularly. I don't ever see many people. It's irregular to see someone there in that time and place. So I stopped my patrol vehicle just to speak with the man.
All right, and so did you do that?
Yes,
Okay, and did you make contact with this man?
yes,
Did you get a look at his face?
yes,
Do you recognize him in the courtroom today?
yes.
Please point to him and identify an article of clothing.
Dark blue shirt.
Can you give is there any accessories on this individual?
The glasses.
Okay.
Well, the court will take judicial notice that, the other individual at the table, Mr. Parker, does not have a dark blue shirt on.
Well, he's wearing a suit, but anyway, I just wanted to double
Yeah.
check. So anyway, but, yes, at this time, Your Honor, the people motion that the witnesses identify the defendant in this case.
Okay, anything for the record, Mr. Parker?
So stipulated, Your Honor.
All right, the court will indicate the defendant has been identified.
So what you spoke to him?
I did.
Okay, what was the conversation?
I initially asked like where he was heading to, if I could assist him in any way, asked him if I could give him a ride, if he was all right.
Okay, but at this point, this wasn't any sort of like criminal stop, he was free to leave at this point.
Correct.
Okay, so at this point, there was, strike that last sentence. All right, and so what did he say to you?
He had just stated, he was just defensive and anything.
I'm sorry, I can't hear that. What'd you say?
He was very defensive, and when I was talking to him, even asking about his welfare, he declined a ride, which that's okay. He didn't want to answer where he was going or where he was coming from. Again, it's consensual talk, so I just recognize his behavior as slightly not the norm of someone that I just stop in the street and check on their welfare.
You said.
Well, I think we're getting into his opinion here.
I was just gonna elaborate just a little bit. I was just gonna say, you said this was a consensual talk, that was exactly what you said. So what makes you say that?
I did not activate my patrol lights on him. I simply stopped my vehicle, exited the vehicle, and spoke with him, which he willingly approached me as well, and we had a conversation.
Okay. And so did this conversation cease? So once he said he didn't want to ride, did this conversation end?
I'd asked for his name, I like to document who I speak with on the road, which he then declined to provide, which I then advised him that he was free to go.
Okay. And so did he walk away?
He did.
Okay. All right. And so did you return back to your vehicle?
Yep.
Okay. And just real quickly were you in uniform that night?
I was.
Okay. Can you describe that uniform for me?
The same uniform that I'm wearing right now.
Okay. So I mean, is there any just for the record here, are there any markings?
Yep.
Or,
Lined up police badges on each shoulder, police badge on my chest of my vest, and a big police logo on the rear of my vest.
Did your vehicle bear any similar markings?
Yes.
Was it marked police
Is that
car?
yes?
Yes.
Was it a marked police car?
Yes.
All right, so after he walked away, where did he go exactly?
He continued walking westbound Goddard on the north side of the street
Okay,
towards that bridge.
and where did you go? Did you went back to your
I
car?
returned to my patrol vehicle to then continue traveling westbound.
Okay, so did you start traveling westbound?
I began to.
Okay, when you say I began to, what do you mean?
I got into my vehicle to travel back westbound Goddard.
Okay, all right, and so what if anything happened next?
I observed Fontaine, then reached the corner of the bridge in Goddard, and then crossed the street where there's no crosswalk, nothing posted, completely, you're not allowed to cross there.
Okay,
Which obstructed, I would say, I could not continue westbound Goddard until we finished crossing.
okay, so when you say you're not allowed to cross there, so he crossed the street?
Correct,
Okay, was this in front of your vehicle?
directly in front.
Okay, was this happening as you were going down the street?
Simultaneously,
Okay.
I was putting,
And so upon this, what did you do?
he finished crossing the street, got to that side of the street, and then I had driven up a few a few feet, probably about 50 feet. And then I re-got out of my vehicle and advised him of a violation that he just committed directly in front of me.
Okay, and what violation did you tell him it was?
Jaywalking.
Okay. And so upon this, what did you do?
I just asked him, I advised him that it was just a minor violation. I would just have to acquire his name.
Okay, and so did you get his name?
He then provided me his name, yes, and then admitted that he had active warrants.
He admitted that to you?
Correct.
Okay. And so did you confirm this in any sort of way?
Yeah, other officers arrived on scene, just to sit with Fontaine. I returned to my patrol vehicle and conducted a lien inquiry.
Okay, so lien, is that, what is lien?
Law enforcement information letter.
Okay, is this a tool commonly used by the police?
Yes,
All right, and so in this, did you confirm the warrants?
yeah, he had 7 active.
7 active?
Yeah.
Okay, and so upon you observing this on lien, what did you do?
Well, all the warrants that confirmed the valid. And then I exited my patrol vehicle, traveled back to Fontaine, advised him that he was under arrest for his warrants.
And what happened next?
He was handcuffed, a search of his person was conducted, and in his shoulder bag, fanny pack thing that he slung over his shoulder, in the zipper pocket, I located a knotted cellophane bag with crystal rock-like substance.
All right, before we get to that, this fanny, it was like a shoulder fanny
Correct.
type thing, so did he have this on, like, throughout, like, when you first saw him and everything? Okay, so this was the accessory he had on during this entire duration of this incident?
Yes.
Okay, so you searched it?
Yes.
Okay, and why you searched it again, I'm sorry?
He was under arrest at that point.
Okay, so you searched it, and what, if anything, did you find?
So in the main compartment, which was located on his back, in the zipper pocket was a knotted cellophane bag containing a crystal rock-like substance, which I immediately recognized as methamphetamine.
All right, and so what did you do with this substance?
I secured it in my vehicle. Advised him that he was also under arrest for methamphetamine.
And did you submit it into evidence?
I did.
Okay, and did you have any more contact with that substance?
Just field testing it and putting
Okay.
evidence on it.
Where did this field test happen?
In the Wyandotte Police Department.
Okay, and did you, what field test did you do?
The NIC2 methamphetamine MDMA reagent kit.
All right, and just for the record, can you explain how that works?
You take a small piece of the substance, whether it's a little piece of residue, it doesn't take much. You open the field test, you then put it in there and you seal it, and there's glass vials with liquid, you crack those, and then it turns, for methamphetamine, it's a dark blue, purplish color, if it's positive, which
Have you done that before?
yes,
Okay. And are these common tests used by the police?
yes,
Okay. And so did you follow that same exact procedure for this substance?
yes,
Okay, and what was the result?
it was positive,
Okay, what color did it show?
dark blue, purple.
And this was all from fanny pack fanny pack shoulder sling that was on the defendant when you arrested him?
Yes, there was also in the front, kind of on the strap portion of the fanny pack, there was another small pouch, which a pipe used for smoking methamphetamine was also recovered from.
Now, did you weigh the substances at all?
I did.
And how much did it come out to?
6.5 and some change.
And some change. Did you ever fill out like a preliminary test form?
Preliminary field test.
If I were to show that to you, because you said and some change, I just want to confirm the exact amount. If I were to show it to you, would you be able to? Okay. You want me to approach and show
Yes.
him? Oh, sorry.
Sorry, I did not see that. It's in here.
Permission to approach the
That's my
witness?
computer there. Yes, permission. Sorry, Brian.
That's all right. Do you recall the weight of that substance?
Yes,
How much?
6.52 grams.
All right. No further questions.
And
Thank you. And cross-examination.
Mr. Cox, so let's describe that area. You were by yourself, is that correct?
I was.
And so You're saying that my client, was he on 13th or was he on Goddard?
He was on Goddard.
I'm sorry, we're just gonna take a quick break for one moment.
Okay.
Just everybody can see where they're at.
Okay.
Okay, I apologize. Right, and so we're back on the record.
So, Mr. Cox, you said that you're by yourself, is that correct?
Yep,
And so you said you approached Mr. Fontaine because you don't regularly see people walking down that street?
correct.
All right, so describe that area. What is it? Is it residential, or is it industrial, or nothing?
So it's a border street of our city. A creek goes along Goddard Road and bends. So on the north side of Goddard Road right there, there's a big open field. There's a park. To the south of Goddard Road, there are residential streets that continue south.
So the particular position you stopped Mr. Fontaine in, is it fair to say to get to the park, you would just cross the street?
I don't understand your question.
Was the park right across the street from where you stopped Mr. Goddard?
No, he was on the same side as the park.
He's on the same side of the street, the park, what's on the other side?
The first time I stopped him.
The first time, we're only talking about the first time.
Correct.
First time you stopped him, the park's on that side of the street. What's on the other side of the street?
Residents.
Residents?
Yep.
Okay. So at this point in time, you got out your vehicle. Did you have your video on, sir?
Yep, I had my body worn camera on.
You had your body worn camera?
Yep,
Yes, is that yes?
yep, yes.
So did you have your body worn camera on or the car video on when you observed Mr. Fontaine, either as you described, jaywalk?
I had not, because our initial conversations ended. I had shut my body cam off, returned to my vehicle to then carry on with my patrol.
Did you give your body cam information or video to your OIC?
Yes,
So he should have it?
yes,
Is there a different number between the number of this first stop versus the second stop?
no,
So it should all be the same thing?
correct. There should be 2 body worn camera videos.
2 body worn camera videos? Right. Well, I'm looking for any video of the first stop. I have video. Yeah, thank you. So you're saying that this particular incident, you did have your body cam video on when you talked to Mr. Fontaine.
Yes,
Then you go to your car and you turn it off.
correct.
And then at what point in time do you turn it back on?
When I was exiting my vehicle again to make contact again with Fontaine after he committed a violation.
So it's fair to say your observations of Mr. Fontaine on that second stop of yours is one that wasn't recorded, right? Actual alleged jaywalking, is that correct?
Correct.
When you first started to talk about the initial stop, you said that you generally don't see people walking down that street, is that correct?
And it's not that I don't see people walking on the street. With the area and time, it's irregular to see people walk on the walk, yes.
And so you said that you offered him a ride?
Yes,
And so what, do people just generally get in your police car when you offer them a ride?
we often give courtesy transfers, yes,
You do that?
yes.
Okay. And on the second part, or the stop, after you say that you see Mr. Fontaine jaywalk across the street, what do you feel constitutes the jaywalking? When you say he can't cross at that point?
There's no crosswalk, there's nothing, there's no even entryway from the sidewalk into the road to cross.
So how do you get across the street at that point in time?
You walk to the next crosswalk.
You don't walk to the next crosswalk? And how far is that from a particular point in time? What is it?
I believe there's a crosswalk further east, near 8th, so a few blocks. Or you can continue the next, if you will continue west, not until 4th Street.
So are you saying that the only place you could cross the street legally, in your opinion, is going a couple of blocks down?
Correct.
And when you say a couple of blocks, we all talk about blocks. What do you call a block? Is it like?
So he had already passed the last crosswalk because he was coming from the east, he was walking west.
Okay.
So he had opportunity to use the crosswalk.
Well, do you know where he was coming from?
Yeah, he stated, he had pointed, he had stated he was coming from that way, from the east.
So he pointed backwards and said, I was coming from this way?
Correct, I believe he said he was coming from, I wouldn't be able to say exactly where he was coming from. He said he was coming from a girl's house.
Okay.
And then pointed.
But, so did he get detailed in terms of what, where he exactly was coming from, or he just said he was coming from a girl's house?
Yeah, no, he didn't get very detailed. Like I said, he did not really want to speak with me.
Well, you did see him walking in that direction, right?
West.
West, right, okay, and so are we talking about the first time you talked to him when he said that he was coming from his girlfriend's? Or-
Yes.
Okay. So he was coming from that particular direction and he's heading north,
He's heading west.
heading west?
Yeah,
Okay, he's heading west. West on 13?
got it.
Goddard, west on Goddard. Goddard. So the cross street, when you say 13, is that the one that's 2 blocks away?
No, 13 is where he jaywalked.
13 is where you jaywalk.
Correct.
So when you say Goddard and 13, I get the impression that that's a cross street, right?
It's an intersection.
An
yes.
intersection. So what, he can't cross at 13?
You can't, there's no crosswalk or entry of sidewalk into the street.
Don't know this area. 13, cars go up and down 13?
Yes.
It's a street, it's a real street.
There's a bridge at 13th that leads into the city of Lincoln Park.
Yeah, that's where I get sort of confused when you say bridge and a creek and all that. I don't know if this is rural or what, so when I ask the question, 13, it's a regular street,
Yes,
cars go two-way traffic,
13th is now a one-way.
it's one way. But you can't cross there, you're on
No,
the sidewalk.
you can only cross if you were to be on the south side of the street already. You can cross east to west. There's a crosswalk there. But there's no crosswalk north to south. Cross Goddard Road.
Okay, may I have a minute?
Yes.
All right.
Any more questions?
I'm gonna have my investigator go out there and map it out. I didn't know it was that detailed stuff. I have no further questions.
You want to draw it out on the board?
I'll have my investigator take care of it. You won't go that way.
Well, the people who bind over on,
Hold on, do you have any redirect?
oh, yeah, you're right. I'm sorry, no further questions.
Okay. All right, and I do have one question. When you first made contact with the defendant, he was on the north side, and he was in between, what is that, 9th Street and the creek? Because he was at Beaver Park, correct?
Correct.
Okay. Was he walking on the grass or in the road?
He was walking on the sidewalk. There's a sidewalk in between Goddard Road and Beaver Park that ends at the 13th Bridge.
Oh, that's right, okay. All right, okay, thank you. Any further questions based upon those questions?
None from the people.
Okay, and Mr. Parker, any questions based upon that?
I have nothing at this time.
All right, Mr. Matherly?
Yes, Your Honor, people move to bind over, I believe it's just count one, and then there's individual offender attached to it, so just for now, Your Honor, just count one. And we reserve argument for rebuttal.
Mr. Parker?
Yes, sir. Your Honor, we disagree with the bind over. We feel that this stop was contextual in nature. I think that his Fourth Amendment rights were violated. This officer has to have something more reasonable suspicion, reasonable inquiry in terms of whether or not there's something criminally afoot. And my client was simply walking down the street. The officer approached him and talked to him, and I just feel like his rights were violated, and we ask you not to bind over on that. So,
And Mr. Matherly?
Your Honor, here, we have, on this night, we have Officer Kyle Cox going through the area, and we see that, well, not we see, he observes the defendant walking down the street. Well, at that time, he realized the defendant, but he later identifies him as the defendant. But walking down the street, he goes up to him, and he testified earlier that it's very common that we ask people who are alone, like later at night, if they need a lift, need anywhere to go. So at this point, and also he said that he was free to leave at any point. He said this was consensual talk. At this point, this was not a Terry stop or any sort of criminal stop for any sort of purposes. He was not asking any sort of incriminating questions. He just wanted to see where he was going. He just wanted to see if he could take him. And so then he gets back in his vehicle, and then he observes the defendant jaywalking across the street. So then he goes over for the civil infraction, goes over and speaks to him, gets his name, is told that he has warrants, goes and confirms the warrants, then goes and arrests him. I think it was 7 or 7. He said several or 7 warrants, and then goes over and search incident to arrest. He finds it was a meth-like substance that he recognized as meth, and he did the field test, which confirmed that it was methamphetamine per People's Exhibit 1. And so, yes, Your Honor, the people believe that the burden of probable cause has been met, and we move to bind over. Thank you.
All right, and the court will note that the court has, I'm sorry, you may step down. I'm sorry, I forgot that. So the court has heard testimony that the officer had brief contact with Mr. Fontaine, and nothing came of that. Mr. Fontaine didn't give his information, and the officer didn't pursue that, and he was free to leave. It wasn't until Mr. Fontaine violated an ordinance regarding jaywalking, and that is when the officer had contacted and asked Mr. Fontaine for his information, because at that point the testimony was he was communicating with him regarding the violation. At that point, Mr. Fontaine, per testimony, gave his name, also offered up that he had warrants out for his arrest, and as such, the officer was conducting a search incident to arrest. And so therefore, based upon that, the court does find that a crime that's not casual in district court has been committed, there's probable cause to believe defendant committed that offense. The court's going to bind the defendant over on count 1. And you are to appear in circuit court on May 29th at 9 a.m. on the charges of the complaint.
Thank you.
Thank you. And Mr. Fontaine, if you're to test right now, what's in your system?
Nothing.
All right, bond and conditions are continued. Counsel, you're 53832, correct?
That is correct, Your Honor.
Sorry, guys. Let's go off the record for a moment.
I have to make sure you give me somebody else's number. I will be able to contact you.
Okay, so we have to get Schroeder out back, so we want to.
I want to confirm that my witnesses are here because I know Parker. I know River Rouge for some reason, one of his, that's River Rouge,
Riverview?
Riverview, because I do River Rouge as well. I know that they only have 2 officers going out, like, on patrol right now, and both of them are my witnesses for some reason.
Those things happen.
So, I want to make sure they're both here.
Okay.
All right, then. We'll work it.
Mr. Parker, can I just ask you real quickly? I just want to show you something.
Yeah.
Okay. I just want to make sure I wasn't like.
No.
No.
But he answered the question was, video, or he did not have this.
So that video actually was called. So, no.
Are you appearing on behalf of Ms. Locke?
Yes, Your Honor.
All right, we're gonna go on the record in the matter of the marriage of Brian Farthing versus Catherine Farthing. It is 2024 DM 311. The petitioner appears through Mr. Hughes and on behalf of Ms. Locke this morning. Ms. Farthing appears, she is self-represented. Her attorney has withdrawn from the case, which I authorized. We set this matter for review. It looks like the parties are close to having what they need. I don't remember if there's a contract on the house or not, but I wanted to do an update, frankly, and I don't know, Mr. Hughes, if you're familiar enough to give the court an update on where we're at and where we're headed.
Yes, Your Honor, I've been clued in on it. So on discovery, there are a couple of outstanding things. We have a business record subpoena we're still waiting for a response on. And then we've also issued interrogatories to Ms. Farthing that are at this point over a month. We issued them April 4th, and we haven't gotten a response from those yet. We've sent Ms. Farthing a golden rule letter about that, and still no response. So we may be headed toward a motion to compel potentially on our interrogatories about her finances and other issues for that.
Okay. Amy, do you know, is there anything in the file that I might be missing or anything you need to bring my attention to in this case?
Not that I'm aware of. The last thing filed in the case was 5-1, which was a motion to withdraw from Eric Kidwell.
Okay, that's what I showed.
Yeah.
Ms.
Outside of that
Farthing-
was just an email from Miss Locke advising that Mr. Hughes was gonna be filling in for her
Okay.
today.
Ms. Farthing, is there some reason that you've not completed discovery in a timely manner?
Yes, Your Honor. I was informed on Mother's Day of the interrogatories. I had told my attorney I'd objected to the subpoenas on March 26th, but then she withdrew. So apparently there was some kind of mix-up in communication. Now Miss Locke said that she had emailed these items to me and I never received them. She also said that she mailed paper mail and I never received that. I would have thought that maybe it would be registered mail or be served by a processor for these items. And that's where I'm at that. I was just informed on Sunday of these interrogatories.
All right, well,
you're-
Mr. Hughes, why don't you forward them to us and we'll forward them to her? And we will have them clocked here, so we know when her 30 days is, and we'll confirm that she received them. But Ms. Hughes is pretty good about following protocols and dotting her i's and crossing her t's, and there doesn't need to be any special service. It's your address or your attorney. They're served on your attorney when you have one.
I think that's maybe where things got a little cross-wired.
Okay, well, that attorney that withdrew is supposed to update you on everything and put everything in your lap if they're withdrawing. But Mr. Hughes, I will give you a chance to respond on the record.
Okay, so Susie told me that she sent the court a set of exhibits, and in one of those exhibits, it's a record of a text message from Miss Farthing to Mr. Farthing, where she says, you can sit there and ask for bank records all you want. And that text message was sent on April 4th, which
Yes.
would indicate she did know about these interrogatories the day they were sent.
No, I'm sorry, sir, but that was for the subpoenas.
All right, well, I'm gonna set a deadline on discovery, and now that she's unrepresented, I'm just gonna go ahead and have you all forward the discovery to us. We'll forward it to her, and that's when her 30 days will start to run. And hopefully get this thing scheduled for trial. Amy, we don't have any trial dates or anything.
The only thing that Miss Locke had indicated is that, in her most recent email on Wednesday, she said that she was advised that the Mattingly guardian and conservator case set the end of July is, settled by consent. So that will open up a trial date, but I don't know if that's gonna be too soon.
Oh, yeah, I've got to give her 30 days to respond to discovery if we're gonna do it this way, and so that's June 15th at a minimum. I don't know when they're gonna get their subpoenas back. July.
It's July 29 and 30 is where that probate case is scheduled. And we have a
We
domestic on the
might
31st.
be able to do that if I do a discovery submission cutoff of July 1st. And then we could do, which dates did you say?
The trial on that probate is scheduled Tuesday, July 29 and the 30th, 2 full days.
And you said it's settled?
Yes, per Miss Locke. She said that she was told Tuesday this week that it's been settled by consent. So that'll open up those 2 full days for trial and the 11th. Which I think is where we have a pre-trial hearing scheduled.
All right, I'm gonna go ahead and schedule this for trial. July 30th. Amy, can we just do a quick, can I have you do a quick scheduling order?
Yes, I can do that.
That'll be 9 to 5. And, see, this case number is 24 DM 311.
We've got a pretrial or a domestic day on July 10th if you're looking for a pretrial date. And Miss
Yeah.
Locke is on your 4 o'clock cases.
Do what?
Miss Locke is already on your 4 o'clock cases on that July 10th date.
Okay, let's go ahead and do this one at 3:30. For a pretrial conference on July the 10th. So discovery cutoff July 1, of course, this farthing yours is gonna be due within 30 days from the date it gets forwarded to you. But any submission cutoffs are July 1. And then we'll do a pretrial conference July 10th at 3:30. And a trial on July the 30th, 9 to 5.
Okay. Thank you, Your Honor.
All right, anything further, Mr. Hughes? You can convey all that to Ms. Locke.
Yes, Your Honor. We have the issue of the house sale. The house is under contract right now.
That's what I thought.
I understand the court ordered Ms. Farthing to jointly share in the mortgage expenses and the utility expenses and all the other expenses up to the sale. That hasn't occurred, so Mr. Farthing has had to front all those costs so far.
Okay,
And so just going forward in the sale, we'd ask that Mr. Farthing be allowed to complete the sale without any further action needed from Ms. Farthing.
well, when's the closing scheduled?
I don't know off the top of my head. I could probably find that.
Your Honor.
Looks like it's scheduled for June 10th.
Okay. Yes, Ms. Farthing.
I have a few questions. Since I'm having discovery done on my bank accounts, is the same going to be for Brian?
No,
And if he's going to be solely responsible for the sale of the home that I bought on my VA and paid for, just like him, I need to make sure that that VA loan is going to be paid off.
well, no one is gonna do a closing on a house where the mortgage doesn't get paid off.
Okay.
That's the first thing that occurs. So, I do want Mr. Hughes to submit to her, a state, he should get at some point, a closing statement. A proposed closing statement, I think. That needs to be sent to her. And then any items that, she didn't pay on that are to be deducted from the sale of the house. And the proceeds, there just needs to be a list of that to give her notice. And from the time she receives it, she's got 7 days to object.
I did see a sticker on the home that said it had been winterized, so I'm assuming that all the utilities have been shut off, including the water.
Yeah, I don't know. Listen, I can't get in the middle of this. This is
I
something
know.
you're gonna have to email Ms. Locke about.
I apologize.
But that's all right. The answer to your question is no, they have no obligation to produce anything to you other than to disclose assets, which they should have done at the beginning of the case. But they have no obligation to provide you with anything unless it's requested in the form of discovery, which is something that your attorney would have done, or you can do pro se, just as long as you submit it in time that it can be responded to by July 1st. And then you're free to subpoena whatever you want as well, since you're acting as your own attorney. But the only thing that's reciprocal discovery is when you're preparing for trial, if you're going to call witnesses, a list of witnesses, and if you're going to produce exhibits, a list of those exhibits, that's reciprocal. But otherwise, the rest is produced in the form of formal discovery under the Kansas civil procedure rules. Okay?
Okay.
All right. If you need me before then, Mr. Hughes, let me know, schedule something up if we need to do a quick status on something that has gone awry, given the fact that Ms. Farthing is self-represented, but otherwise she's going to have to try to communicate by email with her to maybe settle any remaining issues that exist since she's unrepresented. Okay, we are adjourned. Thank you.
And Your Honor,
Thank
before
you,
that,
Your
I do have one
Yes.
more thing I wanted to bring up.
Yes.
The spousal support and child support schedule, it looks to me from the Kansas Payment Center records that Susie provided to me and that provided to the court that Mr. Farthing has been making all of his payments, $800 to Miss Farthing on time, but Miss Farthing's child support payments haven't been made since this case started. There's no record of that there, so wanted to bring it to the court's attention that it doesn't look like that obligation is being fulfilled.
Your Honor, I have had custody of my youngest son since the middle of February.
Yeah, I don't recall that obligation, but I'm just gonna remind everybody, anything under court order that you're obligated to do, you need to do it. And if not, you're subject to a motion to compel and potential a contempt citation, which could result in sanctions of being ordered to pay attorney's fees, having to pay fines or go to jail. So, but Mr. Hughes, for me to pursue those matters, notice needs to be given, and it needs to be in the form of either a contempt or a motion to compel or something of that nature. Otherwise, I'm just gonna do a direct admonishment today to keep current with your obligations, if you have any.
This afternoon, or this morning, is people of the state of Michigan versus Stephen Davis. This is file number 24-13803. FH. Appearances, please. You all may be seated, of course.
Joanna and Gary for the people.
Robert Hartzell for Mr. Stephen Johnson, to my left, Your Honor.
Thank you. Also here this morning is Mr. Stephen Saladay. He is the agent from the Michigan Department of Corrections who is serving as the probation officer today on this file. We were last on the record here about a month ago on April 14th. The defendant waived the 14-day rule and was released on bond. Again, we're here today for a probation violation hearing. The arraignment was originally conducted on April 10th. There is a requested warrant for a probation violation in this file that alleges 2 non-technical offenses. What are we doing today, Mr. Hartel?
Your Honor, my client would ask for a contested.
Ms. Carey?
People are ready to proceed.
All right. Who we calling?
Ms. Lindsay Simmons.
Ms. Simmons, come on down. Raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, nothing but the truth?
Do.
You may have a seat. The court will take judicial notice that this is Ms. Lindsay Simmons, an agent from the Michigan Department of Corrections as a probation officer on the file. You may begin. Oh, the court will also take judicial notice of the terms and conditions for probation contained in the file, signed by this court on July 23rd of 2024, and then subsequently acknowledged by the defendant on July 26th of 2024. You may continue.
Thank you. Ms. Simmons. Did you go to the defendant's house on April 9th this year?
Yes,
And what was the purpose of that?
we were conducting compliance checks with law enforcement.
Who went with you?
It was myself, Agent Van Apple, detectives from the Traverse Narcotics team, and 2 troopers.
And was the defendant present when you arrived?
He was.
What happened when you arrived?
We entered the home and began a search. We explained why we were there, what the cause was. Compliance checks to do a search, make sure that everything was what supposed to be going on. And we searched the defendant's room, discovered some miscellaneous marijuana, things like that. There was a gun safe in the room, and we had asked him about the gun safe, who had access to it, and he had a key on a keychain that he had on his person that he provided to us to get into the gun safe.
Whose house was this at?
That was at his house where his mom, I don't remember his mom's name, but him and his mom lived there.
And when you talk about his room, his bedroom,
Yes.
And there was a gun safe in the bedroom.
Yes.
Was the gun safe access? Was it open?
It was not. It was locked. We had asked him about it, and he had a key on a keychain that he had that we gained access to the gun safe.
That was my question. So
Yes,
it
sorry.
was open when you were there.
We opened it, yes.
Correct. Thank you. Was there anything inside of the gun case?
There was personal documents, some identifying documents for both him and his mom. And then we found shells, like ammunition, in the gun safe.
The defendant asked about those shells.
Yes.
Did you make a comment regarding those shells?
I don't recall asking him directly about the shells.
Okay. Do you know, was there a police report prepared regarding this?
I believe from the narcotics team, yes.
And I have shown proposed exhibit 1 to the defense. It's a report from Traverse Narcotics Officer Trooper Aaron Killenbeck, and I would ask that be admitted. It describes the events of April 9th at the defendant's home.
It should so be admitted. Yeah, make sure you speak up. All right, I am now receiving a copy of People's Exhibit number 1. Again, for the record, it is the Michigan State Department of Police Incident Report TNS 16-25. All right, thank you. You may continue.
Do you know what happened with the ammunition that was found in the gun safe?
It was confiscated from the residence.
Thank you, and it was again in his bedroom.
Correct.
Thank you. I don't have any further questions.
Mr. Hold on. I'm sorry, Mr. Hartel.
Thank you, Your Honor. Ma'am, I know a moment ago you said that you don't believe that you directly asked them any questions about the items, but do you recall if any of the other agents asked them any questions that you were aware of, that you overheard, they didn't told you about, since the rules of hearsay don't apply to these hearings?
I don't specifically. No, I apologize.
No, it's okay. If
Yeah.
you don't know, you don't know. I know the court's been given a copy of the police
Yeah.
report. Do you recall if he had any objection to the items being taken? The shotgun shells?
I don't recall that part either.
Well, appreciate your honesty.
Yeah.
Okay, I don't have any further follow-up. Thank you.
Thank you. Ms. Simmons, I don't see on the felony information any habitual felony enhancements. I see here that he was convicted in this file of 2 felonies. Are you aware of any other felonies in his criminal history? Can you review the file?
I probably would, Your Honor. I don't recall.
That's right, hold on. I'll wait to see if we have any other witnesses, but thank you very much. No further questions. Ms. Carey, any further questions from Ms. Simmons? Hold on, let me see, is it mentioned in, I should have asked that. Is it mentioned in the PSI? Or not the PSI, the police report? Disregard. Ms. Simmons, any further questions? Ms. Carey?
Not of this witness, no.
Thank you very much. You may step down, ma'am. Any other witnesses or evidence, Ms. Carey?
No, thank you. I think that the police report covers it all.
Thank you. Mr. Hartel, any witnesses to present?
No, Your Honor, at this point, my client would enact his Fifth Amendment rights. We have no other proofs.
Thank you. Ms. Carey, argument?
Thank you, Your Honor. I believe that we have met the burden by Ms. Simmons' testimony and the entry of the police report that the defendant possessed ammunition located in a gun safe in his bedroom, the house that he's living at, and they were that he had a key to. There are new charges pending. He's set for a preliminary exam next week in district court. Thank you.
Thank you. Mr. Hartel?
Yes, thank you, Your Honor. As the police report does note that the court was given a copy of, when my client was interviewed, according to the report, he denied knowing that there was still any shotgun ammunition in his home. He had previously been a hunter, but obviously while on this type of probation or with these type of convictions that's passed, life changes. As was noted, although he is said to have had a key to the safe, there were items belonging to his mother in there as well. I don't think we've heard any testimony that only he had access to the safe. From what I can tell, both based on what he told law enforcement according to the report and what was stated on the record here today, I don't believe that there's any evidence that he intentionally possessed anything. And again, more than just he most likely had access to that area. I ask the court to factor that in.
Moment. Count 1 on the request and warrant asserts a violation of condition 4.20. That condition reads verbatim as follows, quote, "You must not use any object as a weapon you must not own, use, or have under your control or area of control any type of control a weapon of any type or any imitation of a weapon. You must not be in the company of anyone you know to possess these items. Question that I have is, does a couple or do a couple shells amount to a weapon? I'm going to say that based upon a general definition of a weapon, the answer would be no. Therefore, the defendant is found not guilty of count 1. However, count 2 says violation of rule 1. You're not to violate any criminal law of any unit of government. And while it was not listed specifically in that, I take note that for judicial notice that MCL 750.224F prohibits an individual who has a prior felony conviction is not to possess any ammunition. Therefore, at least for today's purposes, by a preponderance of the evidence, the court finds that the defendant had in his area of control ammunition. The ammunition was in the gun safe. I'm going to assume, since there were not going to assume, I'm going to find that because there were no weapons, those must have been removed, which means he knew or should have known and gone through to make sure all the ammunition was gone. And he had it, he had a key. He opened it. It was in his area of control. Therefore, the defendant, for these purposes, not making any finding on a criminal conviction, because that would have a higher burden of proof that the defendant is guilty of count 2. Now, that means we can either set the matter for sentencing or we can proceed to sentencing. Before I do that, let me hear from a little bit, let's all hear a bit from Mr. Saladay. Does he have, what did he score in his guidelines here for the 2 counts?
For the carrying concealed weapons, guidelines are 5 to 23 months. And for the controlled substance possession of not to 0 to 17.
And hold on, let's take a look. What did I give him? Okay. I gave 4 years of probation. Wow.
4 years, or I had 24 months.
24 months.
I had 48 months.
Hold on. Take a look here, everybody.
The court order says 48 months.
It's 24. When there's 2 counts, the system combines the total.
Oh, okay, so it
That's
is
an error,
24
so-
months. I've been, because I couldn't give you 48 months, so,
I apologize, I just read it out there. So
okay. I was gonna say, I had one. How did I give an illegal sentence? All right. And how many days of credit does he have? Did I look, if I did a warrant, he must have been arrested on this. He must have in another day or 2. Yes,
as
sir.
of today's date, he has 127 days credit.
All right. I think we can do sentencing today. Any objection, Ms. Carey?
No.
Mr. Hartel?
Your Honor, my client has advised that if possible for my office to have time to do a mitigation report with their office social worker or with the court, we trust the court's discretion.
Let's go ahead and do sentencing today. All right, Mr. Saladay, let's go ahead and make your recommendation.
What he was serving for and what his original sentence was, 127 days credit. All of his fines have been paid in full. And he has no other probation violations. So the recommendation for this page would be for 210 days jail, which my math would 48 days to serve.
Gary?
I would ask the court follow the recommendation.
Mr. Hartel?
Your Honor, due to the evidence that was presented today and due to the fact that at least appears he didn't have malicious intent, I'll phrase it that way, I would ask the court to continue his probation He does have obviously the other case pending, and we realize that may result in its own punishments if there is a finding there. But he does have an elderly mother he takes care of. He does have other responsibilities, and I don't doubt he's going to be the world's best janitor moving forward. I'll put it that way. Thank you.
All right, Mr. Davis, do you wish to make any statement?
Other than I've been clean for 15 months and I haven't violated. And I take care of my mother as my sole purpose in life right now, and that's the only thing I have to request. I mean, I have no other anything in life to take care of other than my mother. That's my whole serve, and I had no knowledge of. I mean,
Probably don't want to talk too much about that.
Okay, let's be careful about
Thank you.
what you say, because anything could be used.
I'm just concerned of my mother.
Fines and costs were paid. How, has he had any other violations?
No other violation.
All right. The court hereby continues probation. How many days of credit?
It's 127, right?
Okay, hold on. The court sentences the defendant to 150 days with 127 days of credit. The reason, so basically you don't have any additional time to serve. I'm gonna leave you on probation just to get you through this, to make sure everything's going well. And that there aren't any substance issues here that reignite. Paid off all your fines and costs, that's good. No one found any firearms, that's good. Technically, you should have gone through and done a better job to make sure that all the ammo was out of but again, the fact that there weren't any firearms is my incentive here today. Plus, I know there's the other cases coming. I don't know what's going to happen to it, but at least for the day's purposes, that's the sentence today. All right. And you've been doing well on the probation, haven't had any positive tests. That's really what we're looking for here, sir, is to make sure that you're. All right, so hold on. The court must notify you, because Mr. Hartel is going to grab from the clerk 2 copies of one document. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. If you choose to file an application for leave to appeal, which is the only kind of appeal you may use, you may complete the bottom half of that document, return to court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. All right, anything further, Mr. Hartel?
I don't know if I may approach this, sir.
Yeah, thank you. Anything further, Mr. Saladay?
Okay.
And Ms. Carey?
No, sir.
Thank you very much. We are adjourned. What's that?
Is he gonna need to be booked in asbestos and credit?
No, we are, I don't think so. No,
Okay.
no, because he already has all his credit. Yeah, otherwise he would, yeah, I did the math. He would have gotten 25 days, so yeah, he's good. All right.
There's the amended one, correct declaration.
Our next file is People of the State of Michigan versus Molly White. This is going to be case number 24-13886F.
Court will call the matters of Second Jala Middleton, case numbers 15S00710 and 14S00159.
What's for the people? Allison Muller here. I'm so sorry. Here on behalf of Miss Middleton. Go ahead, Miss Middleton. Sorry to cut you off.
Oh, I was just gonna state my name.
You can go ahead, ma'am.
Sequangela Middleton.
Angela, thank you. All right, in both of these, well, we're here on a pre-trial and a show cause today.
Yes, Your Honor, for the pretrial, which I believe is 2 counts. Ms. Woods, correct me if I'm wrong, but I think we provided proof of insurance. So my understanding is you'd be willing to dismiss that count right now. If the court wants to do it that way, but we would need an adjournment on the driving with a suspended license. She does have an appointment with the Secretary of State on May 22nd to work towards getting her license back. So we can either adjourn both, or if the court and Ms. Wood is willing to dismiss the insurance now, and then we can proceed on the adjourning the license.
Before we go there, what is the appointment with the Secretary of State about? She's still suspended.
Ms. Middleton, what was the purpose of that appointment with the Secretary of State?
To get my license.
Did
The
you just want to
ticket
try?
is paid already. That was holding me for getting my license. The tickets are already been paid.
Well, the 14A2 is still showing that, and we ran this today at 7:47 a.m. The 14A2 ticket. When did you pay it, ma'am?
14A2. What was I
Yeah.
supposed to pay there? I didn't know I had a ticket there.
You have a no proof of insurance ticket that you need to take care of. You're suspended out of 14A2, and you're suspended out of, let's see, let me see here. You're still suspended out of the 22nd District Court for disobeying a stop sign. And it also shows as a suspension, which the 22nd is Inkster. And then it still shows as well, we got actually 4 suspensions still. There's a suspension out of Plymouth, the 35th District Court, for operating while impaired.
That was the only ticket I was aware of that was holding my license being suspended. I didn't know about the 14A. I didn't know anything about those.
Okay. There's also a 35th District Court. Oh, why? I don't understand the order of this. In any event, there's a 35th District Court for operating while intoxicated that she's suspended out of as well.
Yeah, that ticket I paid 2 weeks ago, and it was only $45.
It's still showing on your record this morning. I can't tell you what you did or didn't do, and I'm not disputing it. I'm just telling you that your record still shows these things as holding you and suspending you. So you might want to call them.
Yeah, because I'm sure I know I paid them. Oh my God.
Thank you, Your Honor. And yeah, Ms. Middleton, just definitely reach out to the 14A2, it sounds like, and maybe follow up with the courts the judge just mentioned, and maybe keep that appointment at the Secretary of State in person.
Okay.
To clarify all this.
Okay. 14A. That's the Ypsilanti.
Ypsilanti City, off of Michigan Ave in the city of Ypsi. Across from the chicken place. Well, what used to be the chicken place.
Okay, I think I know what you're talking about. Okay. Damn.
And then there's a number of them. So you're gonna call Inkster, you're gonna call. You said you dealt with Plymouth, but. Yes, ma'am.
Okay. Inkster and 14A District Court. Okay.
All right, apparently there's an A and a B ticket. Well, only one is suspending her though, so.
Okay.
With the no proof of the other. It's the no proof that's suspending her. 376. The no proof of insurance ticket that is suspending you out of 14A2 is $376.
Correct.
$376 is what I'm being told.
I don't remember having a court date for that. Was it already, I've been had a court date for it? Or this was just a longer time ago?
It was a long time ago. It's from 2014.
So is there a way that I can call to get set up a court date, or I would just have to pay?
Ma'am, you have to call them. That's not my court. I can't tell you.
Oh, okay.
There. Okay.
Okay.
All right. So given all of that, Ms. Moeller, what is your request?
Your Honor, we would still request Whatever's the easiest way to do it, either just if we could go ahead and dismiss the no insurance here and just adjourn the driving with the suspended license pretrial, or we can adjourn both and deal with them at the same time, but we did provide that proof of insurance.
Ms. Woods?
Judge, I did receive a copy of that valid insurance policy yesterday, so I'm gonna dismiss that case, whether you want to do it now or do them both at the same time. That's entirely up to you, Judge.
All right, count one is dismissed. The pretrial will be adjourned to. She's obviously gonna need some time here, so I'll bring her back on July 17th. Ma'am, you need to be working on these, okay?
Okay.
July 17th at 9:00 a.m. And you still owe us money. We don't have you suspended, but you still owe money here. You're on a $25 per month payment plan, Mr.
Yes, I talked to my lawyer and he gave me another option to pay it because the one is online it wasn't working. It's not available for that, for the restitution.
Oh, gotcha. Restitution. Is that what that is? Okay.
Yes.
I understand. All right. What the heck is this? Okay. All right. We'll see you back here on the July 17th date at 9 a.m., ma'am.
Okay.
Good luck to you.
Thank you.
Okay.
Thank you.
What else? You need it? State of Michigan versus June 17th, 2025 at 9 a.m. Bond will continue.
Thank you very much, Your Honor.
Thank you. The court will call the case of the state of Michigan versus Reginald Burks, case number 25S00042.
What's for the people?
Good morning again, Your Honor. Dan Guerin on behalf of Mr. Burks. Mr. Burks, can you identify yourself to the judge, please?
Good morning, Your Honor. My name is Reginald Burks.
Thank you. Good morning. We're here for sentencing in this matter today.
We are, Your Honor. Mr. Burks and I have reviewed all the reports and recommendations. We have no corrections or updates. I will say rather briefly, Your Honor, I believe this recommendation is appropriate, as does Mr. Burks. We're asking you to follow it. I believe he can pay his fines and costs up front, and that's all I have to offer at this time.
Judge, I've also had an opportunity to review the PSIR recommendation. I agree that it is an appropriate sentence, and I would ask the court to follow the recommendations put in that report. Thank you.
Thank you. Mr. Burks, is there anything you would like to say, sir, before I impose sentence?
Just basically that, just my feelings about this situation is, is embarrassed and disappointed because I definitely do know better. And, this is definitely more of an exception than a norm in terms of my behavior. And while I can't change what happened, all I can do is make sure it doesn't happen again.
I appreciate everything you just had to say, sir. And I hope that you keep to that statement. Okay.
Thank you.
It is the sentence of the court that you serve 93 days in the Washington County Jail, credit for 1 day served. The balance of that time is suspended. So if you do everything you're supposed to do, then you don't have to do any additional jail time. Okay.
Okay.
You are to complete 5 days for a total of 40 hours of community service. You're on probation for 9 months. You'll be eligible for early discharge once you complete all the terms of your probation. If you do that within 4.5 months, you could be you could be eligible for early discharge. Okay.
Thank you.
All right. Fines and court costs in this particular case. for a total of $11.5. $30 per month probation oversight fee. You must report to the probation officer monthly via the online platform during the second week of each month. So you go online, you'll make a report to the probation agent. You must meet with probation when and where directed, including any and all home visits. You complete an ABR gun safety course and complete the highway safety program within 90 days. You complete the MAD victim impact panel within 45 days. There's no use of possession of firearm components, ammunition, or other dangerous weapons, and will be in the presence of anyone carrying. There's no possession of alcohol, marijuana, illicit drugs, drug paraphernalia, and not being in the presence of anyone using or carrying them. You must drug and alcohol test 2 times per month and any other time that is ordered by the court. You're the drug and alcohol, you're to have a review with me in 90 days. And that review will be on August 14th at 9 o'clock. I'm sorry, at 10 o'clock a.m., okay?
Okay.
Do you have any questions? There were a lot of terms. I know your attorney went over it with you, but probation will go over it with you again also, okay?
Okay.
I'm gonna give you their phone number right now, and I'm gonna give it to everybody else on the call. So everybody should write down the phone number, so that way I only have to hand it out, hopefully 1 or maybe at most 2 times today. Let me know when you're ready, and like I said, everybody should make sure they write down the phone number that is in the call at this time.
I'm ready.
734-483-7336.
Okay, I got it.
Thank you. You have a great day and good luck with your probation, sir.
Thank you once again.
You're welcome, sir.
Have a good day.
Thank you, Mr. Garrett. Have a good day. The court will recall the matters of Clarence Dubose, both cases.
Tiffany Woods for the people.
Matthew Mansour on behalf of Mr. DuBose. Mr. DuBose, can you state your name for the judge one more time, please?
At 9 o'clock a.m. Bond is continued. We'll see you then, okay, ma'am?
Thank you, Your Honor.
Have a good day. State of Michigan versus Ernina Phillips, case number 23 FB 1260.
Tiffany Woods for the people.
Ernina Phillips.
Morning, Your Honor. Assistant Public Defender Davi Leva on behalf of Ms. Phillips.
Thank you. We're here for a review today. It looks like we don't know what's going on with Ms. Phillips since we haven't heard back from the behavioral center regarding her treatment.
Yes, Your Honor, I did speak to Ms. Phillips about that. She told me that her understanding was that a doctor named Dr. Mann at Livingwell had sent the documentation over. I've explained to her that the probation agent has not received those documents. She's going to follow up with them again immediately after court today. And additionally, she's going to be giving probation a call after court today.
May I speak?
Yes, ma'am.
I just spoke with him about 5 minutes ago while we were in court. I called him. He said he sent them twice. He also just emailed me the results, and I was right in the middle of emailing them to Papahagen. So I don't understand why he did not receive them. He said he also faxed them to him. So I don't know why he did not receive those documents, because he sent them out last week, because I made sure I stayed on him to send them to him. But I have the results. I was just looking at them, and I was just in the middle of sending them to him again.
Good morning, Mr. Papenhagen.
Good morning, Your Honor. I received the results this morning. I didn't receive them last week, but I received them this morning, and everything looks good.
All right. I think you still need her to contact the probation department within 24 hours, correct?
That's correct, Your Honor.
And what about the return in 30 days? Is that still your recommendation, or are you willing to give additional time now that you have the record?
I'm willing to push it out to 60 days, Your Honor.
Okay, thank you. Well, thank you for doing what you're supposed to be doing. He says it looks good. Are you, do you feel like the services are working for you, Ms. Phillips?
Yes, I am very, I guess I could say proud of myself for making sure I do everything right and, changing my life around.
I am proud of you too, and I can't wait to see you continue it and continue down this path. Okay.
Absolutely. Absolutely.
I'll see you in 60 days on July 17th at 10 o'clock a.m. Okay.
Okay. Thank you.
Thank you. Have a good day.
You too. Bye-bye.
Bye-bye. What else? You need it? State of Michigan versus Taracum Pruitt Pringle, case number 23 FB 1348.
Tiffany, what's for the people? Allison Muller here on behalf of Mr. Pruitt Pringle. Mr. Pruitt Pringle, can you unmute and go ahead and state your name?
Taracum Pruitt Pringle Senior.
Thank you. We're here for a review today.
Yes, Your Honor. I went over the report
And
together.
I'm sorry. And a
What's up?
violation.
In a violation as well, you said, Your Honor.
Yes.
Let me see. Is that the, I'm sorry, Your Honor, what is the violation?
On March 20th, when we were here, we set it over to today's date, both for the review and for the violation of probation.
Violation of probation.
It's regarding the domestic violence that he didn't report out of Warren.
Oh, correct, Your Honor. Your Honor, I don't know.
I already have a probation violation for that case out of Macomb, literally. I caught that case last year. I'm getting that case. I don't go to trial for that case until June 23rd, though. They pushed it all the way back into June 23rd. It would have been dismissed, but it's just been a long process and BS going through the court, honestly. Like literally, as far as that go for that new case, I caught that case last year, and that's when I got locked up. Literally, I was locked up the whole October. I got transferred from different counties, and I got transferred to York County, and I got released, and then got locked back up in February for a probation violation. It was on tether from Macomb County. I've been on tether from Macomb County since I want to say last week, and then they finally took me off. Literally, they just took me off tether last week. So I honestly been kind of dealing with Macomb County and probation for them and Lansing. I'm kind of like the probation. Yeah, that's about it, honestly. That case, I caught that case last year, and I already got a violation from Macomb out of it. That was my first violation.
I'm sometimes surprised that attorneys allow their clients to keep talking when they're clearly digging a hole for themselves. Sir, I don't really care that you got a violation in Macomb. You're also in violation here if you get convicted of it.
I haven't been convicted. Honestly, I haven't been convicted of it. I'm literally going to trial for it so I can get it dismissed. And I can honestly say the case is going to get dropped.
Schedule this for July 3rd. 2025 at 10 a.m.
I'm, Miss, Your Honor, I'm sorry, I have court that day too. I have court that day for Macomb County. I just got off court with them before I came to court with y'all. They got me on July 3rd too.
At what time?
9:30 in the morning.
Are we open on July 10th, Ms. Heather? I'm sorry?
I said, give me 1 minute and I'm double checking. We are here and we about it.
All right, July 10th at 10 o'clock a.m. I'll adjourn the VOP and the review to that day.
Oh.
State of Michigan versus Shaquille Martin, case number 24 FB 1414.
What's for the people?
Matthew Mansour, Assistant Public Defender, with and on behalf of Mr. Shaquille Martin. Shaquille, can you state your name for the judge, please?
Shaquille Martin.
Thank you. You're all set, ma'am. Bye-bye. The court will call the case of Alan Pelton, case number 15S00004.
What's for the people?
Matthew Mansour, on behalf of Mr. Pelton. Alan, can you state your name for the judge?
Alan Dwayne Pelton.
Thank you. Where is Mr. Pelton? Oh, there he is. Thank you. I see you, sir. All right. We're here today for a review in this case. It looks like Mr. Mansour.
Yes, sir. We're here for a review, and I also believe a review for a discharge hearing as well, if that's accurate.
It is, but apparently its halfway point is not until June 12th.
Oh, June 12th. Okay. Well, Mr. Pelton has been, he's very steady with his payments. He always makes a $60 payment. He's doing all of his conditions. He has either completed or is still doing his conditions. He's doing very well. There's only $525 left on this account, from what I believe. And we are hopeful to get to that mark where he's going to be eligible for discharge. And then we just keep going from there, Your Honor.
Anything from the people?
Nothing from the
All right. Anything from you, sir? Anything from you, Mr. Pelton?
No, I'm just doing my thing. I'm trying to start a Peace Corps and animal rescue stations. I'm trying to make preserves, houses for animals. I'm just taking care of business, doing my thing.
All right, thank you.
Yeah.
All right, I'm going to schedule you for a review before Ms. Johnson on June 12th, 2025 at 9 a.m. At which time, if you are still on track, he may be discharged.
Thank you. Thank you, Your Honor.
Objection to that, Ms. Woods, to an early discharge for Mr. Bolton.
Judge, at this point, this is a child abuse case. I would like the opportunity to contact the other parent just to make sure there is no objection before that discharge happens.
All right. Well, I'm gonna give her permission to do that unless you file an objection, okay? And then she'll schedule it for a hearing in front of me. All right? So you'll have a chance to talk to her before the June 12th date. And if you have any objections, you should file those. All right, thank you, Ms. Woods. All right, you're all set, Mr. Pelton. Good luck. All right.
Good,
Thank you.
What's up?
The court will call the case of the state of Michigan versus Deshaun McFarland, case number 24 FB 1230.
What's for the people?
Good morning, Your Honor. Juan Puza on behalf of the defendant, Deshaun McFarland.
Thank you.
Deshaun McFarland.
Thank you. Good afternoon. Good morning still, I guess, Mr. McFarland. How are you?
Hey, good morning.
All right, July 10th at 10 o'clock a.m. I'll adjourn the VOP and the review to that day.
Oh.
State of Michigan versus Shaquille Martin, case number 24 FB 1414.
What's for the people?
Matthew Mansour, Assistant Public Defender, with and on behalf of Mr. Shaquille Martin. Shaquille, can you state your name for the judge, please?
Shaquille Martin.
Thank
Thank you.
You're here for
Your-
a review.
Yes, Your Honor. Can we approach with probation on this one, please?
All right, we're back on the record in the case of the state of Michigan versus Shaquille Martin. We did have a breakout room with respect to this matter, and the court was a request was made regarding early discharge. The court is unwilling to do that at this time for a number of reasons, including the fact that Mr. Martin here, he is, including the fact that Mr. Martin.
I can't hear you. You said what?
I said I'm unwilling to do a early discharge from probation. Is there anything you want to say today, sir?
You said you are willing or you're unwilling? Okay. Could I ask why?
Sure. Is there anything else you want to say before I give my rationale?
No.
All right. So first of all, sir, you just blew a 0.04 in January of this year on this particular case. And in addition to that, you were just taken off a scram less than 2 months ago, and your testing just started. It's a step-down process. You have a serious disease, and we are going to monitor you until we are more certain that you have this under control. So that is why.
Okay.
So what I will do, though, is allow him to test 1 time per month, as opposed to the 3 times per month, as the step-down process is supposed to work. And I will allow him to have a review. Are you still recommending the 90-day review, Mr. Pappenhagen?
Good morning, Your Honor. Yes, I'm recommending 90 days for myself.
All right. And we'll do a review with Mr. Pappenhagen. And that will be on August 14th, 2025.
Okay. Okay, so I do have one question.
Yes, sir.
Okay, so you guys are drafting it down for once a month. I already tested this month, so does that count or?
That's up to community corrections, sir.
Okay, so just call them after I get off the phone.
You can call them. They may not tell you. The reason we don't tell you what your testing situation is because it's random.
Okay. Okay, thank you.
So that'll be August 14th at 9:00 a.m. with Mr. Pappenhagen. So if you keep doing what you're supposed to do, because you seem to think you have it under control, then you wouldn't be seeing me anymore. You'll only see Mr. Pappenhagen. Okay? All
Okay.
right. Take care of yourself.
All right, you too.
Continue working hard.
I will.
All right. Thank you.
Bye.
State of Michigan versus James Johnson, 24 FB 1350.
Different goods for the people.
Public Defender Davi Lebo, may I have Mr. Johnson? Mr. Johnson, could you state your name, sir?
Doing what you're supposed to do, because you seem to think you have it under control, then you wouldn't be seeing me anymore. You'll only see Mr. Pappenhagen. Okay? All right. Take care of yourself.
All right, you too.
Continue working hard.
I will.
All right. Thank you.
Bye.
State of Michigan versus James Johnson, 24 FB 1350.
Different goods for the people.
Public Defender Davi Lebo, may I have Mr. Johnson? Mr. Johnson, could you state your name, sir?
James Johnson.
Thank you. All right. Back in April, the defendant was supposed to come before me because we were looking to see if he was doing a review. I think he was trying to get into treatment. Is that correct?
No. Remember, I came the last time I seen you that I could recall. I was in front of you. We did a review at the courthouse, and you told me that you was gonna run my probation with
circuit court probation.
Yeah, with my circuit court probation.
And what's
And
going
then,
on with circuit court probation?
my circuit court probation gave me a accountable choices class. I was supposed to take it in the world, but I wasn't able to take it in the world, so they gave it to me in the county jail, and it's going to discharge me, as well as my misdemeanor probation as well. They all came into an agreement of completing accountable choices class and be released and discharged from probation.
So I'm confused because what's holding you in custody, sir?
I have I had a violation for not completing the class and stuff. So my 22nd district had gave me, they sentenced me to a year with the completion of a accountable choice class. And I'll be released and discharged off of probation. My probation agent recommended that I be discharged completely. And the prosecution countered with, they believe that I still need the class, the accountable choice class. And they
So
gave
you
it to
haven't
me.
done any of those classes?
Yes, I'm in accountable choices class as of right now. And my misdemeanor as well. And I think it's 15 district probation. They as well gave me the same recommendation to complete the class and be discharged off of probation.
And then once you complete the class, you can be released from jail? Is that what they said?
Yes, ma'am. And I've been on probation since 2019 in the circuit court. So me and my judge, as well as my probation agent, believe that this should be a new start for me. So they took me off of probation. I still had 3 years left of probation, but my probation agent recommended that I be discharged off of probation. I just did 5.5 months on home confinement. So once I do this, I'm in the class as of right now. So once I do this will be the last of all my court proceedings with anything in Washington County. I live in Southgate, so I won't even be in Washington County at all. I've been out there for the past 5.5 months.
So the sentence from this court was for 365 days in the Washington County Jail. You got credit for 103. The balance was suspended with $275 in fines and costs, and your bond was going to be applied. You needed to continue with your circuit court probation, and I set it for review in April. But in April, they didn't bring you to court. So this is why I'm just now seeing you again.
Oh yeah, I don't know why. I've been in here 50 something days now.
Yeah.
Or something like that.
So, Mr. Lebo, and what is your request today?
Your Honor, I would either be asking for a general discharge, or for an adjournment until Mr. Johnson is released.
Ms. Woods?
Judge, I would leave this up to your discretion how you want to handle this.
Yeah, if I could say one more thing, I just the other courts is aware I just had a child as well. 7 months. He's 7 months old. So that's kind of like all in the works, and kind of the factor what Judge Collin sentenced me to the accountable choices class. So that's what my main focus is just to start a fresh start, get off of probation. Like I said, I've been on probation through Washington County since 2019 or 18 or something like that. And it's been just a continuous of up and downs with the probation departments and multiple classes that, I failed to take. And I'm not placing no blame or trying to take light off any situation, but I need this fresh start. So if anything, I would ask if I could just go with the recommendation as well with the other courts, with all the other courts that's on agreement, and just complete the accountable choice class and be discharged out of probation as well. Like I said, I live in Southgate now. So Washington County is something in my past besides these situations that I got to take care of now, which is this review hearing, the other probation department's already is in the midst of taking that class already. So I just asked if anything, if you could show any type of leniency, if and just discharge me off of probation and or with the completion of this accountable choice class, discharge me off of probation.
I am not discharging you yet. I am indicating that you may complete the in-jail accountable choices program and then you'll purge any need for probation, but I'll do a review on August 14th, 2025 at 10 a.m. to see whether you have completed those classes or not.
All
Okay?
right. Yes, ma'am.
I'll see you then.
So one quick question. So
Yeah. We're not holding.
okay, that's it. All right, thank you.
Change that, okay? But if you don't complete that class, you'll still be on probation to us. So you need to complete it. Okay?
Yes, ma'am.
All right.
Okay,
Thank you.
thank you. You have a good day.
You too.
What's the deal, man? Same old, man.
State of Michigan versus Tamaya Harris, case number 25 FB 1034.
Looks like you.
Okay. Sorry, my Zoom was.
You'll be on probation to us. So you need to complete it. Okay?
Yes, ma'am.
All right.
Okay,
Thank you.
thank you. You have a good day.
You too.
What's the deal, man? Same old, man.
State of Michigan versus Tamaya Harris, case number 25 FB 1034.
Looks like you.
Okay. Sorry, my Zoom was. Takes a moment. I don't know if I'm frozen. Judge, can you hear me?
We can hear you, yes.
Okay, it just looks frozen. Sam Bernstein for Ms. Harris, Your Honor. I see her present. Tamaya, can you please state your name for the court?
Yes, Tamaya Harris.
Thank you. Good morning, Ms. Harris.
Good morning.
We're here for sentencing today. Have you had a chance to review the report with your client?
Reviewed it, Your Honor. I don't have any corrections to make to the report or anything like that. Like a few words to say about the recommendation at the appropriate time.
Thank you. Ms. Woods?
We also had an opportunity to review the PSI recommendation. I agree with the recommendation and amount of probation. So I'd ask the court to follow the recommendation from that report. Thank you.
Thank you. All right, Mr. Bernstein.
Thank you, Your Honor. I see what Ms. Harris wrote. She said, I don't mind being on probation and, whatever the court deems acceptable. I mean, I think there's a little mitigation in the fact pattern of what happened. I do appreciate that she's taking responsibility for interfering with the police. I think she knows it's something that she shouldn't have done. But, I'm reading this police report that, she calls the cops to say that a guy's putting his hands on her, and then the cops show up, and then this guy comes to the door and starts yelling to the point that the cops can't even really talk to her anymore. And then the situation really just devolves into focusing on controlling this guy. And, I mean, she shouldn't have interfered with that from that point. She did. I don't know if it was like a show of loyalty or whatever. I watched the video and the police keep asking her afterwards, like, hey, do you still want to talk about the DV? Do you want to talk about the DV? And she says no, but I think some things kind of got lost in what happened in the case. And I feel sorry for Ms. Harris for that, Your Honor. I'm heartened that nevertheless she did recognize that she shouldn't have interfered with the police no matter what. And that shows a lot of insight on her behalf. I don't know what specifically the class is that's being recommended. It could be helpful. I don't think she would mind taking it. My recommendation, just giving everything and knowing her, would be that she takes the class and close the case out, Your Honor. That would be my request.
All right. Ms. Woods, you may proceed.
But I think that the time frame, the 9 months, is appropriate in this case. Judge, I mean, she called police showed up. They tried to do an investigation. The when they tried to arrest the person who committed the crime, the defendant here, Miss Harris, actively got in the way. She actually was grabbing at the officer, an attempt to pull the officer off of the person that they're trying to detain and take into custody, to help her in this situation. So Judge, I believe she does need classes, and I believe she does need some supervision. And what she did was wrong. You know, she shouldn't have tried to get in the way of the officers doing their job. And that's exactly what she was trying to do, Judge.
Did you read her statement about why she was trying to do that and what her concerns were for her? I mean, people call police, but their loved ones at that point, she was concerned about him. Did you read that part?
Judge, I do understand her concerns, but at the same point, you know, officers have a duty. They were doing what they were supposed to do. And if she wouldn't have got involved, I don't think it would have had gotten to the place that it did.
What do you mean by that?
You know, getting involved with the arrest of Alante Lindsay.
When you said it wouldn't have gotten to the place that it did, what are you referring to? What place?
Where we are today. If she would have,
I don't think she's denying that. That's not what she's saying. She's saying I accept responsibility for doing what I did. They're arguing that she shouldn't have to do 9 months of probation for the situation, which is not the same as saying I'm not guilty and I didn't do anything wrong. She's saying she did something wrong. She acknowledges she shouldn't have gotten into it. The question is, what should the repercussion look like? So the question really for me is whether or not, because she tried to help in a situation where she shouldn't have, she committed a crime, she's accepted responsibility for that, does she need 9 months of probation for how all of this happened? As the victim of a situation, she's calling on someone, she clearly loves that person because she's in a relationship with him. And then he escalates it, clearly he does, by coming behind her back. And I read the whole report because I was concerned about what this looked like. He comes behind her, he starts yelling at the officers. The officers try to get him under control, and he doesn't get under control. Then 4 officers are on top of him after he's just had surgery. So she's concerned about him getting seriously hurt. So her impulse, and I believe she needs the class, I'm not denying that, was to jump in it. It's a situation where now she, as the victim, is charged because of how this went down. So the question is, what should the repercussion be? Not that she didn't do anything wrong, as I understand it.
Yes, Judge, and I agree with what the probation is asking for, Judge, based on the totality of the circumstances.
All right, thank you. Ms. Harris, what would you like to say, ma'am?
I don't have anything to say.
Well, as I just articulated, you clearly were in the wrong. But you're clearly already in a distressful situation. It was just, as Mr. Bernstein said, this devolved into a mess because of who you're dating, and still, I don't even know if you're still in relationship with this individual. So they came there to help you, and then it devolved. So this court's question really is, what should your repercussion look like? And what would have made a difference in you choosing to do something different that day?
There was just a lot going on that day. I mean, I don't mind being on probation and dropping if that's what she recommends, or being on probation for 9 months. I am 11 weeks pregnant, so I don't mind doing none of the classes or dropping or anything like that. I was just in a difficult situation and I was scared at the moment and I called. So
Yeah, I know. All right. It is the sentence of this court, ma'am, that you serve 365 days in the Washington County Jail, credit to serve. All the balance of that time is suspended, so you don't have to do any jail time as long as you do what you're asked to do here in court, okay? I am going to place you on probation, and I'm going to place you on probation for a total of 6 months. So if you get all this done in the first 3 months, then you can be off probation, okay?
okay.
Fines and court costs in this particular case for a total of $325. You must meet with probation when and where directed, including any and all home visits. You must complete the Crossroads Impulse Control Program. You must make legitimate efforts to maintain employment. There's no assaultive or threatening behavior towards anyone. You must submit to and pay and be responsible for any random drug and alcohol tests, but none are being required at this time. There's no use or for possession of alcohol, marijuana, illegal drugs, firearm components, ammunition, or other dangerous weapons. I'm going to do a review in 3 months, so that's 90 days. And at that point, we'll see if you've done all the things you're supposed to do, which really boils down to pay your fines and costs, complete the program, and make sure you don't basically violate these orders by assaulting anybody else. So if you've done those things, then at that time you would be eligible for early discharge. Do you understand that part, ma'am?
Yes.
All right. So do what you got to do, get it done, and then you can be discharged from probation. I will see you back here on August 14th, 2025.
Okay, thank you.
You're welcome.
Thank you, Your Honor.
You're welcome. So we'll call the case of the State of Michigan versus Tommy Butler, case number 24 FB 1358.
What's for people?
Mr. Butler, please unmute and state your name, sir.
Tommy Butler.
Thank you. So, Mr. Butler, you're here for a review today. So we'll call the case of the State of Michigan versus Tommy Butler, case number 24 FB 1358.
What's for people?
Mr. Butler, please unmute and state your name, sir.
Tommy Butler.
Thank you. So, Mr. Butler, you're here for a review today.
Yes.
And it appears that you left the state without seeking permission from the court. Is that correct?
No, ma'am. I'm a truck driver. I've been a truck driver for 2 years. And when I got arrested on this particular crime, I had what was his name? Cedric Simpson. Cedric Simpson. And I asked him, like, can I continue to work? And he said, yes, you got permission to go to the state of Ohio. And my load, that's where it goes, from Ohio to Flint. And that's what I've been doing since I've been out on bond. I've been working. I was completing that class, but there was a misunderstanding with this. Like, I'd never been on this before, this community correction thing. There was a misunderstanding. They told me that it either go by letters, numbers, or colors. And they told me I go by a letter. And they told me my letter is T. So as I'm in this class, I work 12 to 14 hours a day, 6 days a week. Like, I just got off work right now. So while I'm waiting on them to call T, I call every day. While I'm waiting on them to call T, they call T once a month. I'm under the impression that I only go by the letter T, but I got 3 letters. I did not know that. So while I was in the class, I did the class, even though I was doing 12-hour shifts. So while I'm doing the class, one day I was attending class and she basically said she's kicking me out the class. And I said, can I ask why? And she was like, you got to call your probation officer. So I called my probation officer. My probation officer said that I missed a couple drops. So I'm like, I couldn't have missed a couple drops. I told him that my letter is T.
Sir, I need you to stop talking. This is the way this is going to work. We're going to need to have him appointed an attorney. So I think we're going to have to adjourn this. Do you plan to rehire, or was Mr. Drukas appointed, or did you retain him?
He was appointed, ma'am.
Okay. I'm going to arraign you on the violation. A violation has been filed. It indicates that you missed testing on March 17th, March 19th, March 24th, and April 2nd, and that you were discharged from MRT for non-compliance on April the 2nd. I'm gonna do a referral to the appointing authority. As far, Mr. Pappenhagen, as far as the leaving the state of Michigan without permission is concerned, back in November, Judge Simpson did grant him authority to leave the state. And I believe he didn't understand that once he was sentenced by me, there should have been another request for that at that time. That changed. You are no longer on bond, you're under sentence, sir. So things change. And you have to make sure that your probation includes the term that you can leave the state. So I'm going to refer you to the appointing authority so that they can appoint an attorney for you regarding the testing. Because I clearly said that you were to test 3 times per month when you were here on February 6th.
Ma'am, and they told me my letter was T.
Okay, you can talk to your attorney about all of that.
Ma'am, can I say one thing?
You probably should not. June 12th, 2025, and that's going to be at 10:00 a.m. Someone from the public defender's office or some attorney will reach out to you so that they can go over your violations with you and go over your options with you and talk to you about your explanations for why you did not do what you were ordered to do. And then we'll see you both back here on June 12th at 10:00 a.m. Mr. Butler, okay? Did you hear me, sir?
Yes, I hear you, ma'am. I'm sorry. I hear you. I'm just trying to do the right thing, man.
Your bond is granted. Until then. We'll see you back here then, so.
Okay.
The court will call the case of the state of Michigan versus Christian Thrasher, case number 13S00637.
Three people.
Allison Muller here on behalf of Mr. Thrasher. Mr. Thrasher, could you please state your name?
Christian Thrasher.
Which one's the private attorney?
Stimson?
Stimson? Attorney David Stimson.
Yes, Your Honor.
The recorder has been trying to chat with you in the chat to find out what you're on.
I apologize, Your Honor. I'm on Miss Catherine Jensen.
Thank you. The court will call the case of the state of Michigan versus DeQuevion Wells, case number 23 FB 1141.
Tiffany works for the people.
Assistant Public Defender Daffy Lieb on behalf of Mr. Wells. Mr. Wells, do you see your name, sir?
DeQuavion Wells.
Thank you. So in this particular case, Mr. Wells is here for a review. Last time we were here, I held a violation of probation in abeyance to see if Mr. Wells would get himself together. But it appears that we're still in the same place we were last time. He's progressing slowly, only on step 2, and has had 3 absences and is at risk for being discharged. So I'm kind of tired. If he gets discharged, I'm just going to do the jail time.
I do want to provide some information that Mr. Wells has given me regarding why he's struggling. What he's explained to me is the classes are in the morning on Tuesdays and Thursdays, and they have a very strict absence policy. He tells me that they haven't considered any of his absences excused, although one absence has been for court, another one was for taking his child to the doctor, and he further tells me that appearing in court today is causing him to miss an MRT program. He really has made it clear to me, I think sincerely, that he wants to be able to complete the MRT program, but he's having difficulties with the scheduling of the classes, as well as what, from his description, sounds to me like a very tight absence policy.
Ms. Johnson? Good morning.
Good morning, Your Honor.
Is it true that they won't excuse his absences when he has court?
If he does have court, they will excuse his absence. I can let them know that he was in court for those.
Okay.
He just needs to notify me so that we can let them know that he had court for those absences.
And he's had 3 at the time that you wrote this report, so this would be the 4th one. And so one of those seems to be an unexcused absence, and then the other, you're saying that he had a child that was sick?
Mr. Wells indicated to me that he had missed that class because he had to take his child to the doctor. He also tells me that he can provide documentation.
He should do that.
Mr. Wells, do you have my email address?
No, I don't, but can I say something? I'll be communicating with my facilitator and Miss Johnson whenever I miss a class, Miss Washington. And none of my absences got excused. Like, none of them. And I do have the documentation for the doctor and stuff. Can I get your email, Mr. Lebo, please?
Sent it to you in the chat, sir.
Thank you.
And then my next question is, why are you progressing so slowly, sir? Why aren't you moving along in the program?
Miss Washington, it's not about me progressing slow. I'm not the only person in the class. So like if I do miss a class, it'll offset the scheduling of the facilitator because people, they also have to work out of their MRT book and stuff. So it's like I can't explain it. Just cause I wasn't there a day means like the program stopped or anything, you know?
What I think is happening.
Go ahead, Mr. William.
You know, what I think is happening from Mr. Wells has said to me is that when he has an absence from MRT, he on a day that he has a presentation, he gets pushed back to the back of the line, so to speak, which causes him to be held back on a step. Is that what's happening, Mr. Wells?
Basically, yeah.
Mr. Wells should not miss any more classes.
I made that very clear to him, Your Honor.
All right, I'm gonna see him back here in 90 days. Ms. Johnson is going to talk to them about your past absences, if they involve court or you have a letter regarding your daughter. It can't just be she had an appointment that she needed to have an emergency situation. You know, when your classes are, someone else should have the responsibility of taking them. You need to finish these classes, sir. I've given you multiple opportunities and this is the last one. August 14th, 2025 at 10 o'clock a.m. We'll see you back here.
All right, y'all have a blessed day.
You too, Mr. Wells. The court will call the case of the state of Michigan versus Catherine Jensen, 25S00005.
Good night. David Stimson on behalf of the defendant with Ms. Jensen today, Your Honor.
Thank you. Today, have you had a chance? Ms. Jensen, I'm sorry. Please state your name for me.
Catherine
For the
Jensen.
record, thank you.
Have you had a chance to review the pre-sentence investigation report with your client?
We have, Your Honor, we have two corrections to the pre-sentence investigation report, more clarifications than corrections. The first being of which the probation officer indicates that she says she does not drink alcohol, and I think there's a miscommunication in this particular aspect. This event took place back in Labor Day of 2024. What Ms. Jensen's indicated to her PO is that she has not drank alcohol since last fall. She no longer drinks alcohol. She is also currently pregnant, so she, again, doesn't drink alcohol or take any drugs. And not only that, her husband quit drinking alcohol back in the fall. That's the one correction. I think there was more of a miscommunication. I don't think she was denying that she drank alcohol at the time of the incident or that she was a regular drinker at the time of the incident. I think she was referring to more her current status. The second is that there is a issue kind of talking about the eye level of the children of a shotgun. This is not entirely accurate. The shotgun was on top of a shelf, which is built into a wall. It is inappropriate and has been since secured in a locked gun safe. However, the description suggests that it's maybe 3 to 4 feet off the floor in height, when it's more like 6 to 7 feet off the floor in height. Just simply because it matters a little bit, and the recommendation is that this gun was well out of reach of any young children, however, still inappropriately secured by placing it up on top of a built-in shelf rather than in a gun safe. Those are the only two corrections that we would have. She takes full responsibility otherwise for the actions that occurred that night and is willing to proceed with the recommendation.
Thank you. Ms. Woods?
Judge, all I can say is the police report says that the shelf that the gun was on was at eye level and any 3 of the children could have climbed to it. So, it looks like the kids would have been able to access it, which was the concern, and it was fully loaded. Judge, I've read the PSIR and I would ask the court to follow the recommendations within that report.
Thank you. Anything else you want to say on behalf of your client, Mr. Stimson?
Yes, Your Honor. And again, most of this comes back to that gun aspect. Miss Jensen's husband is a retired military. He was in the infantry, served for a couple different tours. He has several firearms in the house that are now locked in a safe and secured. One of the provisions associated with this is no possession or use of any firearms. She obviously doesn't have any problem not possessing them personally, but to remove them, which would be kind of the implication from the home, would be very difficult, if not impossible, for them to do that. So as long as they're secured in a gun safe, we would ask that the court allow that to be the case. And that's really the only other request we have. The rest of it, she believes is appropriate. She's just happy that nobody was injured. She clearly made some poor decisions that night by getting intoxicated to the level that she was, and is willing to move forward. The other aspect that's not included in the recommendation is simply not mentioned, is this is a deferred request that was part of the plea agreement. So that's the only other aspect.
With respect to the gun, it is a standard condition regarding weapons in the house. I think we need to have a breakout room so we can talk about this. I'm sorry? Yes, with probation. All right, we're back on the record in the case of the state of Michigan versus Catherine Jensen, case number 25S00005. We have had a breakout room with respect to this particular matter, and Mr. Stimson, I believe you made an adequate record as to what your request was regarding the weapons. I believe that Ms. Woods wants to make an additional argument regarding why the court should not consider it. You may make your additional argument on the record at this time, Ms. Woods.
Yes, Judge. There was a weapon in this home when the defendant was passed out on the couch, drunk, and unable to be woken up. They finally were able to wake her. She had children in the home, young children that could have easily accessed the weapon if they were able to climb up onto that eye level counter and get it. Which is why there's a gun safety course that's being requested from the probation department. I'm asking that no weapons be allowed in the home. I am aware that the husband has multiple weapons that supposedly are kept in a gun safe, but that wasn't the case in this scenario, Judge, that the weapon was kept in a gun safe. It was kept open and loaded. So she's an adult, she would have access to that gun safe, and there's no guarantee that those guns would be locked up in that gun safe. So I would object to not having that provision in sentencing. Thank you, Judge.
Thank you. Anything else you want to say, Mr. Stimson, or may I go on to your client?
And nothing further here.
Thank you. Ms. Jensen, is there anything you would like to say today, ma'am?
Yes, Your Honor.
You may.
I have never been in trouble with the law. I come from a family who hasn't. This night was a night of mistakes. I've learned my lesson. They'll never happen again, and I'm just glad my kids are okay.
Thank you, ma'am. I'm glad your kids are okay too. I am concerned about your kids, and I understand you haven't had any issues with the law before, but this situation is very, very concerning. I understand Ms. Wood's concerns. The issue is whether or not the court can fashion a sentence that takes those concerns into consideration while trying to ensure that people who are not committing the charge are least affected by the situation that you've created for you and your family. And so that's why I met with your attorney to try to figure out, and Ms. Woods in probation, to try to figure out what's the best way to try to fashion something under these circumstances. And so that's what I believe I've come up with. And I am hopeful that you will follow all of the court's orders and that you can have this matter removed from your record if you complete the probationary terms that you've been ordered to do.
Yes, Your Honor.
So in this particular case, ma'am, it is the sentence of the court that you serve 365 days in the Washington County Jail. There is no credit because you didn't do any jail time, and all of those days are suspended as long as you do what you're supposed to do. You will be on probation for a total of 18 months. Fines and court costs in this particular case for a total of $625. You are going to have $30 per month probation oversight fee. You're to report to the probation officer monthly via the online reporting platform and report during the second week of each month. You're to complete the Dawn Farm outpatient program within 30 days of the sentence and sign a release of information so that your probation officer can see that. You're to complete the ABR gun safety program within 90 days. I believe that is necessary given the fact that there was a gun that was accessible. They may be your husband's guns, but they are also your responsibility for protection of your children as well. You're to complete the EARN e-learning parenting course within 90 days. There's no use or possession of alcohol, marijuana, illegal drugs, drug paraphernalia, and no being in the possession of the presence of anyone possessing those items. So that will apply to you and your husband. So there shouldn't be alcohol in the home. If he's looking out for you, he will not do that because you clearly have some issues going on. We want to make sure that you are on the correct path. In terms of the firearms, there's a constitutional right for people to have those, not you, because you've committed an offense. And until you've completed your probation, you're not entitled to use them. That doesn't apply to your husband. And given his military background, the court will make an exception under these particular criteria. One, all weapons are to be secured and locked in a safe. You and your husband will subject yourself to random home visits at any point in time by the probation department to determine whether they are locked in a safe. In addition to that, the court will have a list of any and all weapons that are in the house. Any weapons that are found in the house that are not on that list would be a violation of probation for you. Do you understand that part?
I understand.
And in addition to that, there must be proof that those weapons do not belong to you and they in fact belong to your husband. So we will need to have proof of that. Any weapons not on that particular list or any weapons that belong to you need to be removed. Okay?
Yes, Your Honor.
You must drug and alcohol test 3 times per month, and any other times is ordered by the court, probation, or any provider. You must attend 15 12-step meetings. This is under the prosecutor's defer. And you are to have a review in this case in 90 days on August 14th, 2025, and that will be at 10 o'clock a.m. Do you have any questions about your sentence, ma'am?
No, Your Honor.
All right. You're going to contact the probation department. They're going to provide you with a contract that you need to sign regarding your probation and go over any of these particular rules with you, okay?
Okay.
And I'll see you back here on August 14th at 10 o'clock a.m. Thank you.
Okay, thank you. Have a good day.
Do you have the probation phone number?
Yes, ma'am.
All right. Please call them tomorrow after 9.
Okay.
Thank you.
Thank you.
You're all set, ma'am. Bye-bye. The court will call the case of Alan Pelton, case number 15S00004.
Yes, for the people.
Matthew Mansour on behalf of Mr. Pelton. Alan, can you state your name for the judge?
Alan Dwayne Pelton.
Thank you. Where is Mr. Pelton? Oh, there he is. Thank you. I see you, sir. All right. All right, the 14B District Court is now back in session. The court will call the case of the State of Michigan versus Rudy Smith, case number 25-00007.
It's for the people.
Allison Muller here on behalf of Rudy Smith. Mr. Smith, can you, once you're unmuted there on the kiosk, can you go ahead and state your name?
Rudy Esau Casserole Smith.
Thank you. Good morning, Mr. Smith.
Good morning.
We're here for sentencing today. Have you had a chance to review the report with your client?
Yes, Your Honor, we have, and we have no corrections, modifications, or deletions to the report. We appreciate the recommendation from probation and do ask the court to follow it. Mr. Smith takes full accountability for what happened here. He is, I think, going to be a great candidate. I know he'll have no problem on probation. He's been very straightforward to work with, really a really great client to work with. And he's working full-time at U of M as a janitor. He's also in treatment and following up with his therapist. So he's very busy, but he will get these requirements done and have no issue with that. He appreciates the recommendation from probation.
Thank you, Ms. Woods.
Judge, I've also had an opportunity to review the PSIR, and I'd asked the court to follow the recommendations within that report. But I also got a community corrections report, and it says he tested positive for alcohol on February 4th. I don't know if we ever discussed that or not. He had multiple tests that were negative with abnormal creatinine. I don't know why I just got that report yesterday, Judge. I don't know. I'm looking through my notes right now. I don't see that we've addressed that.
No, I don't think we've gotten a report before the May 13th report.
I can email it right now, Judge.
I know I have it. I'm just saying I don't think I had gotten one prior to that.
Right. I just wanted to let the court know I received that report. And then I just asked the court to follow the recommendations within the PSIR.
So the report is labeled as a progress report. It does indicate that on 2/12 he tested positive for alcohol. He apparently told them that he had been taking NyQuil, which doesn't test positive for alcohol like that, not at that level. I'm going to give you a warning about that, sir. Okay?
Yes, ma'am.
Is there anything you want to say today?
I'm sorry what I did. Very sorry what I did. Messed up.
Yeah.
I did. And I'm really in treatment, doing the best I can. I love my therapist and I'm doing the best I can to change. I'm gonna do good at this.
Sir, I hope that's true. And if you're having difficulties, you should increase your level of care.
I'm way too old to be catching cases. My record's pretty good. Just misdemeanor driving with suspended license, but I'm too old to be catching cases like that, you know? So I'm embarrassed.
Yeah. Well, I hope that you don't have a drinking problem that you're
don't.
Okay. Yes, anything else, sir, before I impose sentence?
No.
All right. I'm going to follow the recommendation of the probation department. It's the sentence of this court that should serve 93 days in the Washington County Jail, credit for 1 day served. The balance of that time is suspended. What that means is if you do everything you're supposed to do, then you don't have to do any additional jail time. Okay. You must complete a total of 5 days of community service.
5 days?
Yes.
How many hours is that?
40. And you're on probation for 12 months. You'll be eligible for early discharge after you complete half of that if you completed all the terms of your probation. Fines and costs in this particular case for a total of $825, $30 per month probation oversight fee. You to report to the probation officer monthly via the online reporting platform and during the second week of each month. You either continue with outpatient treatment with deep water counseling and sign a release of information. You must sign that release of information so that we can see what's going on, okay, sir?
Yes, ma'am.
You must complete the MAD victim impact panel within 45 days. There's no use or possession of alcohol, marijuana, illegal drugs, paraphernalia, firearm components, ammunition, or other dangerous weapons, and no being in the presence of anyone using those. You must drug and alcohol test 3 times per month, and any other times as ordered by the court, probation, police agency. You attend 3 times per month 12-step meetings and provide proof of those 3 times per month to the probation department. You'd have a review in 90 days with me, and that's going to be on August 14th. 2025 at 10 o'clock a.m. You need to call the probation department tomorrow after 9 o'clock a.m. Do you have their phone number, sir? You do have it? Not community corrections, but probation. Those are two.
My lawyer gave it to me.
Okay, good. Call them tomorrow after 9 o'clock. So sir, you are not to have any additional positive ETG tests. You can't take NyQuil or any of that stuff if it may ring up as positive. In addition to that, I'm not certain what's going on with your abnormal creatinine levels, but you need to have your creatinine levels come back within normal range. Usually that means that people are drinking water in excess so that they don't test positive. I want to not see that anymore.
What you mean?
I don't know how else to say that people are drinking water so that they not test positive for whatever it is that we're testing for. So you need to talk to your attorney and you need to get those creatinine levels within normal range. I'll put you in a breakout room with her.
Thank you.
Can I get your cell phone number again? Because somebody stole my phone.
I'm sorry, what, sir?
My lawyer.
Okay, we're gonna put you in a breakout room. You're not there yet.
Oh, I'm sorry.
That's okay.
Sorry.
That's okay. All right. All right, the court will call the case of the state of Michigan versus Donald Taylor, 24 FB 1250.
System plug defender Davia Lebo for Mr. Taylor. Mr. Taylor, can you state your name, sir? Mr. Taylor, could you just tap the unmute button?
Mr. Lee, your device is making that squealing noise again. So therefore, I'm going to set this for a contempt hearing. And I will set it for July 3rd, 2025 at 10. Mr. Smith, I think we're done. Was there a need to recall his case?
No, there wasn't, Your Honor. Thank you.
So you can go. Make sure you call probation tomorrow, okay, Mr. Smith? All right, thank you. Take care. The court will call the matter of the state of Michigan versus Muhammad Shohati, case number 24S4361480.
System plug defender Davia Lebo for Mr. Shahati. Your Honor, the phone number I had for Mr. Shahati is disconnected.
Mr. Shahati is valid, though.
They stole my phone.
I'm sorry, what, sir?
My lawyer.
Okay, we're gonna put you in a breakout room. You're not there yet.
Oh, I'm sorry.
That's okay.
Sorry.
That's okay. All right. All right, the court will call the case of the state of Michigan versus Donald Taylor, 24 FB 1250.
System plug defender Davia Lebo for Mr. Taylor. Mr. Taylor, can you state your name, sir? Mr. Taylor, could you just tap the unmute button?
Mr. Lee, your device is making that squealing noise again.
Is this improved, Your Honor?
Yes, it is.
Okay, it seems like I have to toggle the noise canceling on and off. Mr. Taylor, can you state your name, sir?
He needs to unmute his device by hitting the microphone button to unmute it. All right.
Can you hear it?
Mute
Can
it.
you hear him?
Yes, he can say his name now.
Okay. Yes, I'm Donald Powell Taylor, ma'am.
All right. Mr. Taylor is supposed to be here for sentencing today, but he did not show up to have his PSI done. Is that correct?
Yes, Your Honor. So I did have a pretty lengthy discussion with Mr. Taylor about this. What he's told me is that a couple weeks ago he was in Harbor Light. He just got it last week. Additionally, he's been attending Narcotics Anonymous several times a week. On his way back from one of those meetings, his phone was stolen, and his phone was stolen from his car. He has connected with his brother now. He's using his brother's phone, and he's able to do that to make contact with probation. He's also indicated to me that he has some health issues that are complicating things for him.
Well, the other thing is I'm going to arraign him on a violation of his bond conditions because he's supposed to be testing and he's not. Well, actually, let me see something here.
Tested positive for cocaine on April 18th, Judge.
Yes, that's what I'm part of what I'm going to arraign him on. So, sir, you're in violation of your bond conditions on April 18th, 2025. On April 18th, 2025, you tested positive for cocaine, which is a violation of your bond conditions. And I'm not asking you to say anything. In addition to that, April 25th, May 1st, and May 5th, you failed to test at all. You must understand that this is a violation of your bond conditions. If it is found that you in fact tested positive and failed to test, you could have your bond revoked. Mr. Lebo, have you had a chance to speak with your client regarding this?
Yeah, Your Honor. Mr. Taylor will admit to the violations.
All right. Mr. Taylor, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. Is it true that you tested positive for cocaine on April 18th and test on all those dates that I indicated?
Yes, but I like to say this. When I was in treatment, I was there and it tested for like 17 days. It take a longer time and they can verify that. And it didn't, I'm not making excuses. They can verify that because they drop you in the program. And I didn't have no visitors of any sort at all because it's in the building. We didn't have no visitors. I didn't have any visitors. So I just wanted you to know that. And I got paperwork, but I can't get to it until my peoples get off work at 4:30 today. And I can show you the paperwork that from their doctor too.
Your Honor, Mr. Taylor's brother is going to be emailing me the documentation that he was attending treatment. He had attended treatment after the positive test and was released last week.
Thank you. I find that there's no one willing admission to probation. Are you satisfied, Ms. Woods?
Yes.
Defense is likewise satisfied, Your Honor. Thank you.
All right, so Ms. Woods, do you have thoughts on where we should go from here?
So he has not done his PSIR, is that correct, Judge?
That's correct.
I would, and then a violation for cocaine. I don't know if you want to give him a time to do that IR, or he has to go to hospital, get it done. I don't know if you want to give him some sort of time for to get that completed.
Mr. Lubo, anything from you?
Your Honor, I would suggest that Mr. Taylor test after court today. He tells me he'll test negative, and that he's given some time to complete his PSIR now that he does have access to a phone.
Defendant is to test within 24 hours, ETG test as well as drug test. I'm going to schedule you back here for sentencing on June 12th, 2025. at 10 a.m. Plus, get the PSI at the schedule an assessment. Sir, if you don't, and you're going to continue testing at the 3 times per month level. If you miss another test, then I'm going to revoke your bond. You need to get those proofs over to Mr. Lebo regarding you being in treatment, okay?
Yes, ma'am.
All right. I'll see
And
you
Mr.
back.
I was also having problems. I had some issues when I'm doing what you tell me to do, ma'am.
Okay, thank you, sir.
And Mr.
Yes.
Powell, if you have any questions about what you need to do or you need help, please give me a call, okay?
His name
Yes,
is Taylor.
sir. That's my middle name, Powell, but my last name is Taylor.
Get your lawyer then.
Yeah.
My apologies, sir.
And I need your number, please.
It's in the email I sent to your brother, sir.
Okay. Thank you.
Of course.
Right. Thank you. You're all set, sir. Remember, you got to test
Thank you,
with
ma'am.
okay?
Yes.
The date that I gave him was June. Yeah. All right, we're all set. Call probation tomorrow after 9 a.m. because they gotta get for your assessment.
Well, you say you want me to go to probation tomorrow?
You need to call them tomorrow at 9 so you can get your assessment set up as soon as possible.
Yes, ma'am. I have to use my brother's phone. I would do that now.
You have their phone number?
Take the drug test. Where do he gotta go to take the drug test?
Community corrections.
Okay.
All right. Do you need to talk to your attorney about what it is? Well, he knows where it is. He knows where the test is in there.
Yes.
All right.
I know where that's at. That's by the jailhouse.
Yes, it is.
Yes, ma'am.
Thank you,
And I've
sir.
sent Mr. Taylor the number for probation.
All right, thank you. All right, you're all set, sir. Have a good day.
You too, ma'am.
Quote call the case of the state of Michigan versus Orville Howard 21S393009B.
Tiffany Woods for the people.
I'm pretty sure this was Ms. Miller's case.
I'm sorry, Your Honor. Allison Mueller here on behalf of Orville Howard. Mr. What are we calling?
Present. These are a failure to appears.
Sorry, Your Honor. Let's see. Mr. Howard owes, I believe, 200.
Every day in the USA, people find themselves in court.
All right, let's talk about your case. This is file 25689SN. Are you Daniel Lee Fry?
Yes, sir.
Mr. Fry, you're charged with the crime of the day, driving without insurance, driving with a suspended license, and improper plates. Those things often go together. You got $909 worth of previous unpaid tickets. going back to 2021, allowing another to violate the motor vehicle code. Boy, you didn't pay any on that. Speeding, no proof of insurance, didn't pay that. No registration plate and another registration plate. So you got $909 worth of fines. You did say you wanted to come in today and pay some.
Yeah,
As
I
a
was
general
up there.
rule, I said people don't go to jail for this, but for you, I could make an exception.
Oh, please
You
don't.
got a number of previous convictions for the same thing, and you don't pay your fines. So best bet may be to get a lawyer to help you with this. Do you have insurance now?
Yes, sir.
All right. Let's take a look and see why you're suspended. Probably because you got a bunch of unpaid tickets.
Been a long suspension.
Well, I call it getting on the driving suspended merry-go-round. Once you get on it, it's hard to get off it. You're actually revoked. And you and I go back a ways, but you've got a lot of old baggage on your license. You must have, gosh. You and I go back a long ways.
Yeah.
I was still prosecutor in the 80s. Anyway, you got some old drinking driving convictions, and then you got a bunch of driving suspended tickets. And you're not supposed to drive. In 2021, they cut you a break and reduced it to allowing another to violate the motor vehicle code, and you never paid the fine.
Right.
Then you kept on driving and kept on driving with no insurance. So you do have insurance now?
Yes, sir. I actually done a lot of work on my license when I was in prison and got them back. And when I got out, they were expired. I went to renew them. They said I had a ticket to pay here. And I come and paid the ticket, and then they revoked them.
All right. I think you could use a lawyer to help you.
Yeah.
Are you still living on Clay Street?
No, sir. I live in Mottville now.
All right. That's officially out in the boondocks.
But there was nothing there. The town just killed me.
Well, maybe now the problem is when you live way out in the country like that, you need to drive. You can't drive. I don't know why you got revoked. When did you get out of prison?
It's 2016.
Well,
And I went to renew my license. And they said I had 2 tickets to pay here that I got in 2012.
well, there was a 2009. All right. I think you could use some legal help.
Okay.
I'm going to appoint an attorney, set an attorney pre-trial for the June date.
Do you want to see the proof of insurance?
I'll ask you to,
Today?
the clerks to make a copy of it.
Okay.
Please note new address. And copy his proof of insurance. How about registration?
I haven't got that yet. It's $120 and money's really hard to come by.
Well, it is. And the problem is you can't get registration or insurance if you don't have a valid license. So we're going to find out about why you're revoked, and you need to stop driving. How'd you get here?
My daughter-in-law brought me.
Very good. Don't make things worse.
Right.
Oh,
The only reason I was driving that day is my brother-in-law passed away.
all right. Well,
I had to go to work.
all right. That happens a lot. People, their ride doesn't show up. They got to go to work or they lose their job. The person they thought they had a ride left without them.
Right.
Or sometimes they're just plain old driving, but we'll get you a lawyer to help you with this.
Okay.
All right. Okay. I'll see you in June. They'll give you the date out there at the counter. I'm not sure what the date is. I think it's June 13th. While we're doing this, Mr. Gabriel is also doing some pre-trials. I have one of those now. Victoria Palau. Did I say that right?
Yeah.
You got a ticket for no proof of insurance and driving with a suspended license. Or driving without a license. You got one of these in 2004. Did pay the ticket. Let's take a look at your ticket here. Driving suspended second is what's on the ticket. And no proof of insurance. You're not licensed. I had one in 2024. Driving suspended. Indiana, 2020. Driving suspended, Indiana, 2012. Some old Indiana drinking, driving stuff, which caused you to be suspended. Okay, you did get one of these last year and you paid it. Well, let's talk about this. Driving suspended second is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Carries 2 points on your license. It requires that your license be further suspended. Having no proof of insurance is a civil infraction, punishable by a fine of up to $150. Mr. Stickley, what's your thought here?
Might be a bit tough at this point with the situation. Get a license in a couple of weeks, but it's up to the gentleman.
He's not going to be able to get a license without lots of work.
It's not something I would normally suggest we appoint an attorney on. I don't think there's anything, unless the court's going to indicate that it's something jailable.
It could be. His life driving record's terrible.
If there's a liberty risk at stake, I don't have a problem with appointing an attorney on.
All right. Same question. I'm always interested to know where you were going and what you're doing. But right now you have a right not to say anything, and I encourage people to not say anything. How'd you get here?
Fiance drove me here.
All right, don't let him drive anymore, or he's gonna end up sitting in a cell in Centerville.
And I told the lady that asked me for a ride, I told her, I said, I can't drive, and she was having a panic.
All right, don't say any more about it. The car didn't have any insurance. Do you have insurance? Is that car?
Yeah, I got proof.
So appoint an attorney. Set May 30th is too soon. Well, May 30th is not too soon. Are you missing work right now?
I'm retired. I had a stroke.
Okay, well, even more reason why you should probably stop driving. 8:30, take proof of his insurance. All right, I'm gonna have the court officer take you out. We'll get a lawyer to help you. We'll take a copy of your proof of insurance, and your fiance is not gonna let you drive anymore.
No, she drives.
Very good. All right, we'll see what we can sort out here. All right, I'm gonna take one more, and then we're gonna take a break, and Mr. Stickley's gonna try to catch up with the prosecutor. Antonio Wilson. Tobias Nolan. Good morning, sir.
Good morning.
Tobias J. Nolan.
Yes.
Welcome to No Insurance Day, Mr. Nolan. File number 25693. You're charged with no insurance and driving with a suspended license and failing to obtain a Michigan license plate. Let's take a look at your circumstance. You have $234 worth of unpaid tickets. I think the plate violation is in here. You have no proof of insurance from 2021 that you never paid, which is a previous conviction for the same thing. But you've got a reduction and you didn't pay the fine. That hurts my feelings.
I thought I had everything taken care of.
Yeah, they're all you, Tobias James Nolan. Let's see what we got here. You used to live in Indiana. You live in Michigan now?
Yes.
You got charged with driving without a license in January of 21. And then attached to that was a no insurance. And you pled to no proof of insurance. Got a fine of $150 and then never paid it. All right. What's your circumstance now? Do you have insurance on this vehicle now?
It is all legal. It's in my son's name because we was getting it ready for him.
All right, let's take a look at why you're suspended. Oh, you're now valid. Wait a minute.
No, I got to
That's
carry.
the last dude.
I have to carry a SR22 from Indiana and get my license back for 6 months.
SR-22 sounds like a secret fighter jet. There it is. You're suspended. This unpaid traffic ticket is in there. Drove without a license. The 21 stuff is there. Drive suspended 2018. Drive suspended 2017. Drive suspended 2017. Drive suspended 2017. Drive without a license 2015. Oh boy. You got about 8 prior driving suspendeds and no prior insurance, and you didn't pay it. As I told the other guy, I don't usually go to jail for this, but for you, I could make an exception. I think you could use an attorney to help you with this. You're not supposed to be driving. You're super suspended. You got multiple prior suspensions. You didn't pay your last ticket. And I don't know what you were doing. You got no insurance, no plate, and you got about 8 prior driving suspendeds in Michigan. Plus you got several more in Indiana. Probably altogether, there's probably 10 of them. So one of the things you need to do is pay your unpaid ticket from 2021. So the car is now insured and in your son's name?
Yeah, yes,
Proper plate too?
yes.
Those charges probably could be worked out, but the prosecutor, like me, isn't gonna be real happy with the fact that you have 10 prior driving suspendeds. And then you don't pay your tickets that you do get. Let's take a look. This was at 10 o'clock in the morning out near where you live on Purgatory. And it looks like they pulled you over speeding. Anyway, Mr. Stickley, you agree here?
I would agree, actually, Your Honor.
All right, show a plea not guilty, appoint an attorney. Set an attorney pretrial for June 20. June 13th. Hi, you can't help me. I got a criminal question. Oh, yeah, all right, I'll figure it out. Thanks. Okay, bye. What do you do, sir? What's your employment?
I work at Interstate Manufacturing.
How are they doing? We used to have a lot of people working there. I don't hear much about them anymore.
Well, we're still huffing it. Not doing too good right now because I'm
It's
not
just
there.
over the, you're not there, so business is falling apart. I thought I had pre-trials on June 13th. But I can't tell if I'm looking at this. When are the pre-trials for me for June?
For June,
I believe the 13th.
um,
20th is Judge Pattison. I'm gone the 6th.
your June was May 30th.
All right, so
So your next one is July 11th.
boy, it's a ways out.
Yeah.
All right, thanks. All right, I'm gonna appoint an attorney, set a pretrial for July 11th. 4th of July is a Friday, so we usually do them on the first Friday of the month. All right, a couple things you need to do. Stop driving. How'd you get here?
My wife.
All right, and pay off your unpaid ticket. When you go out there, they can tell you what that is. That might help your cause with the prosecutor. Your issue for sentencing is the judge. Your issue for the charge is the prosecutor. Right now, we're waiting for the prosecutor to come back so we can see if he'll reduce some of these charges. I can't reduce the charge. The no insurance, as I said, carries a minimum $325 fine. And that's bad because you have a couple previous convictions of that and you didn't pay them. You got multiple previous driving suspendeds and you got to the point where you just don't care. So you're driving anyway. And you were way out in the country and probably didn't expect to get pulled over. The cops aren't out there very much. Anyway, let's see what we can sort out. We'll get you an attorney and get some help. Set it for July 11th at 8:30. All right, you can go with the court officer. Jerry Howard. Hope Gary didn't give up. 3, 4, 5, 6, 7, 8. I think what I'll do, Keith, is I'll do a couple more of these and then take a break. A cure. All right, I'm pretty sure we can do that. Let me make sure that you don't owe me a bunch of money. No. Salama Osama. Good morning, sir. If I look at this one, that's a little out of the norm here. Thank you. I'm going to next out a couple of these. File number 25668, Salama Osama Mahdi. That's you, sir?
Yeah, Osama Majdi Salame.
Say that again.
Osama Majdi Salame.
Majdi is your middle name. Okay. It's important to get people's names right. You got a ticket for allowing another to violate the motor vehicle code.
Yeah.
It's an interesting charge. It's almost never charged as an original charge. It's charged often as a plea down. But this says, now let me tell you what it is. It's a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. It doesn't carry any points and it doesn't go on your driving record. So it won't affect your ability to keep or maintain your license.
Your Honor.
Yes.
May I say something?
Yeah.
It's shown on my ticket as civil infraction.
Yeah, it does, but it's a misdemeanor, so the ticket is wrong. Maybe that's what they intended to do. You allowed Jonathan Borchardt to operate a motorcycle without insurance and without an endorsement.
So what happened was.
Oh, okay, don't tell me too much about it at this point. Now you haven't paid your last batch of fines. You got a speeding ticket. $108 and something else.
Yeah, that was last week.
No proof of insurance.
Yeah, I was driving my girlfriend's car and I got pulled over the day before court. I came in last week, but then I was told that I took vacation last week because the ticket said I had to show up on May 8th. And I was here and they told me that court wasn't today, it was next week.
Well, I apologize. The officer gave you the ticket for May 8th and I see they scratched it out. We were gone. We were at the judicial conference, which is mandatory in Detroit. So that's one of the reasons why today is so busy. So you missed a day of work for that.
Yeah.
What's your thought here, Mr. Stickley?
If I can make just a very brief inquiry of the gentleman. Your Honor, I think there's some extenuating circumstances here. I would see, I don't know that we're gonna figure it out on a pretrial or on an instant pretrial. I can try, but.
Let's try. He's already missed 1 day of work.
that's
Now he's
fine.
missed 2. Have a seat, Mr. Osama, and we'll come back to this.
Yeah, use the bathroom.
Sure.
Yeah.
Yeah, go ahead.
Thank you.
Glenn Yarwood, would
Yes, sir.
you come forward, please?
Yes, sir.
Got a lot more names in here than I have files in front of me. There's instructions in here on how to pay it online.
Okay.
And you can also send it by the money order or pay green cash. All right, sir, you're good to go.
Thank you, sir. Have a great day.
Thank you. All right, Osama Salama, what did you do with this one?
Your Honor, we had a discussion. The people weren't comfortable coming up with a solution. They suggested that a pretrial be set if it was not guilty.
All right, Mr. Salama, here's the deal. At this point, they're not willing to dismiss the charge. If you plead to this charge, I'm going to fine you $75 plus $125 of costs. It won't go on your driving record, but it is a very minor misdemeanor. If you plead guilty, that's what's going to happen. If you plead not guilty, we'll set it for another day for you to take care of these other tickets and then give your explanation.
Well,
What would you like?
I just lost my job.
Because of missing work?
Well, yeah, the day after that, I got suspended because I was late to work. And so when I go back next Monday, I'm gonna get terminated because I had the write-ups for being late.
Where do you work?
American Axle.
For going to court,
No, it's because I used to be on second shift and they bumped me to first shift, and I'm not a morning person, so I was late a couple times. And I got, you can only get 3 write-ups before you get fired, and I got my 3rd one, so.
What do you want to do with this one?
Well, the cop got a lot of stuff wrong on this, and I've been here twice already. Is it like, can we talk to the prosecutor again, see if he can get it dismissed, or?
Well, he did talk to him, and he doesn't wish to dismiss it.
Can we explain more of the circumstances since you didn't hear the story of what happened?
Yes, but he doesn't have time to do it this morning, which means you got to come back on another day. So I apologize, but that's not up to me. That would be my preference, that we reset this and you come back in.
Because I waited 3 hours today, and this is the 2nd time I'm in court. I kind of want to take care of this today.
I understand. You can take care of it and pay a $200 fine, but if you wish to continue your plea of not guilty, I can't.
I don't have any misdemeanors on my name.
What's that?
I said I don't have any misdemeanors.
Yeah, I don't blame
want
you.
one.
You don't want any. So set a pretrial for
When's the earliest we could do?
2 weeks. May 29. Are you working days? Will you have to miss work again for that?
Well, I don't know. It all depends on if I get fired when I go in on Monday. You might give me a chance or you might fire me. So, but then I'm gonna be back on second shift, so I'll be okay.
All
As
right,
long
well,
as
so-
court doesn't take more than 2 p.m.
No, May 29th,
You said what? 8/29?
May 29th.
May 29?
Yes, I apologize. You saw what I was doing. I wasn't in here twiddling my thumbs.
Can you dismiss it or no?
I don't have the authority to dismiss it. Well, it sounds like you may have some defenses, but let's try this. Thursday, May 29th.
At the time, I was just garaging it for a friend named Bridget. That's another one. May 29th.
All right, we're on the home stretch here.
8:30.
8:30.
This one. See.
William Collier.
Thank you.
This is that 6-year, 5-year-old ticket where he has a valid license now and I have bond money. All right, you go with the process or the bailiff. Talk to Miss Cripe. Alpharetta Cripe. Good morning, ma'am.
Good morning.
Again, thank you for your patience. You got the tickets of the day, no insurance and operating without a valid license. So let's take a look at your situation. You got a ticket at Broadway and 131 at 5:30 at night on April 17th. It's just up the street from where you live. Operating without a valid license and no insurance. License was not valid. Pipe was found inside the vehicle. Vehicle stopped for vision instruction. They didn't charge anything other than that. Not valid. Looks like you might be eligible to get it back. Have you done anything to try to get your license back?
Well, I've tried a couple years ago. They just give me the loops and runarounds, and I just gave up.
Did you have some baggage from another state?
Yes, from Elkhart, Indiana, or Goshen, Indiana. But I know it's in Indiana.
Do you have insurance now?
Yes,
Who's your carrier?
Progressive.
Stickley, Mr. Stickley, her Michigan license isn't bad. She has a driving suspended from 2015 and a no operators license from 2017, and then nothing since. So she hasn't had anything in 9 years, but she doesn't have a valid Michigan license. But she now has insurance. All right, I think I'll ask Mr. Stickley to run this past the prosecutor. Are you still at Maple Crest?
Yes.
You used to live on 9th Street?
No. I used to live on 9th Street. Yes.
Yeah, years back.
Yes.
All right, 9th Street, it's a long street. Not really on the way to anywhere, but I drive down that street sometimes. Sorry, give that to Mr. Stickley. Then this is Keith Wilson we dealt with. All right, Anthony Michael Smith. Appears to be in. How about Mr. Keith Wilson? No, I'm asking him what happened. As the guy where we don't have the charging document yet.
You know what, Your Honor?
All right, Ms. Cripe, would you come forward? Return to file 25738 SM, People versus Alpharetta Cripe. You have current insurance on this vehicle?
Yes.
Whose name
It's
is
in my
it?
niece's name, Jasmine Brooks.
Okay. And who owns the car?
Me, my mom owned the car. My mom co-signed it for me so I can have a ride back and forth to my doctor's appointment.
But you can't drive.
No, my niece drives me
Okay.
everywhere. She moved from Elkhart with me so she could drive
All
for
right.
me.
The prosecutors agreed to dismiss the no light operator's license. Just gonna save you 2 points and $200. Do you acknowledge that on that day you didn't have proof that there was valid insurance in the car?
Yes.
Fine and cost is $150. We made a lot of 150s today. Can you pay that in 30 days?
Yes.
Where were you going?
I was on my way coming from the weed dispensary.
All right, well, you can't drive. You could walk to the weed dispensary. Just go to a different one. Literally, you can walk to Harbor Farms from where you live.
Yeah, sometimes it's hard for me to walk because I have rheumatoid arthritis.
Well, you can't do that. Which one were you going to?
The goat.
All right.
Coming from the goat.
All right, well, the prosecutor cut you a big break. So if you got afford to buy weed, you can afford to pay this ticket. So it's due by June 15th. And that won't carry any points. And you're good to go.
Thank you, Your Honor.
Thank you. Anthony Smith. Let's return Mr. Smith's license to him. He's enhanced. The prosecutor agreed to amend this to a charge called
Every day in the USA, people find themselves in court.
And
Talking
but
about the
it's-
12th. You're talking about the 12th.
Yes, it's going to go through the 12th, but it's likely not going to go. So,
Claude Kevin, Commonwealth versus Claude Kevin.
okay, thank you, Your Honor. May I be excused?
Yeah, absolutely.
Thank you.
Commonwealth versus Claude Kevin. Are you Claude Kevin?
Yes, sir.
Good morning. Were you born in 1998?
Yes, sir.
Last 4 digits, social security number 0475.
Yes, sir.
We're on 24 CR 0082. It says probation revocation. You want to come around, Mr. Stockton?
Yes, Your Honor. Mr. Kevin had 7.5 years on bribery for a public servant. He was placed in drug court in Allen County, was discharged, and I have the lady here to testify.
No stipulator.
No, Your Honor, we want to have a hearing.
Oh, you don't want to stipulate? Okay, we'll call your first witness. Okay, you gonna come around? You can just stand right here if you want to. You raise your right hand, please. You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes.
State your name and who you're employed in what capacity.
My name is Samantha Neely. I'm the Program and Recovery Coordinator for Allen and Simpson County Drug Court.
Thank you. You may proceed, Mr. Jones.
11 years.
Okay, so you're familiar with the defendant Claude Cabin,
Yes.
and did you orient him or did him started in drug court in Allen County?
Yes, he was actually a transfer from Monroe County. So we accepted him as a transfer on March the 3rd of 2025, and he attended orientation with us on March 5th of 2025.
Okay, and was he terminated from drug court in Allen County?
He was.
And what date was that?
March 26th of 2025.
So he was only over there for about 21 days?
Yes.
Okay, why was he terminated?
His transfer was accepted contingent upon his placement at a sober living home in Allen County called the Dream House. That was the only approved home placement for him there. And he was unsuccessfully discharged from that placement on March the 25th.
You know why he was discharged?
He refused to stop driving even though he didn't have a license.
That was my next question. So while he was at the sober living house, he continued to drive?
Yes.
Did you get complaints from individuals about that?
I did.
From what, was it private individuals or law?
Private individuals.
I have nothing further.
I have a few questions, Your Honor. Ma'am, with regard to the driving without license, did you ever witness Mr. Cavan drive without license?
I did not, but he did admit to me that he was.
Okay. And with regard to the sober living home, did drug court attempt to help Mr. Cavan with alternative living placement?
No, we accepted the transfer from the other county based on his placement at that sober living. It's the only sober living home in Allen County.
So why did the Allen County Drug Court terminate him instead of send him back to Monroe County, who had sent him to you all?
That's not how our process works. Once the transfer has been transferred, then the process is they either complete that program or administratively discharged or terminated, and then the case is sent back.
So with regard to drug court, was Mr. Cavan otherwise complying with drug court?
No.
Okay. Do you know if the Dream House would have taken Mr. Cavan back?
They would not, or at least that's what they told me.
I have no further questions.
No redirect.
May she be excused? Thank you for attending. You have any other witnesses?
I do not.
Would you like to call a witness?
Yes, Your Honor, Mr. Cavan.
You raise your right hand, please. You swear the testimony about to give the truth, the whole truth, and nothing but the truth.
Yes, sir.
State your full name, please.
Claude Cecil Cavan Jr.
Mr. Cavan, can you explain to the court the issues you are having with housing at the Dream House?
I had self-terminated myself because I was having an issue there. I did drive to work one day, and when I did, they found out about it and they confronted me about it, and I didn't like the fact that I was confronted about it. And so I had subjected to leaving, and they said that that was fine. And I had called Miss Samantha. I called her, told her what was going on, and I told her that I had another placement, but it was through Bowling Green, one of Brad Sowell's home placements. And I had explained to her that moving to his house, I would have bus routes and things to get to work, And while I was trying to get that worked out, I come back to Monroe County and I stayed the night at my father's.
Why did you come back to Monroe?
Um, I didn't know if I was gonna be transferred back into
Okay.
the system here, because when they terminated me, she said to come up here the following Monday. And I showed up and I went to Larry Graves' office and I sat outside his office for a couple hours waiting to find out what was gonna happen.
Okay. With regard to housing in Allen County, did you have anywhere else to live other than the dream house?
Not in Allen County, no.
Okay. And, did you have housing otherwise?
Yes.
Where at?
Back here in Monroe County at my previous address.
Okay. And what are you asking the court to do today?
Well, drug court was helping me. It really was. The AA meetings were helping. Being able to be a part of that community was forming me into a different person. And the fact that I didn't take accountability at the time that I got terminated, really changed my perspective on a lot of things. And now that I'm taking accountability now, I was hoping to maybe either get a chance to go back into drug court here in Monroe County, go back to my previous address, or get sent to a long-term treatment.
And do you believe that you could be successful at drug court this time?
Yes, ma'am.
And if drug court was not an option, do you believe that you could be successful with long-term treatment
Yes.
and on supervision with the probation office?
Yes.
I have no further questions.
Mr. Caven,
Yes, sir.
you were you in jail until you entered the Monroe County Drug Court on this case?
Yes, sir.
And when was you released from jail?
It was December 17th of 2024. I
Okay.
believe.
And so you were in drug courts in Monroe County for about 3 months before you were transferred to Allen County?
Yes, I was in here for it was about 3 months or so, and
And I'm curious, since I don't attend the drug court down here on Monroe County, you was there for 3 months. Did you have violations the reason you were transferred to Allen County?
no, I asked to be transferred to Allen County. I was thinking it was gonna be better for me being in Allen County, and I guess I was not
wrong.
correct. I was not correct.
Yeah, okay. So you voluntarily wanted to go to Allen County and live in this sober living house?
Yes, sir.
Okay. And you never had driver's license the entire time after you were released from jail? Okay. And you said you drove one time?
I did.
Yeah. I have no further questions.
Let me redirect.
No, Your Honor, but I would like to make an offer in lieu of revocation. I'd like to make an argument in lieu of revocation. Your Honor, I'd ask the court to not revoke Mr. Cavan and instead give him another opportunity to be successful on probation, either through drug court if he were to be accepted into the program again, or through long-term treatment with supervision by the probation office. Mr. Cavan was in drug court from December through end of March. Testimony here today says that he shows he did not do very well in Allen County like he expected to while he was on supervision by the drug court. He had some issues with transportation as he did not have a license. He had some issues with housing once he was kicked out of the sober living program. He has testified this morning that he now has a new perspective after everything has happened and would be willing to comply with the terms of either drug court or long-term treatment with supervision by the probation office. And I would ask the court to not revoke him and instead give him another opportunity to be successful on probation and with his recovery.
You want to move to the left a little bit here?
Yes, sir. Sorry.
This case originated because Mr. Cavan was in a bad place. He was on synthetic drugs. He got into the residence of Jackie Wheat, who found him sitting in his truck. He busted out the glass to gain entry. Then he got into a Evangeline Bray's vehicle where she had her infant child strapped in the back and attempted to leave that vehicle with the baby in there. So he was he ended up pleading guilty because he offered the officer like $10,000 to let him go or something like that after all this happened. And he was placed directly into the Monroe County Drug Court program based on his actions and his plea to try to get a handle on this so he wouldn't repeat his conduct. Mr. Cavan's made some bad decisions here by asking to be transferred to Allen County in this case. He would probably still be in Monroe County Drug Court maybe doing fine if he hadn't done that, but you don't get two bites at the apple on this on the drug court program. And it's the Commonwealth's policy, and it always has been, if you're terminated for the drug court program, the Commonwealth asks for revocation.
Did he go in on a plea or a diverse?
Directly in on the plea. He went in front after.
He did a felony plea.
It was a felony plea, 7.5 years sentence.
Anything else?
Judge, I still maintain my argument that I support to not revoke, give him another opportunity.
Well, here's the thing about it. You know, drug court is not a right. It's an opportunity given. It's a break given. And, you know, he wasn't supposed to drive. These are vehicle related situations. He wasn't supposed to drive, didn't have a license. He just violates the thing. And then this argument about where he came and he was doing this, it's just, I just don't think he can be compliant from what I hear in the thing. So I'm going to go ahead and revoke him. And I guess he would be eligible for shock at some time. Is that correct? So I would consider a motion for shock at some time. But, you know, these people have got to comply. If we let everybody just do the way they want to in drug court, come and fro, and then, I mean, there's no reason to have it if they're not compliant. So thank you very much. Timothy Curtis. Timothy Curtis. Are you? And I guess he would be eligible for shock at some time. Is that correct? So I would consider a motion for shock at some time. But, you know, these people have got to comply. If we let everybody just do the way they want to in drug court, come and fro, and then, I mean, there's no reason to have it if they're not compliant. So thank you very much. Timothy Curtis. Timothy Curtis. Are you Timothy Curtis? Good morning. It's Commonwealth versus Timothy Curtis, 25 CR 004. Mr. Curtis, were you born in 1978?
Sir.
Last four digits, social security number 1511.
Yes, sir.
We're here for a pretrial conference. What do we have?
We have a felony plea, Your Honor.
Motion has been filed that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Just plead freely and voluntarily get given?
Yes.
Hey, are you the person that we just identified in the indictment?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney, and are you satisfied with her advice?
Yes, sir.
Have you viewed the evidence Commonwealth has against you? You believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today? You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Right to speedy trial of the jury, the right to be represented by counsel at the jury trial, the right to confront and cross-examine all witnesses called against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of charges against you.
Sir.
You understand that if you, by entering this guilty plea, you give up those charges. You understand that?
Sir.
And I may consider the Commonwealth's recommendation, but I may apply a range of penalty provided by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I'll await a pre-sentence investigation report to be done by probation and parole.
Yes,
In the
sir.
event I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial.
Yes, sir.
You move to your left here, sir. Move to your left. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to trafficking in a controlled substance, first degree, second offense, the defendant shall receive a sentence of 20 years. Upon a plea of guilty to criminal mischief, first degree, and persistent felony offender, second degree, the defendant shall receive a sentence of 10 years. The 10-year sentence and the 20-year sentence shall run consecutively for a total of 30 years. Probated for 5 years, supervised. The defendant shall enter and complete a long-term treatment facility provided by DPA and agreed upon by the Commonwealth. The defendant is currently incarcerated and shall not be released prior to final sentencing. The defendant shall remain incarcerated until the morning of the bed date. Probation and parole shall transport the defendant to the rehab facility. The defendant shall receive credit for time served. The defendant shall pay restitution in the amount of $1,000 at a monthly rate of $100 payable to the Monroe Circuit Court Clerk, with first payment being due 30 days after being released and due on the same date thereafter. Restitution is subject to a 5% clerk's fee. The defendant agrees to have any and all evidence in the above style case forfeited and destroyed in a manner that's consistent with the laws, the Commonwealth, and the holding agency. The defendant shall obtain gainful employment or do a minimum of 30 hours per week of community service until gainful employment is obtained.
Sir, is that your understanding of the Commonwealth's recommendation? Are you pleading guilty because you did commit the act charged in the indictment as amended?
Yes, sir.
You doing so of your own free will? Doing so of your own free will?
Yes, sir.
Knowing your constitutional rights, explain to us it's still your desire to give up those rights, enter plea of guilty, and allow the court to fix your punishment or range committed by law.
Sir.
Okay, you understand, by entering this plea, any future convictions will be enhanced further under the persistent penalty offender law.
Yes, sir.
Is that your signature?
Yes, sir.
I'll accept the agreement, order pre-sentence investigation report, schedule sentencing for June the 12th. Dwayne Flowers. Dwayne Flowers.
Oh, Robert, she's got your Christmas card too.
Come around, Mr. Flowers. Come on around here. Come on up here. Are you Dwayne Flowers? Good morning. Mr. Flowers, you're here on 20 CR 00.
I've never received anything. So
We do have some records, but I do not want to have the hearing today. I would like to have it in June when he is present.
all I'm saying is if there's records, I need to see.
Yeah, I'll get them to you.
Okay, well, I'll just continue it generally and you can redocket it.
Yes, Your Honor. Thank you.
Christopher Sutton.
That's your thing,
Let me finish this, two more people in the grand jury. Are you Christopher Sutton?
Yes, sir.
Good morning. This is 24 CR 007. Mr. Sutton, were you born in 1995?
Yes, sir.
Last four digits, social security number 1321.
Yes.
This is a motion for shock probation. What do you have?
Your Honor, I would like to call Mr. Sutton to testify.
Raise your right hand. Raise your right hand. You swear the testimony you're about to give us the truth, the whole truth, and nothing but the truth.
Yes, sir.
Mr. Sutton, can you explain to the court why it is you're asking for shock probation?
I've been in jail. I've been incarcerated for quite some time now, and everything I got was mainly drug charges, and I feel like if I had rehab, honestly, it would give me the tools that I need when I get back
Mainly,
out.
what besides drug charges, what did you have?
They got me with a step on lawful taking under 1,000 facts. That was their initial charges.
What did you steal?
They said I was taking a tobacco wagon.
Go ahead.
Thank you, Your Honor. Mr. Sutton, were you previously in the drug court program?
I was.
And can you explain what happened with that?
I've had dirty urines and they revoked me over.
Okay. How long were you in the drug court program?
Not very long.
Okay, and by not very long, are we talking about days, weeks, months?
Roughly days.
Okay.
That's why I feel like rehab would be a more reasonable option.
Okay, so are you currently facing a pending circuit case in Barron?
Yes.
Okay, and what is that charge?
Possession charge.
What does that stem from? What are the allegations?
Allegations, possessions. I don't know how to know
Okay.
what you mean.
And with regard to, do you have a holder out of Barron Circuit?
Yes. I
Okay,
would
is it,
assume.
is it bond?
No, they're just agreeing if I get this, then I can go to rehab also.
Okay. And, do you
What you're
feel,
telling me is why he's been out. He got charged with possession.
yes, Judge, but that was the subject of the underlying revocation we had in this case. He picked up a new possession charge in Barron that is still pending.
Oh, it's in drug court.
Yeah, that is what got,
You had the marijuana, I mean, the meth on your person while using the drug court office. See?
Unknowingly, but yes, that's what they got me with.
Somebody planted on you?
No, sir, I'm assuming that it was left in my clothes, honestly.
By
I didn't
someone
know.
else or?
Just to say I
Okay,
didn't.
go ahead.
Mr. Sutton, when the incident occurred in drug court, had you been in drug court long enough to have the tools for sobriety?
I hadn't been in drug court long enough to speak with the life skills officer.
Okay, so you had not gone to any counseling yet?
Nothing.
Okay. You had just started the program pretty much?
Yes.
Okay, I have no further questions.
I don't have any questions.
Your Honor, I would like to make an argument for shock probation on Mr. Sutton's behalf. We would ask the court to grant shock probation, allow Mr. Sutton to go to long-term treatment. When he picked up the possession charge in Barron, he had been in drug court only a matter of days. He had been oriented into the program, but he had not yet been set up for the counseling, which means that while Mr. Sutton was technically in drug court, he had not been given any of the tools or had the opportunity to obtain any of the tools to work on his sobriety. While I understand that Mr. Sutton does have that pending charge, it is a possession charge. And the best way that we can help Mr. Sutton and ensure no future criminal activity is to send someone to treatment. Drug court did not work out, but we are asking for a long-term treatment. We can arrange the bed. We have had him assessed while this case has been pending shock probation. He would qualify for treatment. I would provide that bed letter to Mr. Stockton for the Commonwealth to approve of that placement, or if the court would prefer, then we would also be agreeable to probation making the recommendation for treatment. But we are asking the court to give Mr. Sutton one more chance.
Your Honor, the Commonwealth's opposed to shock probation. Mr. Sutton has a problem with hiding methamphetamine. When he was arrested for stealing the trailer, which is the underlying case in this, he had a 9mm pistol with meth stuck up in the butt of the gun. Now he's got meth in his pocket when he goes into the drug court office. So I just don't see how he would be amenable.
I think Mr. Sutton got a better deal than I thought at the time, you know.
He served some jail time and then went.
Yeah, you know, I just don't, I just think he just needs to serve his time. Thank you. Michael Vibbert. Michael Vibbert.
Your Honor, Rotor is supposed to be bringing him down. We were going to enter a felony plea today on his cases, but we are unable to do so unless and until he gets here. So I would ask.
You inform me, I'll leave it open. Did y'all clear the jury, you clear the jury box out there? We're gonna bring the grand jury in.
Okay.
As soon as the grand jury finishes, they'll be over to talk to you about it, Mr. Austin, okay?
Yes, sir.
David Buck. How well, David Buck?
Yes, sir.
This is 24 CR 0080 and 24 CR 0078. Mr. Buck was born in 1954 and last four digits social security number 4580. What's the Commonwealth had to say?
Your Honor, this started out as my motion for supervised probation, I'm sorry. After he was released from the Monroe County with drug court, he was administratively discharged. He's got a 5-year sentence. And you wanted him to get housing, DPA to get housing for him. I don't think they've been able to. Is that right?
No, we are Mr. Buck wishes to stand revoked, Your Honor, on both of the cases after further communication with him.
He wishes to do what?
He wishes to stand revoked on these and would like to get his time calculated by DOC.
Okay, we can accomplish that.
I believe it's a pre-child alert.
So I'll have to
Is it?
order pre-sentence investigation report to be done by probation and parole. We'll have a sentencing on the 12th. And Mr. Buck, this time will be good that you're getting it towards your calculation, okay?
Thank you.
James Dockery. James Dockery. Commonwealth versus James Dockery, 25 CR 006 for sentencing. You are James Dockery, is that correct?
Yes,
Born in 1963.
yes, sir.
Last four digits of your social security number 6386. Mr. Dockery, have you had an opportunity to look at the pre-sentence investigation?
Yes,
Substantially correct.
yes.
Counsel, is there any reason this gentleman should not be sentenced today?
No, you're.
Upon a plea of guilty to failure to comply with sex offender register first offense, the defendant shows of 1 year served. Okay, thank you very much. Mark Hunter.
Yes, sir.
How much? This is another motion to secure the attendance of a witness. You have no objection?
I don't think we have standing objection.
Okay, well. Michael Turner for review. Commonwealth versus Michael Turner. 0055. Mr. Turner was born in 1967. The last four digits for social security number 1161 is for review. Was a Commonwealth.
Your Honor, the Commonwealth and District Court has filed a petition for involuntary hospitalization. I also contacted Mr. Stevens, the county attorney, yesterday and asked him to file a petition for guardianship where the state could be appointed guardians for Mr. Turner. I would just let the case continue till both of those matters are accomplished.
Since he's incarcerated, let's give a date certain. Let's put June the 12th to review this again. Your attorney.
Say something.
Your
I'm
attorney.
not talking. He's not coming to see me. I'm not talking to my attorney. And I was released 3 times.
Wait just a second. Wait just a second.
Charges filed against him.
Wait just a second.
For slaming me against the door last time.
Sir, I'm telling you to be quiet. I'm trying to help you here just for a second, okay? When have you been over to see him?
It's been a few months, Judge, I think.
Well, you need to go over and consult with this gentleman within this week, within a week from today. Your attorney will be over to see you. I've ordered him to come over and see you and discuss this matter with you, Mr. Turner, okay?
Can I say something, Your Honor?
At your own peril. You know, anything you say could be used against you, but go ahead.
I don't need no guardian. They're trying to commit me for property and everything. I'm an eyewitness to them killing Katie Cawthorn. I have tried to get the state police and the FBI in here, and they have robbed me blind out there, even tore my house down. Stole my truck. And I can't get nothing done.
Okay, I can't talk about the case with you here. Okay, your attorney will be over to talk to you, and he'll explain what your options are. Okay, thank you very much.
Well, he's working for them. Can I borrow him and be let out?
Okay, take the gentleman back to his cell.
Don't touch me. I'm not.
Thank you very much. Oh, it's a pleasure talking to you. Brittany Williams. Brittany Williams.
Yes, sir.
Commonwealth versus Brittany Williams, 25 CR 0021. Are you Brittany Williams?
Yes, sir.
Were you born in 1991?
Yes, sir.
Last four digits of your social security number 2941. You're here for the purpose of arraignment. Did the public advocate's office represent you in district court?
No, I never went to court. They just took it all upstairs.
The 12th, they want to see what the parole board does, sir. And that'll, okay, thank you very much. Okay, now let's go back and get Benjamin Tooley. Benjamin Tooley. Commonwealth versus Benjamin Tooley. '24 CR 0020. Are you Benjamin Tooley?
Yes, sir.
Good morning. You born in 1987.
Yes, sir.
Social Security number 2174. You're here for
Yeah.
sentence. You're here for sentencing today. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes.
Mr. That's the way I was going. I don't know what I called the right. No, did I call 24 CR 0020? Yeah, okay. Mr. Bell, if you had an opportunity to look at this, is there any reason this defendant should not be sentenced?
There is not, Your Honor. The only issue we had, and we've talked to probation pros about the days he was given.
Upon a plea of guilty to possession of controlled substance, first degree, first offense, the defendant shall receive a sentence of 1 year. And the ballot's probated for 5 years. It's still run consecutively to the Monroe indictment 20 CR 005, 21 CR 0093, and 21 CR 0092. What is the problem? Are you still working on the number of days?
Right, maybe I can explain what's going on.
It's always
So
good.
he's got to serve his 120 days before goes to rehab. He's only been credited 24 days. Because he was held on a probation violation on a lot of the time he's been in jail on the previous case. He only got time from the time he was arrested on 2/20 till he made bond on 3/14.
That would be correct.
But he's never been out since that time. We were hoping you would give him credit for the time of his arrest.
I don't think that was the intent of the plea. Is that correct, Mr. Stockton?
I think Mr. Tooley's getting a good break. I hope he does well after he gets his time in and goes to rehab.
Okay, thank you very much.
Thank you, Judge. You have a good day.
Thank you. Is there anyone else? I'm gonna waive the court costs on Mr. Tooley since the time he served.
Thank you.
See that?
Okay, now we have an evidentiary hearing, is that correct?
Yeah, Your Honor, but one matter before that, if we could take up Kendra Ford, who was not on the docket, 20 CR 77. We've submitted an order to extend her probation. She's graduating from the special report program, but her probation expires about 2 days before the
Is
graduation.
her here?
She is here, Your Honor.
So we're just asking to extend her probation for 90 days.
You gonna be a graduate?
Yeah.
Okay, well, that's good. Well,
Thank
we'll extend it. Is that your signature?
Yes, sir.
I'll accept the agreement order pre-sentence investigation report, schedule sentencing for June 12th. Dwayne Flowers. Dwayne Flowers.
Oh, Auburn. She's got your Christmas party too. I just can't get to me.
Come around, Mr. Flowers. Come on around here. Come on up here. Are you Dwayne Flowers? Good morning. Mr. Flowers, you're here on 20 CR 0082, a pretrial diversion revocation. Were you born in 1973? Last four, you're gonna have to say something. It's a voice. Okay, let me hear you. Okay. That's what gets the camera on you, what the noise does. You see what I'm saying? It's a voice activated camera. The last 4 digits, social security number 0177.
Yes.
We're here on a pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, Mr. Flowers had a 5-year sentence on theft by unlawful taking. He was being supervised
And then in September of 23, he left the state from supervision, went to Texas, and that's where he was extradited from. So he's been absconded from September of 23 through May of, or April of 25. That's the beginning stuff.
Judge, we're asking for a hearing.
Are you with us?
No, Mr. Collins.
Raise your right hand, please. You swear the testimony you're about to give us the truth, whole truth, nothing but the truth.
I do, Your Honor.
Okay, Mr. Stockton.
Mr. Collins, looked like Mr. Flowers began supervision sometime in September 2021. Is that correct?
Yeah, it was the supervision began 6/17 of 21.
Okay. And then what happened in September of 23?
So in September 27th of 23, well, let's back up and go from December of 2022.
Okay.
So on 11/8 of 2022, Mr. Flowers reported the address of 117 Countryside Drive, Apartment 4, reported telephone number of 270-779-7989. He was given the next report day of 12/13 of 22 at 10 a.m. On 12/9/22, Officer Ryan Cowles attempted to call subject, scheduled to reschedule his report day, did not answer his phone, and no voicemail was set up to leave a message. Mr. Flowers did not report as originally directed on 12/13 of 22 and did not call to explain why he could not report. And on 12/19 of 22, Officer Cowles and Officer Pitcock attempted to contact Mr. Flowers at his reported address. They did not make contact with anyone at the address, left a door tag directing him to report on 12/20/22 at 9 o'clock. He did not report on 12/20/22 as directed by the door tag. That officer conducted a justice exchange and called medical centers, could not find him or locate him. And then he was charged with absconding there, and what looks like probably a warrant was issued then for absconding.
And then it looks like the last contact with Mr. Flowers in September of 23.
And on 9/27 of 23, Mr. Flowers called from a telephone number, which was the number gave him previously, stated that he was currently homeless in Dallas, Texas. He stated that he ran off from Kentucky because he was scared that a man in Kentucky was out to do harm to him. He stated that he knew he had messed up and did not want to go to prison. He advised subject that he would need to turn himself in on the warrant to get back to Kentucky. Subject was resistant to this idea and asked if he could make things right without having to go to jail. Officer Cowles advised him that as long as this warrant was active, the worst it would be on him to appear for his revocation hearing. He was given again directive to turn himself into local law enforcement. And then Officer Cowles called KSP Post to verify that he was entered into NCIC.
So I was wrong a while ago. It's even worse than I thought. Really, the last contact where he reported was October of 2021. Is that correct?
From what I see, correct.
Okay. So really probation parole, other than the one phone call, has had no contact with him since October of 2021.
Correct.
Yeah. Thank you.
Ask some questions, Your Honor.
Sure.
Officer Collins, the first missed appointment was December the 13th.
He last
2022.
he last reported on 11/8 of 22 and was given a next report day of 12/13 of 22, and he never reported after that.
Okay.
Yeah.
And so up until December the 13th of 2022, Mr. Mr. Flowers was otherwise compliant with probation's expectation of meeting with him.
Well, not entirely. On 9/16 of 21, looks like he was asked to provide a sample for drug testing, field tested positive for THC, and he admitted that he used an edible on 8/26 of 21 and signed an admission form for that. And it looks like that's the only problems he had prior to that.
And with regard to that, to the incident with the THC, did probation sanction him?
We did. For a marijuana positive for the first time, they're required to complete a marijuana education homework packet. It was supposed to be turned in on 10/14/21, and I'm not sure if that ever got turned in.
Okay.
So
But you also don't know if it was never turned in.
correct.
Okay. And just to establish, you did not personally supervise him?
I did not. This officer's no longer with the department. So,
Okay. And I missed what the what date it is that the report was finalized. What was the last report? When was it finalized?
the last report was finalized on 9/27 of 23.
So do you have any information about any potential contact between probation and Mr. Flowers after that?
The last contact that was made was notated by this officer on 9/27 of 23.
I have no further questions. Thank you.
Yes.
No redirect, Your Honor.
You have another witness?
No other witness.
Your Honor, I'm going to call Mr. Flowers to testify.
Raise your right hand, Mr. Flowers. You swear the testimony about to give us the truth, whole truth, and nothing but the truth.
Yes.
You may proceed.
Mr. Flowers, can you explain to the court why it is that you missed a report date on December the 13th, 2022?
Thought I was okay. I talked to the probation officer about being sent to Texas, because I have family there, and there was problems there with a couple of people. I said, no, I don't want to be involved in this. And there was actually like serious wanting to do harm to me.
Okay.
So I talked to the probation officer and thought that I would be transferred as unsupervised probation in Texas. It got worse. I had to call the police to help get escorted away from there safely. So when I got to that happening, I went on and got on a Greyhound and I left here. So where I could be safe around family.
Okay.
When I did contact Officer Cowles, apparently that wasn't the case of him finishing out me being transported.
Okay. And with regard to Kentucky, did you have any family in Kentucky?
No,
Okay, any support system in Kentucky?
no.
Is the only support system or family you have, were they in Texas?
They're in Texas.
Okay. And can you explain to the court, why it is you did not come back after September the 27th, 2023?
After which date?
September the 27th, that is when, probation last had contact with you.
September. So I was supposed to be back to see him till like October
No, 2023.
of 23.
Yeah, when you were in Texas and you spoke with the probation officer at that point.
I was trying to get enough money because at that time he was saying that I might be going to jail. So I was trying to get enough money to get an attorney.
Okay.
I've been working actually a salesman at Toyota.
Okay. Did you intend to make your whereabouts unknown to probation?
No, he the whole time knew of my address in Texas. He knows that that's my family.
Okay.
And when I told him that I was homeless, is because I didn't want my family directly involved with what I had going on. But
Okay.
he has the address of my sister and where I've been staying since I've gotten arrested this time.
Okay. And with regard to the address to probation, if you were to be offered another opportunity to be on probation, would you comply with the rules and regulations of probation,
Yes,
including reporting?
yes.
Is there anything else that you would like the court to know?
Sorry to misunderstanding, but I'm okay with following the laws of probation. That first time was a mistake. Thought that it was candy, wasn't. But each time after that, I passed each drug test.
And Mr. Flowers, had you been on supervision before?
No.
Okay. I have no further questions.
I just have one. Who was threatening you, Mr. Flowers?
Some members of aid member of Hamilton family.
What was the name of the person?
He's deceased now, Marcus Hamilton.
Hey, why was he threatening?
Because I'm was with and still talk to now his ex-wife. We were together even when the incident of me even being in jail. Drove her car to court, but I was accused of taking her car somehow. And now I've said, okay, I couldn't afford an attorney. I took the consequences of probation and followed probation.
Did you move to Texas because you were afraid of this transit?
it would have been phone threats, and I still have on my Facebook and messages where he was threatening me over there on my Facebook.
I have no other questions.
Your Honor, I have no further questions for him, but I would like to make an argument in lieu of revocation.
Okay.
I would ask the court to not revoke Mr. Flowers. He came onto pretrial diversion in June of 2021 and did have a positive test for marijuana in September of 2021. That probation issued a sanction, including a marijuana education packet. There were no
Was his
further.
pretrial diversion revoked? This is, so it, when she
It's
said,
been pending now for, I guess, 2 years, over 2 years.
okay, go ahead.
Okay. The next violation occurred, with regard to the failure to report on December the 13th, 2022. So up until that point, he was relatively compliant with probation and showed that he could be, managed in the community, that he was not a danger to the community. Mr. Flowers has testified to the court that he became afraid, that he was being threatened here in, Monroe County, that he had no support system here in Monroe County or in Kentucky, that everybody that he knows is in Texas, that he had contacted his probation.
So I don't understand what the testimony is. Is he just left and he told his probation officer he's leaving?
Judge, it is my understanding that Mr. Flowers misunderstood how the interstate compact works and believed that the discussion with his probation officer was good enough at that point for him to go to Texas. And he believed that in Texas
Well,
that he would be.
did he have any
unsupervised.
contact with probation and parole in Texas?
Judge, he did contact his probation officer in
Texas,
September of
he said he
2023.
thought he was getting transferred to Texas. Did he have any interaction with probation parole in Texas?
Judge, I am
I'm
unaware if
asking
he
you,
has.
I'm gonna be like a congressional person, yes or no? If you don't know.
I don't know.
Okay, well, he had an opportunity to tell me and he didn't. Go ahead. Do you have anything else?
No, this is a sad case because Mr. Flowers seemed like a reasonable person. If he had just went through the process and requested an interstate compact transfer to Texas and stayed here until it was approved, he would probably been approved. But you just can't go willy-nilly and do what you want to, and just, these probation officers have a hard enough job trying to keep up with everybody without people not being cooperative.
And Judge, I would like to point out to the court, this was a pretrial diversion. Mr. Flowers had never been on supervision before, so he would not be as familiar with the rules and regulations of probation as someone who had been on.
You don't know how familiar he was or wasn't.
He qualified for a
test-
pretrial diversion, Your Honor.
Yeah. Everybody just about does pretrial diversion. I'm not buying the fact that you just leave the state and aren't in contact with anybody and you think everything's cool. And then you have to be extradited back to the state. I'm just not buying that. What I'm gonna do is I'm gonna revoke the pretrial diversion order, pre-sentence investigation report to be done by probation parole. And then we have the sentencing on June the 12th, and I'll take it, once we see this report, then I'll take a look at whether I probate him or not.
Thank you.
He seems like a fairly, potentially a good prospect for probation, but, we'll see him then, okay?
Thank you, Your Honor.
Yeah. Derek Graves. Elmo versus Derek Graves, 18 CR 00176. Are you Derek Graves?
Yes, sir.
Good morning. Were you born in 1994?
Yes, sir.
Last four digits, social security number 1206.
Yes, sir.
Okay. We have a report, then I'll take a look at whether I probate him or not.
Thank you.
He seems like a fairly, potentially a good prospect for probation, but, we'll see him then, okay?
Thank you, Your Honor.
Yeah. Derek Graves. Elmo versus Derek Graves, 18 CR 00176. Are you Derek Graves?
Yes, sir.
Good morning. Were you born in 1994?
Yes, sir.
Last four digits, social security number 1206.
Yes, sir.
Okay. We have a probation revocation. You will call your first witness, Mr. Stockton?
Yes, this is the Commonwealth's fourth motion to revoke probation, Mr. Collins.
Okay, y'all move over this way, sir.
Yes, sir.
Raise your right hand and swear to testimony about to give us the truth, whole truth, nothing but the truth.
I do, Your Honor.
Where do you want to start at, Mr. Collins, as far as the rights violation? Yes.
That'd be fine.
Okay. Could you go ahead and
Yes,
detail Mr. Graves' violations?
I can.
What they could do?
Yes, Officer Timothy Norton was supervising Mr. Graves at the time this violation occurred. On 12/9 of 24, Mr. Graves was seen at the probation and parole office and given an next report date of 1/9 of 25. Graves did not report on 1/9, did not have a cell phone, which prevented Officer Norton from being able to call him. As of 12/9/24, or I guess it would be as of the date of the report of 1/21/25, Graves still had not made contact with probation and parole. Failed to report changing home address to his parole officer on 1/17 of 25. Officer Norton attempted to contact Mr. Graves' his last reported address at 509 Dennis Way, apartment B1, which was the Soki sober living home. A new resident answered the door and stated that Graves had moved out weeks prior and not been heard from. So officer did not know the current location of Graves. He had failed to make contact or update his current address. Next violation was absconding. After Graves failed to show up for his scheduled report day on 1/9, Officer Norton attempted to make contact with Mr. Graves via phone. However, Graves did not have a working phone. An attempt was made to contact Mr. Graves' last reported address on 509 Dennis Way. And it was discovered he had no longer resides there. He had not provided any phone numbers, emergency contacts, or relatives. Checked Justice Exchange and jails, hospitals. They all yielded no information. Then a probation violation warrant was issued for absconding then.
When was the next time then Mr. Graves was heard from him?
On 4/23 of 25, Mr. Graves was arrested and charged in Monroe County case number 25M42 for fleeing or evading police third degree and alcohol intoxication in public place first or second offense.
And what did the memo say that the officers?
Officers went to 309 Dillon, Officer Deputy 309 Dillon Victory went to attempt to serve a bench warrant on Mr. Graves. Upon turning onto Brandon Road, they spotted Derek in red shorts and a white t-shirt standing outside beside his dad, Billy Graves. We approached Derek, as we approached Derek, he reached his hands into the front of his shorts and took off on foot towards the woods. Myself and Dylan went on foot, pursued after him. After clearing the shed that Derek ran behind, by the time we got in the woods, we lost sight of him. Deputy Geralds arrived on scene about an hour later, and all units went to the edge of the field by the woods, and Mr. Graves was located in the woods, hiding under trees. Mr. Graves had a strong odor of alcohol on his person. He was arrested without incident and transported to the PD.
No further questions.
Just one question, Officer Collins. Are you aware of what the ultimate resolution was to that new misdemeanor case?
I'm not.
No other witness.
Do I call a witness?
Yes, Your Honor, if I could call Mr. Graves.
Raise your right hand, sir. You swear to testimony about to give us the truth, whole truth, nothing but the truth.
Yes, sir.
Derek, can you tell the court what it was that was going on in your personal life that led to these violations?
Well, I went to sober living and I went to actually two of them. I went to Gateway and it was seasonal, so I couldn't get no job at the time. So I stayed at Gateway till they kicked me out. So I went to Soki. And at Soki, I stayed there, still try to get a job. Couldn't find no job. They kicked me out 2 days prior to Christmas. Told me either go to whatever you call it, a Salvation Army, or you're on your own. So I went home. I actually contacted Norton on the field and told him that I need to change my address to Monroe County because I got kicked out of Soki Living. And well, he said, I explained to him that because my mother just died in September, and then my grandma died that day on the field when I called. So when I told him that, he said, he's going to put me, he said, okay, we'll just leave you in the system and
I
don't.
mean, we got a lot of hearsay going on here. I mean, I'm not. I,
Hearsay, Your Honor, generally the rules with probation hearings are that
we
hearsay.
generally
is
are,
allowed.
but you know, we have hearsay on top of hearsay on top of hearsay. I mean, but I'll let him go on. Go ahead.
I just think what's relevant is
Yeah, I don't understand.
the actual violations that we put before the court.
Your Honor, the allegations are that he absconded from probation and parole. We are currently trying to explain to the court
Why?
what was going
Yeah.
on with his
So you
housing
admit he
situation.
absconded, you admit he absconded, and now you're trying to explain why he absconded.
Your Honor, we're
right? Is
trying
that
to-
right?
We're trying
Is that
to,
correct?
that is not exactly correct, Your Honor.
Not exactly.
Yes.
Okay, well, go ahead then. I want to be exact.
And I talked to Officer Norton, like I said, on the 5th, and then he called again, my grandmother on the 17th, because I told him on the 5th, I didn't have no working phone and what was going on. And they said that it was okay, just stay in contact with him. So when he called back on the 17th, my grandma was actually in the hospital, so when he talked to her, I didn't get to talk to him back to the 22nd. And then he explained to me what was going on. And then I ended up getting a fungal infection. So I ended up actually going to the hospital myself in Stanford 4 or 5 days. And then they treated me, they actually made it worse because they gave me infection pills, and it actually makes a fungal infection. I know you probably don't.
We're following this.
I'm explaining to you how it led to the situation where it was at.
You know, I don't know. Let's go, move on.
Move on.
Yes, Your Honor. Derek, can you tell the court what your plea agreement was on that new misdemeanor? case?
PI,
On the
Yes.
AI charge, not on the pleading and evading.
not the pleading invading. I did not plead invade.
Those are all the questions that I have.
I have no questions.
You'll make statements.
Your Honor, at this time, Mr. Graves is asking for the court to allow him to remain on supervision. He would be willing to go back to another sober living residence or other treatment program as the court requires.
Let's comment on that.
Well, Your Honor, this is an 18 case. And it looks like he's been supervised since December of 18. His probation's been extended. This is the Commonwealth's 4th motion to revoke. He's had various, just about every type of violation between now and then he absconded, and he can't be accused of not knowing how the process worked. If he got kicked out of that sober living home, he should have went directly and reported to his officer and made arrangements to get this done. Instead, he goes into the wind and then runs from the officers when they catch him. You know, if he's not revoked, you might as well just let him go and do what he wants to, because that's what he's doing anyway.
Okay, well, this time you got this behind you here. I'm gonna revoke you and just let, you'll be eligible for parole pretty soon. You know, and that'd probably be a less restrictive supervision and better for you than this probation. You haven't done with probation well. William Miller. William Miller.
Judge. William Miller was picked up by Roderer this morning. So he is not here. I would request if we could continue this until June.
He was picked up what?
He was picked up by the prison this morning.
It's short motion and Roderer can't going.
Okay,
Thank you, Your Honor.
Thank you. Okay, we have the matter of Commonwealth versus John Wood. 12 CR 0041-001, an evidentiary hearing. Call that case. John Smith, yes. Who's handling the evidentiary hearing for the Commonwealth?
Mr. Hunley and I, he stepped to the restroom.
Is John Smith here?
Yes.
Yeah, this is paperwork for the correction doc.
For John Smith.
You get it on record in your order that you asked for extension and they denied it.
I think so. I know that I submitted her. I done wrestling back. She's on, she doesn't think that's a paper. The only person I did was wrestling.
Y'all are picking up on the microphone over there. One person.
Who would that be, Judge?
I know the voice sounds vaguely familiar. Okay, we're here on, for a hearing on 1142 motion in which the Court of Appeals ordered us to take evidence in the form of an evidentiary hearing on the issue of ineffective assistance of counsel as it relates to trial counsels not introducing evidence of Mr. Smith's alibi. Is that correct statement, counsel?
Yes.
Okay. You want to call your
I don't believe the burden is on the Commonwealth on this, John.
He's correct. It's our burden.
Well, you want to call somebody or we at?
I would call Mr. Smith.
Impasse.
I'll call Mr. Smith.
Hey, Mr. Smith, come up and take the stand, Mr. Smith. Show Mr. Smith where to go here, Mr. Bailiff. Thank you. Okay, Mr. Smith, the best you can, will you raise your right hand? You swear the testimony you're about to give us the truth, the whole truth, and nothing but the truth.
Yes.
Have a seat there and state your name and answer your counsel's question.
John Smith.
Okay, counsel, you may proceed.
Thank you. Mr. Smith, you know that we're here today on an 1142 motion that you filed regarding your conviction that was occurred in this court previously.
Yes, ma'am.
Okay. And the subject of this hearing, just to kind of get us oriented, as we have discussed, the Court of Appeals has allowed us to present evidence on the issue of whether, about your alibi defense. Is
Yes,
that
ma'am.
correct? Okay. Can you tell the court, explain to us what that alibi defense was?
Well, the state police took a cell phone off of me and it had several messages on it where I called Chastity Hagan from Wanda Hagan's home phone. It was a landline. And nobody ever seemed to care to try to get them messages or see that the calls was made. You can't be in two places at once.
Had you also made, now we are talking about, just to make sure that we're all on the same page, we're talking about the time frame in which the murder that you were convicted of occurred.
Yes, ma'am.
Correct? Okay. So
during that time period, where were you?
I was at Chastity Hagen's mama's house.
And did you make phone calls from the landline there at that residence?
Yes, ma'am.
Who did you make phone calls to?
I called Chastity on her cell phone.
Did you also call someone named Loretta?
Loretta Decker, yes.
Okay. And it was your belief that this would prove where you were during that time, correct?
Yes, ma'am.
Did you advise your attorneys of this?
Yes, ma'am.
Who did you tell?
Well, Miss Sandra Downs and Mr. Michael Buffkin.
And were they the attorneys representing you at that time?
Yes, ma'am.
And what kind of response did you get from them regarding that?
They act like it'd been looked at, but it couldn't have been looked at or they would have known the times and everything I'm talking about.
Did they talk to you about any efforts they had made to, as you say, look into that?
Not that I know
Did you ever speak to any investigators in the case?
of. Yes,
That were working for the defense, not like police?
yes.
Okay. Do you remember who those people were?
One of them was Josephine Guy and the other one was Miss Jessica Shoemaker.
And did you talk to them about this issue as well?
Yes, I did.
And what kind of response did they give?
Apparently they never checked on it because the proof's there.
Now, you actually proceeded to a jury trial in this matter, right?
Yes, ma'am.
At that trial, were there any witnesses called to present this defense that you're talking about?
No,
So no one testified regarding any kind of phone records from the house that you say you were at?
no, ma'am.
And there were no witnesses called who said that they had had a conversation with you during that time?
No, ma'am.
Were you able to speak to your attorneys about why that was?
Kind of after my trial, I never had much contact with them after that.
So you never did have an explanation?
No.
Is there anything else about this issue, as you know?
He said after the trial.
Yes.
Yeah.
That's correct, right? You
Yes,
said
ma'am.
after the trial. Is there anything else as regards to this particular issue that you would like the court to know?
It's like somebody check into them phone records because you can't be in two places at once.
And it is your contention that you were at that home and did not commit this murder?
Yes, ma'am, that's a fact.
I have nothing further from Mr. Smith at this time.
Commonwealth have any questions?
A moment, Your Honor. Mr. Smith, you remember in the hours following Miss Howard's death, you were taken into custody by police officers?
State police, yes.
Did you tell them about these phone calls?
They's the one who took the phone off of me. I had the phone on me at that time.
No, my question was, did you tell the officers about these phone calls?
I was too busy getting kicked to the ground and handcuffed.
So I take it your answer is no, you didn't tell them?
I told the detectives when they questioned me, I think his name was Russell Deckard and
Officer Brooks?
Barry Brooks. No, it wasn't Barry Brooks. He was a Brooks, though.
Did you tell those officers then that you had an alibi or the possibility of an alibi?
I've told everybody I've ever talked to about it.
Yeah, my question is, did
Yes,
you
sir.
tell those officers about
Yes, sir.
that? Where did that conversation or that interrogation take place?
The city police hall.
All right. About how long was it?
Couple hours, I'd say, hour and a half, 2 hours.
Or they were accusing you of the murder of Mrs. Howard, weren't they?
Yes,
And you denied it.
yes.
But you didn't tell them specifically about this alibi?
I've told everyone I've ever talked to.
But did you
everyone.
tell these two officers? Now,
Yes,
wait a
sir.
minute.
Wait till he finishes his question before you answer, okay? Go ahead, Mr.
If I were being interrogated for a murder that happened less than 24 hours before that, and I had an alibi that would prove I was somewhere else, don't you believe I would tell those officers that then and not here 10 years later?
I told them then, I'm telling them now. I've told anybody to listen to me.
So that's your testimony. You told the officer.
I've told everyone that's ever listened to me.
Was that at the place
The officers,
Wait. Let him finish it, Mr. Huntley. Let him, you go ahead and finish.
I've told the officers, I've told every lawyer I've had 15 different lawyers. I've told everyone that's ever been around me that's been involved in this case.
describing the scenario I just gave you, don't you believe if I had an alibi, I would tell the officers then?
I told them then.
Ask and answer it. He said he did tell them.
I did tell them then. I've told every lawyer I've had.
Move on.
I have nothing further.
I have a question. Did you mention it to your lawyers at the trial? I mean, you said you talked to them after the trial. You were at the trial.
Yes, sir.
You didn't mention it at the trial to them?
I mentioned everything to Mr. Buffkin over
I'm
here.
asking you specifically. Did you
Yes.
mention at the trial that you thought that they ought to call the alibi, to challenge the alibi?
I've told him a dozen times, even at my trial. He asked me, what do you think I need to ask? I'm not an attorney. I told him about my alibi, because that proves everything I'm saying.
Thank you very much. Now, do you have another witness?
Can I do redirect just
You
very?
surely may.
Just to be clear, your testimony on direct was that you had told your attorneys before the trial, during preparation.
Yes, way before the trial.
That wasn't his testimony, I don't believe, but now I'll accept it.
I believe it was.
Well, I'll accept it now. That's what he's testified to.
And I think what you said was that you didn't get to speak to them after the trial.
After the trial.
Okay.
And I also just wanted to clarify, because you also mentioned to Mr. Hunley, that a phone was taken from you.
Yes, ma'am.
I think that could be a little unclear. So explain to the court whose cell phone you're talking about that was taken from your person.
It was Chastity's phone. It was a cell phone.
Okay. So during the time frame that we're talking about, the alibi defense, did you have the cell phone at that time?
I had the cell phone when the state police arrested me.
So you didn't have it during
No.
the time? Okay.
No, ma'am. I
Who
called from,
did have it?
Chastity had it.
Okay. So when you say that cell phone
Yes,
would show that you made calls, it would show that you made calls from the landline
Yes, ma'am.
to Chastity.
yes, ma'am.
I just wanted to make sure that was clear. I think that's all.
Okay. Mr. Hunley.
Do I understand that night or the next morning, you did not have Chastity's telephone?
I had it that morning when the police arrested me. I had the cell phone in my pocket.
Did you tell the state police that you didn't make any phone calls on that phone? You didn't?
I didn't make no calls on it. I made them to it.
Did you not tell the state police that you didn't make any phone calls while you were at Wanda's?
The two state,
I'm a little confused by that question myself. There were a lot of negatives in it.
Yeah, just restated.
Did you tell the state police that you did not make any telephone calls that night when you say you were at Wanda's?
no, I didn't tell them I hadn't made no phone calls, cause I had.
Did they question you about whether you had made phone calls?
Mr. Brooks and Mr. Decker, when they questioned me, I told them about the cell phone. Nobody has ever wanted to check into it. I've never seen nothing that shows nobody's ever checked into that. My lawyers, no detectives, nobody.
Did they talk to you about cell towers and the ability they had to track people using cell phones?
That's what I want to do. Yes.
Well, you all discussed, they discussed that with you that night.
I told them about the phones. Before I made the call and left the
My
messages.
question is, that next morning when they had you in custody and they were interrogating you, they were interrogating you about the use of the phones and how they had the ability to track them. Is that correct?
I mean, I know they have the ability to track them because that's what I want them to do.
And didn't you tell them that you didn't make any calls that night or that morning?
No, sir, I didn't tell them I hadn't made no phone calls because I had made phone calls.
All right.
You have anything else, Counselor?
Not for Mr. Smith, no.
Okay, you can stand down.
Your Honor, please.
You have another witness?
I have.
Wait a sec. All right.
I do. I filed a motion yesterday. I e-filed a motion in writing rather than just waiting to do it verbally to allow a witness to testify remotely today. It's Jessica Shoemaker, who was previously an investigator with the Department of Public Advocacy. She is no longer employed by DPA and she lives out of state now. She is available to testify either by Zoom or by telephone.
What do y'all have to say about that?
I would think that would be the ruling for the court, John.
I know, but I want to hear what you have to say about it.
Well, I'm not particularly happy about it.
Okay. Well, is she online now?
I can get her on, she's waiting by her phone for me
Can you
to.
give her a Zoom link?
I can give her a Zoom link if the court gives it to me.
Come up here. Get the Zoom link.
I was in a email address.
You got your CD handy?
We don't have more times a civil. We have a civil document. No, I get it. We have a civil document. What times is it? Do we have anything else this morning?
Show cause.
Yeah. Anybody here for show cause? Still. Let's go off the record.
They want to move.
Is this lady an attorney?
She is an investigator. She's a private investigator now. She was previously employed by the Department of Public
She
Advocacy.
wasn't employed as an attorney.
No, she's
She's an investigator.
she's an investigator. There, she's on there now.
Okay.
Is it best for me to stay here to do questioning of her, or is there somewhere else I
I'd
should
say it
go?
would be better he came to the podium. You want to call your next witness, please?
Thank you, Judge. I called Jessica Shoemaker.
Are you Jessica Shoemaker?
Yes, sir.
Raise your right hand, please. Swear the testimony that gives the truth, the whole truth, and nothing but the truth.
Yes, sir.
What's your name?
Jessica Shoemaker.
May proceed.
Thank you. Ms. Shoemaker, can you tell us where you're employed now?
Yes, I am employed with Inquisitor Inc., investigation firm out of Memphis, Tennessee.
Okay, and what do you do for them?
I am criminal defense investigator. I do fact investigation and mitigation investigation.
Okay, and we are here today on the case of Commonwealth versus John Smith. And you have some knowledge about that case, is that correct?
Yes.
How did you come to have knowledge about that case? What has your involvement been?
When this case was going on, the trial, I worked for the Capital Trial Branch of the Department of Public Advocacy in Kentucky. And one of the attorneys there was Mike Buffkin, and he brought me in to help with the case when funding ran out for the Chapter 31 fact investigator.
Okay, so there had previously been an outside of the agency investigator who was working on the case?
Yes.
And do you recall who that was?
Josephine, I can't remember her last name.
Josephine Guy, does that sound?
Yes, Josephine Guy, yes.
And you said that funding ran out for her. Can you explain that just a little bit?
I'll be honest with you, I don't know that much about it other than for whatever reason she couldn't continue to work because she didn't have funding. And so my boss at the time was Joanne Lynch, and she asked me to help Mike with the case to finish up subpoenas and things like that, last minute things that needed to be done.
Okay. So as part of your work on the case, were you told by anyone involved in the case about a potential alibi defense that Mr. Smith had?
Objection to anyone, Your Honor.
Okay. Were you told that there was a potential alibi defense?
By saying objection.
Overrule. If she was told by anyone, she needs to state their name. What? Could you name any person that gave you any information concerning the lack of the alibi defense?
So I'll be honest with you that I don't remember exactly who told me.
No, wait, no.
Okay.
Okay. As part of your duties on this case, did you investigate a potential alibi defense?
Yes. I was asked to interview Loretta Walker.
And what was the substance what were you trying to find out from Ms. Walker?
Well, when I interviewed her, I was asking her about phone calls that she made with John Smith at the time of the offense.
Okay,
I object to this as hearsay, Your Honor.
Judge, it's not offered for the truth of the matter asserted. Ms. Shoemaker is testifying about actions that she took during her work on the case.
Who did she say that to her? Who told,
Ms. Walker, Loretta Walker.
where is Loretta Walker? Is she gonna testify?
She is not. But again, this is not offered for the truth of the matter asserted of any of the statements of Ms. Walker. This is simply offered to show that Ms. Shoemaker conducted investigation into this issue.
Go ahead.
Ms. Shoemaker, did you, as the investigator assigned to work on the case, did you believe that there,
Her beliefs, Your Honor.
if I could finish the question and then maybe you can object to it.
Let her finish the question.
Did you believe that Ms. Walker had relevant testimony?
Yes.
Did you at any time make any effort to secure Ms. Walker's testimony in court?
Yes. The first time that I interviewed her, I served her with a subpoena because I believed that her testimony would be relevant to the case.
Okay.
When the trial date changed, I gave her a new subpoena for the correct trial date so that she would come to testify during the trial.
And did Ms. Walker appear in court?
No.
Are you aware of any efforts that were made to, any further efforts that were made to secure Ms. Walker's testimony?
No.
Were you asked to go find her or do anything else to get her to court?
No.
I have nothing further, Ms. Shoemaker. I believe that the Commonwealth will likely have questions for you. Thank you.
Give us a moment, Your Honor.
You may have a moment.
Ms. Shoemaker, did you file any kind of written reports to anyone on your efforts with Loretta Walker?
I gave them to the attorneys. The defense attorneys that I was working for, I gave them a memo about my interactions with her.
Do you maintain those records yourself?
Yes, sir. When I left the public defender's office, I saved a copy of those files. So I have a copy of it.
But we don't have it here today.
No, sir.
Have you made it available to Ms. Lewis?
Yes, I emailed her a copy of my memo.
Did you make any effort to find Loretta Walker and bring her in?
Not the day of the trial that I can recall. I'll put it that way.
Well, put it in another way. When did you make any effort to bring her in?
Well, when I served her with subpoenas, those were my efforts to bring her in. And my understanding was that that would require her to be in court. And so on the day that she didn't appear, I assumed that she would be ordered to come in by the court, but as far as I know, that didn't happen.
Do you recall if you filed with the clerk proof of service of these subpoenas?
I do not recall.
Thank you.
I have nothing further.
May this witness be excused? You
Yes.
may be excused. Thank you for your attendance.
Thank you.
Thank you, Ms. Shoemaker.
Thank you.
You have another witness,
I would call Attorney Mike Buffkin.
Mr. Buffkin. You raise your right hand, you swear the testimony about to give us the truth, the whole truth, and nothing but the truth.
I do so, Your Honor.
Take a seat there and state your name.
Can you state your name for the record?
Yes, my name is Michael Joseph Buffkin.
And Mr. Buffkin, what was your involvement in the case against Mr. Smith?
I was one of the defense attorneys.
And were you employed privately by Mr. Smith or by the Department of Public Advocacy?
I was employed by the Department of Public Advocacy.
Were there other people on your team?
Yes, an attorney, Sandra Downs. Jessica Shoemaker was an investigator. Another investigator was Josephine Guy. And then, of course, we had support staff who I don't really remember their names, but there were people who also helped out with the case.
And I'm sure, Mr. Buffkin, that this is a voluminous case. It was a multi-day
Right.
trial, but we're limited to one issue. So,
Yes, ma'am.
And that you've heard that issue is the potential alibi defense.
That's my understanding, yes.
Do you recall being informed of a potential alibi defense?
I'm not honestly sure. However, I know that a Loretta Decker, and I thought her last name was Wallace, but I could be mistaken about it, but that Loretta Decker was subpoenaed to be brought in. I also know that I made an investigative request to Joe Guy to contact Loretta Decker and get a statement from her. And I presume I was asking her to follow up on what Mr. Smith had told us.
Do you, if you remember, because I know it's been a while, do you remember if you intended for Ms. Walker to testify?
I would not have issued a subpoena if I had not intended to call her as a witness. I may have subpoenaed her as a standby witness. I've done that before, where I've called somebody in, but then found either that I didn't think it was necessary to call them, or I determined somehow that it wasn't good to call them, but, for a variety of reasons. But the whole purpose of the subpoena was to bring her in.
And would Ms. Shoemaker or any other investigator working for you, would they have issued a subpoena that you didn't tell them to do?
No, I think they would have done exactly what I asked them to do.
So if a subpoena was issued, it was at your direction or another attorney?
That's correct. That's correct. It would be either myself or Ms. Downs. Subpoenas have the attorney's names on it, so ones that I had issued would have my name on them, and others might have had Sandra Downs' name on them.
Now, in general, if you subpoena a witness to court and they don't appear, do you have any recourse there? Is there any
Yes.
way? What would that generally be?
Ask the judge to send sheriffs out to get them.
Do you recall if that happened with Miss Decker or Miss Walker? I have Loretta Decker Walker is the name I have.
In all honesty, I don't know if that was done or not, but I know that anytime I've ever had a subpoenaed witness, for an evidentiary hearing or a trial and they didn't show up and I wanted them there, I would have told the judge and requested that the judge get the sheriffs to go see if they could find them. That's been my practice for a very, very long time.
Do you recall making a decision that you did not want Ms. Walker to testify?
No, I don't recall making that decision.
Do you recall if you at some point decided that her testimony was not needed?
That's difficult for me to answer because honestly, I'd have to go thoroughly through the file, but I can tell you a little bit about what I did in that kind of, in regards to that.
Okay.
We subpoenaed cell phone records. We subpoenaed landline records. And if we had a particular time that we were trying to pinpoint, we would cross-reference that with the different records that we would have. In addition, there's a process, what's known as triangulation. But that usually involves anywhere from 3 to 4 cell towers in which the radio signals are bouncing off towers. Sometimes a cell phone radio wave will bounce off one tower and then the person goes a mile and bounces off a different tower. So it gets to be a little hairy, I would say, with cell phones to determine location. It's not like a landline where a landline has a physical address attached to it, and that's where it is. That's where it always has been, unless the phone company takes it out. So it's a little more dicey when it comes to cell phones. But yeah, there is a process, and I'm not a scientist, so I don't think I can exactly explain exactly how it works, but I think it has to do with the radio waves intersecting and being able to determine where that location is. So, and then of course, times, you look for time stamps as to when those calls may have occurred, because if it was a phone call from last month, it might not have any relevance at all.
And you heard Mr. Smith's testimony that he testified he was at a physical home and made calls from a landline
Right.
during the time period in question. Do you have any recollection of attempting to get those records from the phone records from that landline?
My recollection, and of course, the court file and the trial video would be the ultimate answer to that, I think. But I looked for landline records, I looked for cell records, and I think there were actually even 2 different cell companies. So I had records from 3 different phone sources.
But you don't recall if you specifically had the landline records from that home during that time?
Are you talking about the home of Chastity Hagen?
Yes, and her mother.
I believe we got records from Hagen, but it may have been her mother's address. I think her mother was Wanda, if memory serves me correct. I think her name was Wanda, and that may have been the landline records that we got would have been under the name Wanda Hagen rather than Chastity Hagen. I think Chastity Hagen had a cell phone.
Would it sound unusual to you if you learned that the landline records had been unavailable by the time they were asked for?
Would it be unusual?
Yes. Does that ring a bell to you?
Well, my experience with phone records is that again is something that can be a little bit spotty. Because sometimes you try and get records and are told that they were destroyed. In which case I would try and get somebody to testify to that fact. And I don't know, I don't recall whether that occurred. I don't believe that that occurred. But I think if a landline was involved, it was probably the one for either Chastity Hagan or Wanda Hagan.
I don't believe I have anything further.
A moment, Your Honor.
Okay.
Wait. Mr. Buckin, I realize that it's been several years since all of this occurred. Do you recall during your preparation for the trial, going over the interrogation that was recorded by the officers and Mr. Smith on the day after the killing?
That was my usual practice was to go since you shouldn't be looking at them. So that's my usual practice, and I believe I've followed my usual practice in that regard.
Are you able now to recall any specifics in that interview that related to telephone calls?
I don't recall any specific statements that were made in regards to telephone calls. And I'm not sure who you're saying. Are you referring to statements by Mr. Smith or the detectives?
Yes, sir.
No, I don't recall.
All right, thank you.
Do you have any redirect?
I do not.
He'd be excused. Would you like his presence to remain present in case something else comes up during the hearing?
As far as I'm concerned, he can be excused, but he's not under my subpoena, so.
May be excused.
I would like Mr. Button to be subject to recall as well as.
May stay subject to recall, Mr. Bowden. He may stand down.
I'll stay and take a seat in the gallery if that's okay, Your Honor.
Fine. Want to call you Call your next witness.
No further witnesses for the defense.
They've announced closed. Do you have witnesses?
I call Russell Decker.
You may stand down.
Thank you very much, Your Honor.
Russell Deckard. Raise your right hand, please. You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I did.
Have a seat. State your name, please.
Russell Decker.
You may inquire.
Mr. Decker, what is your profession or what was your profession back in 2012?
I was a detective assigned to Post 15 in Columbia.
And were you one of the officers that was assigned to investigate the killing of Brenda Howard?
I was, along with Detective Ricky Brooks, who's now deceased.
Do you recall an interview that you and Detective Brooks had with John Smith on the next morning following the murder of Mrs. Howard?
Yes, sir.
Have you had the occasion recently, this morning, for instance, to have listened to that?
I listened to portions of it this morning. Yes, sir.
From what you heard, is that an accurate recording of the interrogations that occurred that morning between you two detectives and Mr. Smith?
Yes, sir.
Were there portions of that interrogation that related to telephone call?
Yes, sir.
Who was the officer mainly talking to him about that?
Most of the time it was myself.
Did you hear that part of the interrogation played this morning?
Yes, sir, I did.
And from what you heard, is it a true and authentic recording of what actually occurred?
Yes, sir.
Now, Amber, Judge, I want to play a portion of the recording.
Okay, that objection's ordered, been authenticated.
I'm sorry, Judge, I didn't hear what.
I
what you
said, without objection, I'll allow it to be played. He has authenticated it. He's listened to it. He was there, was present.
Judge, I don't necessarily object to the claim, but I would object that, I have been very careful to stay within the confines of the issue that the Court of Appeals sent back for this hearing. And that issue is specifically what was told to Mr. Smith's attorneys. So I think we are getting far afield from that in discussing what he told the police.
This will relate to telephone calls, right?
But it won't
You're
relate
saying
to
that we
what he
should
told
not
his
get
attorneys.
into the validity of what he told his attorneys, but just whether he told his attorneys this or not. Is that what you're saying?
The validity may be relevant, but whether he made these statements to the police are not relevant. And that's a fine distinction, I know, but it seems that Mr. Hunley is going, maybe I'm incorrect, but it seems like he is going towards it being an issue whether Mr. Smith gave all of his potential defenses to the police. And that is not the issue. The issue is what he told his attorneys.
But it's please, it would be a statement that would contradict Mr. Smith's testimony here today.
I'm going to listen to it, see what it says. Go ahead.
All right, and start at 32, I believe. Then I'll tell you when to stop.
Hello? Where are we on this?
I don't know, Your Honor. My technology skills don't go this far.
He had went to sleep and it's taken forever to recognize it.
Let's go off the record until the technology gets adjusted here.
You do?
They playing, I don't know where this ended.
Press on the fact to try to get title on.
Okay,
Remember the guy thing? Puts that car there, puts him there.
Oh, the neighbor, yeah.
Yeah.
okay.
not
You wanna stop it now? Stop.
Why?
Is that what you want to get on the record there?
Yeah.
Okay, let's go back on the record. Turn that volume up, please. We're on the record now. Let me proceed.
Mary's house yesterday, I did not go down there. I went two places yesterday. I went to Cash Express in Lafayette to try to get title on, and I went back
Well, that's
home.
not exactly true. Of course, do you have a
Yes,
cell
sir.
phone?
Chastity's.
Did you have it on you?
Yeah, I had it on me this morning.
When they arrested you?
They arrested you this morning?
Yeah.
Okay. Cause then I'll tell you what we're gonna do on that. These little cell phones, and I've got one back there.
Sir.
Hold on. Every place that phone goes, it's looking for a tower. It's called
Yes,
ping.
sir. Hello.
Well, if I take in that area, there's 2 cell phone towers or 3. I don't remember which it is. It doesn't matter. If your phone is in this area, if that lady's trailer is right here, and your phone is here, it's going to hit that cell tower. Well, it's going to tell me he is within this amount of degrees. That phone. Now listen. There's your trailer. There's your cell tower, and that may not be exactly where the cell tower is at. We're just using this for an illustration. But when that phone pings, it'll say, this is the closest tower, and this is at this degrees at this time. Okay? If you move and drive over here, well, then this cell tower will say, well, at this time he was here. And if you drove around that cell tower, it'll say 2 or 3 minutes later, say, well, he's over here. And actually, I track people with these cell phones as long as they're on. Track them all the way to Colorado on a dope deal.
I understand that.
So, you said you had a cell phone. So now I got.
I had that cell phone this morning.
You said you had a cell phone. It's on the
I said
tape.
I had the cell phone this morning, sir.
Well, I'm going to put that cell phone there. And that's it. That's
cell phone. Chastity had her cell phone yesterday.
Yeah, and Chastity had it when you and her went in there and beat that old woman to death, too.
Sir.
How about the phone call you made to her daughter?
I'd like to talk to her dog. No.
And you know her family because you.
You called it private.
No,
Try to lay it
sir.
off on another girl.
Yeah.
No, sir.
Yeah, and when I get those cell phone records later on this afternoon, I'm going to be able to prove that. Even though you blocked that number, it's still going to show up. So, and then I'm going to do a voice line up with you, and then that lady, the daughter, is going to ID your voice, and then that's the nail in the coffin, young man. That is the nail in the coffin.
Your Honor,
I can't sit here and tell you I was down there yesterday when I wasn't.
Your Honor, now I need Ms. Vanderpool to go to hour 1, 17 minutes and 30 seconds. 30 seconds.
Still don't know what's wrong or what happened.
It is. And I never bothered that one. I've never bothered that one. You know, and, I want to do 2 or 3 years, sitting there in a stinking ass jail for something I did not do. Something I did not do. And I don't expect you to believe that for 1 minute. Because you got your mind made up. And it ain't about the evidence, whatever, you know, you can call it anything you want. But I'm telling you right now, I'm gonna do 2 or 3 years in jail before I go to trial. Did not do. Sure will. And buddy, if I know who.
Did you make any calls on that cell phone list?
No, sure.
You never made one call on it. You had it in your pocket, did you?
This morning I got it. So
Take
Chastity,
away.
no, Chastity was gone and I, you know, I done had it in my pocket when she come in. And I didn't think nothing about giving it back to her, so.
You know Melinda Webb?
That's one I don't talk to. That's Chastity's phone call.
Well, those two conversations about the telephone call, and they're talking about Chastity's phone, is that correct?
I believe so, yes, sir.
And he said that Chastity had the phone all day yesterday, but he had it this morning. That's correct.
I believe so.
And that he didn't make any calls on that phone yesterday. That would have been the day of the murder.
Correct.
But that the phone was in his pocket. He had it all along. Chastity didn't have it.
Correct.
Yeah.
Objection, Your Honor. That's not what I heard on that tape.
Well, I'm a little confused my own self here. Now, let me ask you some questions just for my edification.
Me?
Yeah.
Yes.
Your theory is that Mr. Smith said that he made phone calls from a landline to Chastity's phone. That's what he wanted investigated, correct?
That's one of the things. Most of what I was presenting testimony today about of other people was that he made calls from the landline to Loretta Walker.
That's what I just asked you.
You said Chastity Hagan.
Well, so were these other phone calls that you alleged made from a landline? We're talking about a window of opportunity when he says that he has an alibi because the crime was being committed there and he was at a place where he was making calls from a landline.
Correct.
At that time period.
Correct.
Who does he allege that did he tell him he was making phone calls to? Was one of them to Chastity Hagan?
I believe there was his testimony today was that there were calls to Chastity Hagan.
So this is relevant here as to whether or not he had Chastity Hagan's cell phone at a time period when he was saying he was making a call from a landline to that cell phone.
That's exactly
Well,
right.
I'm just trying to
Well, Judge,
understand this. I'm just trying to understand. I'm not saying
I'm just trying to answer your question.
okay, well, I won't interrupt you then.
I mean, relevance is a very low standard. So is it relevant? I guess, but the fact that there are calls coming into a cell phone doesn't tell us where those or who made those calls.
I kind of understand that.
So the point.
Let me ask you, I'm trying just to get some context here. Okay, just some context. It's hard for me. It was hard for me to follow what that said. And then I don't know whether I agree with what the witness said, that it said what he was asked. He responded to the question. But for context here, the calls that your clients depended on to establish his location were made from a site that had a fixed landline.
Correct.
And that's his alibi.
Correct.
Okay. And there were phone calls made to two different people.
Correct.
One of them was Chastity Hagan.
Correct.
But this testimony that your client stated is that he had Chassie Hagan's phone during that time period.
That he just stated there.
Yeah, that's what I understood.
What I heard him say multiple times was that he had that phone on his person the morning of his arrest.
Well, I heard
which
that
is the
portion of it
next
too,
day.
but
And he also very clearly said she had her phone yesterday.
I
which is the day in
didn't hear it
question.
like that. I thought he said he gave it back to her is what I thought.
That morning.
Well, he had
Or
to
no,
have
I'm
that.
sorry, he
That's
said that he
right. That's what I
didn't-
thought
he
he
said he
said.
didn't
Let's
give it
play it
back to her.
again. Let's play that again.
Let's see, no, this one, I think. This portion.
Okay. But you know, it is what it is. And I'll never bother that one. I've never bothered that one,
Turn it up if you
you
can.
know. And I want to do 2 or 3 years, sitting there in this stinking ass jail for something I did not do. Something I did not do. And I don't expect you to believe that for 1 minute. Because you got your mind made up. And it ain't about the evidence, whatever, you know, you can call it anything you want. But I'm telling you right now, I'm gonna do 2 or 3 years in jail before I go to trial. Something I did not do. Sure will. And buddy, if I know who. Did you make any calls on that cell phone yesterday? No, sure. You never made one call on it. You had it in your pocket. This morning, I got it. So Chastity, no, Chastity was gone and I, you know, I done had it in my pocket when she come in. And I ain't thinking nothing about giving it back to her, so. You know Melinda Webb? That's one I don't talk to. That's Chastity's phone call. You know her? Yeah, I know her. Know her. Cause my kid's mama, that's her first cousin. Okay. You know a, Willie Strode?
You won't hear the second call, Judge.
Judge, I'd like to point out that what I heard him say there was he was asked, did you make calls from that phone? And he said, no. And they said, you said you had it. And he said, this morning.
I heard him say he gave it back to her. Let's play it again.
Judge, I don't know how else to.
Well, maybe I'm too thick to understand what you're telling me here, but I'm hearing what I'm hearing here. He said that he didn't make any phone calls on that cell phone, but you've never alleged that he made any phone calls. You're making the allegation. He made the allegation that he made phone calls from a landline to that cell phone.
Yes.
So what I'm trying to determine is when he had that cell phone. We know he had it on him that morning. The day that he was arrested, he had the cell phone on him. We've established that. I'm trying to listen, anytime there's these interrogations, there's these interruptions, with the interrogation techniques and things. I want to play just that portion of it to say when she had the cell phone and when he gave it back to her. Now I'm thinking I'm hearing something like that. Play it one more time. I don't want it from the beginning, just that portion of it.
Sure will. And buddy, if I know who. Did you make any calls on that cell phone yesterday? No, sure. You never made one call on it. You had it in your pocket. This morning, I got it. So Chastity, no, Chastity was gone and I you know, I done had it in my pocket when she come in, and I didn't think nothing about giving it back to her, so.
You know, Melinda,
Okay, stop it right there.
That's one
Stop
of
it
them.
right there. Okay, now what I heard him say, that when she came back in that morning, he already had it in his pocket and he was thinking about giving it back to her. Did you hear that?
Judge,
Did you hear that? I'm just asking you if you heard that.
yes, but the
Okay,
way
well, I'm
I
gonna give you,
hear it is
I'm
that
gonna
that
give
is
you,
all
wait just a second. I'm gonna give you plenty of time. Don't act so frustrated. I'm gonna give you plenty of time to explain it. I'm just asking if we heard the same thing. Okay, did you hear that?
Yes, but that
Okay,
is
now
not
you
the
can explain
complete-
it. Now go ahead.
Judge, he says what you said, yes, but he also seconds before that said this morning, and then everything he says after that relates to this morning.
Okay. Y'all have anything to say about it?
I heard what I heard, Your Honor.
What did you hear?
First call. He said I had the phone call, I had the phone this morning, that's the day after Miss Howard was killed. Then he said Chastity had the phone yesterday. Then the next question was, did you make any phone calls? No, I sure didn't. Sure did not yesterday. The phone was in my pocket. I had forgot about it.
Okay, go ahead. You want to ask this witness any more questions?
No, Your Honor.
Would you like to inquire of the witness?
Yes, thank you. Sir, who employed you at this time?
Kentucky State Police.
Okay, so were you at any time working for the defense?
Oh, sir.
Okay.
No, ma'am.
Ma'am.
I'm sorry.
So it
I
was not
apologize.
your, what, or maybe it was it your job to prepare a defense for Mr. Smith?
I was just there to present the facts to the Commonwealth Attorney's Office.
Okay, was it your job to develop defense strategy for Mr. Smith?
There again, I was just to develop the evidence and report
So
the
that's
evidence. That's no.
Were you privy to conversations about defense strategy?
No.
Did you ever discuss defense strategy with Mr. Smith's attorneys?
No.
Nothing further.
We may have one other thing, but I need a few minutes.
Okay, let's take a brief break. This is a bathroom break. Mr. Smith, if you need to use the restroom or everything, you just tell those people and they'll make an opportunity for it. So we'll take a 10-minute break. Let's go off the record.
That's all I do. I'll bet more out of the house.
Feel bad. I've been everywhere, yeah. That would be. No, I think I can hear it.
Like I would speak so bad. I think it's just kind of the same. Oh, you can come back, like something really will even about, you know, that's like 30 more minutes. Yeah, already, because I'm not being crazy. Yeah, that's so big. My stepdaughter was that's fine. Let's go back.
Thank you all. Be very supportive.
Hey, we bring them, put them in the car. I really need that one. I really do. There you go. I'm up there. Honestly. Yeah, you know. All right, we're gonna get it. I really do. I do need. I want to go. Very cool. Regulations. Now, I'd say good luck to the eyes.
Thank you for being here.
Oh, I'm glad.
I'm glad they were able to find the file yesterday.
What?
I'm glad they found the file yesterday.
Oh, they did. They did. It was very helpful because my memory's not as great as it used to be, so. But a lot of it came back to me, and sometimes I won't see where. Anyway, where they have you now? North, yeah, you've been there for a while. Well, listen, good luck. I gotta try to tell you it as easy as you can. But it's tough. It's real tough.
Unsafe drive fast.
What's that?
So drive safe.
Yeah, I'm gonna stick around in case somebody calls.
Okay.
I'm down in there. I want to slow. See, one more homeowner knows I did not done this. So I always thought that, but then it's this morning, I think something there, but I'm playing court. So. Today's Saturday. I'm saying sorry. You need me back too. Some 7 o'clock. She said, "John, come on, let's go." You should have said that. It's next time. What's up? Nice. Oh, you mean birds on there? What's back to our barn today? You don't know, you turn down the road there. I think that's what I'm going.
I'd like to, I'm gonna get across to get the big shots. I think
Still say, cut Russell loose and I'll leave. I will.
You can go get mine and hit me at the end of that.
I can,
Throw it in the window.
I can buy for it. And get me out of here. But I mean, I want to be in my truck by 12:30. That's 9 minutes. You gonna do that?
I'd like to be there too.
Say, like Melinda or Linda? Say what? Is your name Melinda or Linda? Open. Come up here. Yeah, like, is it Melinda or Linda? Who's Melinda Webb? That her? No, no, that's another person. It's what? That's another person. Okay. Okay, Loretta.
Where did Mr. Buffett go?
Derek Michael's going to get him.
Oh,
They married.
Okay, y'all ready to go back on the record?
Yes, Your Honor.
Okay, let's go back on the record. We've had a short break by way of explanation. We had a short break in the Commonwealth asked. And Mr. Decker, are you still on, is he still on the stand?
No.
Yeah.
I'm,
Are you gonna call somebody else?
yes, I'm gonna recall Michael Buck.
Okay,
Am I free to go?
I don't know.
Okay, am I free to go?
I hope, yes, go ahead. Get on your out, man.
No, Jack.
Okay, you may be released. Thank you.
Thank you, Russell.
Mr. Buck, you realize you're still under oath?
Yes, Your Honor, I do.
Go ahead.
Mr. Buckin, based upon your recall and perhaps some that's been jogged here today, did you investigate or cause to be investigated the potential alibi issue presented to you?
I can tell you what I did. And I want to try and avoid any hearsay, but I instructed Josephine Guy to contact Loretta Decker and to interview Ms. Decker. Is that what you wanted to find out?
That's that would be part of an investigation process, would it not be?
What would that entail? Is that what you're asking?
Did you investigate or cause an investigation to be made on the alibi issue? The answer would be
yes.
Yeah. From the information provided to you as a result of the investigative process or efforts, if it had established an alibi for the defendant, would you have used it?
Yes.
Did you, Mr. Buckin, kind of a summary question, did you see anything from the phone records or the investigative reports furnished to you that would have established an alibi?
Well, I want to make sure my answer is clear, but I think I would have to preface my answer by saying that phone records in and of themselves don't say where a particular person was at a particular time it is records of telephone calls and different people can use the same phones. Do you understand what I'm saying?
Yes.
So I think it's difficult for me. I think particularly because of my profession, to come to a conclusion that I can't say that there's evidence to make it possible to come to that kind of a conclusion.
Well, we have established that you did institute or cause an investigation to be made.
Yes.
Based
Let,
on,
let me ask the question here too. Get these. Was Loretta Decker, she was subpoenaed, right?
Yes, Your Honor.
She was subpoenaed, and when the trial didn't go, you subpoenaed her the second time.
I don't know. I'm
I
sure
thought
I
that's
would
what-
have, but I don't know
Yeah.
for sure, for
And
a fact.
she
Yes.
she didn't show up for the trial.
No, she did not.
And you didn't ask for continuance because she didn't show up.
I don't know if I did or not.
You
I
have no
don't recall.
recollection of that.
I don't recall whether I asked for
And,
continuance.
but I think you
based
previously
upon that.
testified that if she hadn't had known something of relevance, you wouldn't have had her subpoenaed. Did you
Yes,
say
Your Honor.
that? And if you had her subpoenaed, and for whatever reason, do you remember the reason you decided to go on with the trial with her not being here?
I'm trying to recollect my thought processes for a moment, Judge. I don't want to
If you don't remember, you don't remember.
I don't remember.
Okay.
Would be
Okay,
the
y'all
best
can
answer.
continue. I just want to get that.
I have no further questions.
Do you have any inquiry of him?
I don't believe so, Judge. After your follow-up questions, I don't believe I have anything. further.
Okay, now, who is the other, so I can maybe ask him one other question. Who was the other landline call? One of them was the name, who was the other landline call?
There was one, two, well, I think more than one, to Loretta Decker Walker,
Yes,
and at least one, if not more, to Chastity Hagan.
yeah. Were those the only two individuals that you were interested in?
Yes.
Okay. Okay, thank you very much. Can he stand down? Do you have any other questions you'd like to ask him?
I do not.
Okay, you may stand down, but remain
Thank you, Your
present. Yeah. Anybody else have another witness they'd like to call?
I do not, Your Honor.
No,
Or
Your Honor.
anybody else?
No, Your Honor.
Would you like to announce closed?
Yes.
Now, do you believe you get to make the last argument in this?
Yes.
I believe you do too.
It's so opposite of a trial, I have to stop and think, but
Yeah,
yes.
I've suffered that myself as a defense lawyer down through the years. Okay, would y'all like to make a statement?
Judge, would the court prefer, we've done it both ways. I guess more frequently we do written,
I'm gonna ask for both,
Okay.
but
that's
I'd
fine.
like to see, while it's still fresh on my mind and we're on the record here. Do y'all have a closing, or you want to just depend upon a written submission?
I'll say a word, Your Honor.
I thought as much.
I promise you.
Yeah.
The real issue
Why don't you come around here where I can hear you?
The real issue in this case is whether Mr. Bupkin and the attorneys for the defense made any kind of investigation. The proof here today shows, yes, they did make an investigation. Now, the last questions that I asked Mr. Bupkin is that based upon what he found from his investigators and what he learned, would he have used that? Could he have used that to establish an alibi? It was his judgment then and now, no, that it would not. And it's basically that simple.
Okay, thank you. Would you like to?
Yes. Do you want me to come up there, Judge?
Sure.
Judge, I do agree that the issue is really simple. I don't think I agree with Mr. Hunley on what the issue is, though.
That doesn't mean it's not difficult. Even some simple issues are difficult, aren't they?
Yes, yes. The issue is not whether there was an investigation. The issue is whether there was a defense provided to Mr. Smith that meets the professional standards, and whether if it didn't meet those professional standards, whether it caused prejudice to Mr. Smith. So that's what the issue is, which I guess I'll retract my statement, is not quite as simple as what Mr. Hunley characterized it as. I think it is clear from the testimony that there was an investigation, that we've heard about it being directed to happen, and we've heard some about it actually happening from the investigator who testified. But we've also heard that there were steps taken to present the results of that investigation to the jury at trial, but then that it was ultimately not presented to the jury. That Ms. Decker Walker was not present in court, and that there were no efforts made to secure her presence and her testimony in court for the trial.
And Ms. Hagan was present. She testified.
Yes, and Judge, I was focusing more, and have been focusing pursuant to the briefs that were filed previously before I was on the case, on the call to Ms. Decker Walker. I believe that is Mr. Smith's contention that there were calls made to Ms. Hagan. That's a very different issue, especially since she was at some point a co-defendant in the case,
And these calls were made from her mother's. The stationary phone you're talking about.
Correct.
Is her mother's.
Yes.
And he was at and he's saying kinda that he was at the mother's house and used that stationary phone to call Chassie Hagan and Loretta Decker.
Exactly.
And, okay. Well, it took me a while, and the mother's name is Melinda.
Wanda Hagan, yeah.
Wanda Hagan, yeah.
Who was dead before the trial.
I remember her being dead, yeah.
And Judge, I do think it's important to very carefully consider Mr. Buffkin's testimony. It is always the case when an attorney is testifying about a case that happened years ago, as they always are in post-conviction. There are two different things. This is what I precisely remember happening in this case, and this is what I can say my normal practice.
I'm very well aware of
So I
forgetting
just
things
want
that
to-
happened 50 years ago, or 40 years ago, or 10 years ago, or last year, because the things are not as significant to you after you've finished with a case as the case you're working on now or your next case. Okay, I understand that. I'm sure all of us that practice over a period of time have somebody, you remember that will you wrote for me and Mama. And I'll say, well, when was that? Well, that's right after she got out of the hospital. We all experience that sort of thing. But I appreciate your argument. It appears to me the 1142 hinges upon whether or not a valid alibi or an alibi allegation made by the appellant was either ignored or not properly investigated or wasn't presented. And I'm going to allow you to brief this, but let me tell you where I am right now, kind of in my mind, the reason I was asking for some of the questions. It appears to me, and I might have heard that thing wrong, but it appears to me that on the morning that Chassie Hagan came back in, that the appellant had her phone. And that he had her phone. Now, you think that it says that she handed the phone to him that day, or he got the phone that day, which was the day after the shooting took place. Well, if he had it already in his pocket, I don't know where he got it. Did she give it to, and he said he'd forgotten it was there. It appears to me that he might have, as I hear, that he had her phone all along and forgot to give it back to her. If that's the case, he couldn't have made a phone call from the stationary location if he was there because he had the phone. Now that's where, and so I want you to focus on, I'm giving you warning when you, the other thing that appears to me is if he had, as far as this Loretta Decker or whatever, there was an investigation done evidently on why a phone call was made to her from that stationary line. And she was subpoenaed, and Mr. Buffkin said he wouldn't have subpoenaed unless he thought she had some relevant statements made like that. But I'm a pretty experienced criminal defense lawyer, and I get in trials sometimes. And sometimes I've tried the case. I've tried some cases twice, if I was lucky enough, if I lost it the first time. And sometimes you decide and make decisions on why you don't call people. You hear something at the trial or whatever, and you know you've done the investigation and there's something relevant, and your investigator said there was something relevant. She didn't exactly say what it was, the previous investigator. So it appears to me that that someone knew that there was something relevant. If it wasn't about this phone call made from the stationary line, I don't know what else it could have been about. So for whatever reason, Mr. Buffkin decided that when she didn't show up that day under subpoena, that her presence was not necessary, or maybe it wasn't going to be ethical to present the testimony. And he didn't ask for a continuance, and he didn't call her. So that's kind of where I am right now. If you're depending on these two phone calls from a stationary line, one of the individuals was present and was subject to cross-examination, and it would appear to me that if in the appellant's mind, Mr. Smith, that he had called her on a stationary line, somebody could have said, at such and so day on this date, did I not call you on this stationary line? And evidently it wasn't thought that that was relevant, and I would imagine that they could have found out where that cell phone was when the call was made from the stationary line. It would have pinged somewhere. So, I'm leaning to believe that there could have been, and actually was, an investigation made, and there could have been, lost in time, relevant reasons why a experienced defense attorney, and I saw Mr. Buffkin try this case, and I saw all the motions that he made, and in my opinion, he was very thorough. And so that's the way I'm leaning. You might convince me otherwise in this brief that you have. And the other thing about the brief is I don't interrupt you when you write the brief. So it won't take you. Well, thank y'all very much for presenting this thing, and I'll take it under advisement. And I've got this sign right here for you to say, and it says on their officer that I just took it under advisement. Okay. Thank y'all very much. This concludes the session.
I'm sorry, does the court have a day that?
30 days enough. 30 days, and then if I want y'all to come back to argue, I'll schedule it. And y'all get I'll just let them respond. You do 30 days, and Turn that over. Okay. Stinson versus Graves. Turn that over. You go? Good. Anything else I need to know?
The only thing I bring up is that, there was an adoption that I wasn't aware that was on the thing or so you don't know that, so you won't have the document, but it'll be a brief file.
Okay, thank you. Okay, what do we have here? Motion for visitation. We got Danny, Joe, Stinson, and Mackenzie. Right, okay.
It's my motion, Judge. Yeah, this case, there was,
Could you identify the folks? Is this your client? Who are you?
yeah, this is my client. I'm not sure if it is.
I'm Danny Joe Stinson, Your Honor.
Okay.
And what's your involvement in this?
I am the,
He's one of the
custodian.
petitioners.
Levi Garrett.
Okay. And what do you have here?
Judge, it's pretty straightforward. We're just asking for a hearing. The parties all agreed a few years ago to name the Stinsons de facto custodians of the minor child.
How old is the child now?
He's 6-year-old.
And in that agreement, it was that the visitation with the parents would be as agreed with the petitioners. And that worked well up until very recently. Very recently, there's been, I believe, a breakdown and my client's not getting contact with the child.
When you want to set a hearing for?
As soon as possible, Judge. I mean, I think
Well,
it's
know,
pretty
we
straightforward.
could have had one today.
Well, I know, Miss Stinson called my office yesterday.
Are you gonna have an attorney?
Your Honor, I would like to request a continuance here today.
I'm asking you if you're gonna get an attorney.
Yes, sir.
Okay, so let's schedule the hearing. I'm gonna wait till the next rule day.
Okay.
Which is, at like let's say 1:15 on June the 12th. That give you time.
I do have a few extenuating circumstances. I think my father-in-law is in Nashville at the moment battling cancer.
Well, I don't know how long that will last. You know, it might last longer, but June the 12th gives you plenty of time. And, you know, I mean, today's 15th, that's a month. So, I mean, that's longer than they would like. And that's the reason I gave you longer. So you can retain the counsel, okay? Okay, and you'll do an order on that and make sure she has your correct
I was gonna
address.
say, yeah, I need that. And Judge, I know the other case, there's two cases. There are two children. One is with the Stinsons, one is with the Milums.
Yeah.
So it's the same motion for both because they are siblings. So I don't know if you want to call it and schedule it at the same time too.
Milam Loy and others versus Mackenzie Gray, is that it?
Yes.
Is the other side they hear on that?
She did not request this motion. It was all, this here.
I don't know if any of the other parties are here. I don't see them. Loy and Raina Milam. I think Mr. Milam is the one that's in the hospital and has cancer.
Mr. Milam is in the hospital at the moment.
Okay, young lady, what's your name? You got one of the children or what?
No.
She's the mother.
My grandma and grandpa has my daughter. My
Yeah.
mom and dad have my son.
Okay, and the grandparents, well, your grandfather's one that's has
He's in Nashville.
cancer,
and
yeah.
he's gonna be there for,
Well, we'll have to, is your grandmother,
she has to be with me.
well, I know, but I'm gonna schedule this on the, on the 12th of June. And if she's still down there, then she'll just have to make some arrangements for her to be, somebody else to be with him on that day, if she wants to appear, okay? I mean, I'm sorry they're going through that, but I can't put it off forever, you know what I mean? And that's your daughter that they have? Who's got the daughter today? Yeah, well, I mean, when she comes home from school, so you're gonna, the parents are gonna keep it, okay, all right. Well, I don't see any reason why y'all couldn't share a lawyer in the thing. It appears to me there wouldn't be conflict since the same reasons that you don't think visitation ought to happen with the biological father. probably presented in both cases. You agree with that, Counselor?
Yeah, I think that they have aligned interests, yes.
Yeah, they have aligned interests that should save you some money. Okay, thank y'all very much. Hellman versus Hellman. July 17th. Vincent versus Vincent. Vincent versus Vincent. It's a motion to transfer.
Then that group order could be fine.
Transfer the case. To where?
Barrington.
Thought we reluctantly agreed to transfer the case to Barron County's agreed order. Okay. Is that the end of the civil docket? And then we got a confidential matter at what time? 2? Okay, we're off the record then.
Every day in the USA, people find themselves in court.
Have a seat. I am going to call the docket. When I call the docket, you need to stand and let me know you are here. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. Clinton Dixon, Freddie Ariano, Jeffrey Guerrero, Robert Avalos, Clinton Dixon, Fernando Jimenez, Felipe Reyes, custody. DeJohnette Havana, DeJohnette Miller Havana.
She's present with counsel, sorry.
Thank you. Harold Adams Rowley. Hello. Adrian Daniel Morales, David Ford, custody. Daniel Berlanga, I saw you, thank you. Mario Garza. Alex Russell Bacon. Thank you. Eduardo Hernandez, Paul Garay. Custody. All right, and Robert Porter. On Bowen, just let me know whenever you're ready. All right, thank you. Are the parties ready on Freddie Ariano? Court is calling 2024 CR 010818 and 2024 CR 010820, State versus Freddie Ariano. Can I have parties announced?
Ashley Jones for the state. Melissa Christian for the defendant.
And are you the defendant in this case?
Yes, ma'am.
Counsel, in each of the cause number, have you received all discovery? Did you review it with your client?
I have, yes.
Court will find that the state is in compliance with discovery. And each of the cause numbers, did you review the true bill of indictment, sir, with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment in each cause number?
I do, Judge.
State, are you proceeding on the indictment as presented and the cause number ending in 18?
We are not, Your Honor. The state is proceeding only on count 2 of that indictment, and we will waive the remaining counts. No objections.
And are you proceeding on the indictment as presented and the cause number ending in 20?
We are not, Your Honor. The state, again, will proceed only on count 2, but paragraph D of that indictment.
No objections.
All right, and each of the cause numbers, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
And the cause number ending in 1-8, you're charged with aggravated kidnapping, bodily injury, and cause number ending in 2-0, you're charged with aggravated sexual assault. Each of those cause numbers, the range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand by entering these plea bargain agreements, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, Your Honor.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He has.
In each of the cause numbers, do you believe your client has a rational as well as a factual understanding of the charges against him?
I do so believe, Judge.
In each cause number, do you believe your client is currently competent and was legally sane at the time of the offense?
Yes, Your Honor, and just for the record, he was assessed psychologically and came back competent.
And sir, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain agreement
Yes, Your Honor.
with your attorney and did you understand it?
Yes, Your Honor.
In each cause number, the state is proceeding on count 2. And in the cause number ending in 2-0, they're proceeding on paragraph D of count 2. Punishment is to be assessed at 10 years in the prison. There's a $1,500 fine, affirmative finding of deadly weapon. There are no applications. The case will run concurrently. There's an affirmative finding of family violence. There's to be Chapter 62 compliance and no contact with the complainant. Did you understand that to be the plea in each of the cause numbers?
Yes, Your Honor.
Defense, is that the plea?
That is, Judge.
State, is that the plea?
Yes, Your Honor.
In each of the cause numbers, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
Yes, Your Honor.
Counsel, are there any such motions?
No, Judge, motions have been filed, but the answer to your question is no.
And cause number 2024 CR 010818, how do you plead to count 2?
No contest.
And cause number 2024 CR 010820, how do you plead to count 2, paragraph D?
No contest.
State any evidence in each of those cause numbers.
State offers States Exhibit 1 and all attachments for both cause numbers.
We have no objection in either cause.
In each cause numbers, did you review the waiver and stipulations with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. For each of the cause numbers, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge.
All right, state, is there a reason the court should follow this agreement?
Yes, Your Honor, we have spoken with the complainant in depth. She is an adult and this is the outcome that she wants.
All right, then cause number of 2024 CR 010818, the court is finding you guilty. There's an affirmative finding. There is to be a $1,500 fine. This will run concurrent with 2024 CR 10820. There's an affirmative finding of family violence. There's to be no contact with the complainant. There's to be no contact with minors. And there's 10 years in the prison. Credit for any time served. Is there anything else with regards to sentencing in that cause number?
Your Honor, was this cause number 20?
No, this is 10818.
And no, Your Honor.
Okay. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Next, the court is proceeding with 10820. The court is finding you guilty. There's an affirmative finding. And also an affirmative finding of family violence, Chapter 62 compliance. There's a $1,500 fine, 10 years in the prison. This will run concurrent with 2024 CR 10818. There's to be no contact with the complainant. And there's to be no contact with minors. Is there anything else with regards to sentencing in that cause number?
Not from the state, Your Honor.
Nothing from the defense.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal in that cause number? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence and a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. You're receiving the 10 years because the complainant was satisfied with your receiving 10 years. If you would have went to a jury trial and the jury were to find you guilty, they probably would have given you life. You understand?
Mm-hmm.
You're not supposed to treat people that you claim to love this way. You understand?
Yes, Your Honor.
All right, my understanding, there's going to be a victim impact. The
Yes.
deputy's going to take you over to that side. You're Christian Reyna. Are you ready to proceed?
Yes, Your Honor.
Court is calling 2021 CR 9092W State versus Christian Reyna. Can I have parties announced?
Megan Galloway for the state.
And are you Christian Reyna?
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community? Hello. Adrian Daniel Morales, David Ford, custody. Daniel Berlanga, I saw you, thank you. Mario Garza. Alex Russell Bacon. Thank you. Eduardo Hernandez, Paul Garay. Custody, Tammy Franks. Thank you. Orlando Medellin, custody, David Wayne Huff. Thank you. Isaac Valle. Omar Herrera. Eduardo Hernandez, custody, Humberto Alara, thank you. Randall Mobb, Anthony Moran. All right, who is here on Eduardo Hernandez III? And after that, it will be Brandon Bowman. And probation, this is an application for deferred. Court is calling 2025 CR 004104. State versus Eduardo Hernandez III. Can I have parties announced?
Rick Pena for the state of Texas. Doug Campbell for Mr. Hernandez.
All right, if y'all cannot talk behind the court reporter while we're on the record. And are you Mr. Hernandez?
Yes.
Counsel, you received all discovery. Did you review it with your client?
Yes, Judge.
Mr. Hernandez, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Hernandez, did you review the court's admonishments with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with injury to a child or elderly or disabled person bodily injury as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? You need to speak up.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Excuse me, miss. If you cannot whisper, then you need to stop talking. We're on the record. All right. Are you a U.S. citizen?
Yes.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They're taking in consideration 2025 CR 003-443. There's an affirmative finding of family violence. There's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of the plea?
Yes, ma'am.
Defense is at the plea?
It is.
State is at the plea.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be 80 hours of community service restitution, a MIC evaluation, follow the recommendations from MIC, a TAP evaluation, follow all recommendations in anger management. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. This signed state offers into evidence, State Exhibit 1 with all attachments. No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. And state, have you spoken to the complainant?
Yes, we have, Your Honor.
All right. And then the complainant's name is listed with the last name of Garza in the police reports. But in the plea bargain agreement, you've put it as Hernandez.
Judge, it's his stepmother. I'm not opposed to it. The court needs to make a change. We're not-
All right.
You're right, I'm sorry. It-
Well, actually, they have two. They have one that's Hernandez and one that's Garza. And they have two completely different birth dates. So I'm assuming it's no contact with both. Because one is listed as January, one is listed as October
I think it's.
in the stipulations.
It is Garza. It should be Garza with the January 10th, 1959.
Okay,
I think the other one might be a typo.
all right. Love typo, gotta love typos. All right, thank you, State. You may be excused. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Yes, Mr. Hernandez is going to be homeless because of this incident. While he wants to take responsibility and get this behind him, he's not gonna have a job, he's not gonna have any money. He would like some assistance in finding a house, but that's possible to any of the services the court might have available to it. He also would like to have it probated, the fine, and he'd like to do his evaluations while out in the world.
All right, so why didn't you clean up your mess in the kitchen? Yeah, that's what it says. It said they told you to clean up your mess in the kitchen. You became upset and said something bad was going to happen and you will not like it. That's what you told the complainant. So how old are you?
I am 39.
Why are you living with your parents anyway?
I got kicked out of my other parents' house. And I lost my job too.
All right, so why did the other parent kick you out of their house?
They got upset, they're arguing about something about a bowl, that's my boss, it's just
Something about what?
a bowl, a cereal bowl,
Mhm.
and then. And they're in that one, an argument.
All right, so here's the thing, you're an adult, you shouldn't be going from parents' house to parents' house. And I'm gonna tell you what I tell everybody who is an adult or living with somebody else. If you want to keep a dirty kitchen, you can keep a dirty kitchen. But guess what? It needs to be your dirty kitchen. So whether you're an adult or not, whether you're 21 or 60, if you're living under somebody else's roof, you need to follow their rules. You understand? They're asking for a MIC evaluation. Is there any prior mental health issues?
That's my nephew.
I'm sorry?
He has physical conformity, Judge. He can't hear out of his left ear.
Oh, okay.
So you might have to speak up a little.
All right, they're asking for mental health evaluation. Have you ever had any mental health diagnosis?
No,
All right. So do you have any children?
no,
This is what the court is going to do. 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, taking consideration 2025 CR 003443, $1,500 fine, probated, affirmative finding of family violence. There's to be no contact with the complainant and no contact with the complainant's address, which is on Larkia, Larkia Lane. So don't be on that street, you understand?
yes, ma'am.
Proof of employment within 30 days. There's to be no employment as a home healthcare provider or with minors. Field visits 1 time per month until further notice. 100 hours of community service restitution. TAP evaluation, that can be out of custody. Follow recommendations. And they're asking for a MIC evaluation. I'll go ahead and do one. MIC evaluation out of custody. And I'm going to order anger management classes and a life skills course. The court will give him 50 hours credit for completion of the anger management class towards his community service restitution, and another 50 hours credit once the life skills course is completed. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did
Yes,
you
ma'am.
understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. In this court, in order to be successful at probation, communication is key. If you have an issue with probation, let the probation officer know. If there's anything you need help with, let them know. If you feel they're not addressing it, you can always come back to the court. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge. Might be excused.
Yes, you may be excused. Thank you. Who's here on Brandon Bowman? Yes.
I'm actually put him up there for some.
I'm sorry, what?
Brought him up, brought this case for you for some edification.
Okay.
It's a big word.
I love the word.
Okay, so
Edification.
he has an MTO on judge that is saying that it's a third-degree felony, and I looked through the court's file. And in all my years, I've never seen a third-degree felony done on a state jail
Paperwork.
paperwork.
Mario Garza. Alex Russell Bacon. Thank you. Eduardo Hernandez. Paul Garay. Custody, Tammy Franks. Thank you. Orlando Medellin. Custody, David Wayne Huff. Thank you. Isaac Valle. Omar Herrera. Eduardo Hernandez, custody, Humberto Lara, thank you. Randall Mobb, Anthony Moran, Shina Gonzalez.
Electronically monitored, Judge.
All right. Shina Gonzalez. Hello.
Good outcome on the trial.
I'm sorry, what?
Good outcome on the trial. Motion to suppress granted.
Ah, yeah.
I kind of thought so. We took it under consideration, then looked at it again. He goes, no, it's the first stop got thrown out, so then the second one by necessity had to. That's a weird one. I've never seen that before.
Well, good luck. I love when I see attorneys, fighting for their clients. So that's always great.
Oh, yeah. Every now and then, we gotta take the ones when we can get them.
Okay. All right, who's here on Marco Antonio Marino Vasquez? All right, thank you.
Morning, Judge.
Good morning. So, counsel, do you have all discovery now?
I do. We've gone through it. The state had recently given me some new discovery. I've gone through it with my client. He also provided videos, which I've gone through that I don't think my client needs to see, but they are potential Brady that we can use later if we need. So I think we need a trial date, Judge.
Yes, we do. Does he want a jury trial or a bench trial?
Jury trial.
With the jury.
All right. All right. How long do y'all expect this trial to last?
I would say at least a week.
I would think so.
There's a few videos. in it.
Oh, okay.
I mean, it has security surveillance that might be a little bit longer than the normal.
All right. If you all will speak with Ms. Ferguson on a jury trial date and then come back to me with the date that you all agreed upon. Do you have any questions, sir?
And we did.
No, thank you.
We've sort of narrowed it down, Judge.
Judge, I mean, just looking at our schedule, the only dates that I see that if it's one of this year
Everyone, please whisper.
would be December, the Monday's the 8th, but December 9th is a Tuesday. That's, I mean, because everything else we sort of has.
It's booked.
Well, yes, Your Honor, unless you want to get it to January, then that's entirely up to you.
All right, this is what we'll do then. Mr. Marino, in this court, we're in trial every week. I don't like for people to have to wait for their jury trial. But the state can only try one case at a time. And I try to make sure that trials are placed on the docket as quickly as possible. The earliest date that we can give you is December 9th. Now, if for some reason there is an opening that opens up sooner, we can let your attorney know and we can have you brought over sooner. Do you have any objections to the December 9th date?
Well, for me, the sooner the better.
All right, let's go on the record. Court is calling 2023 CR 4371B State versus Marco Antonio Marino Vasquez. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
For the
David A.
defense?
Garcia, attorney for Marco Moreno Vasquez.
And are you Mr. Marino Vasquez?
Yes.
All right, if I can have the interpreter, if you can raise your right hand. Do you solemnly swear or affirm do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand. So, as I was stating off the record, Mr. Vasquez, we try to get cases set in jury trial as quickly as possible. If I had 20 prosecutors in this courtroom, we could still only do one jury trial a week because I have other cases that I have to attend to as well. I know your case has been on the docket since July of 2024. There have been several issues that are outside. Oh, excuse me, just one second. Are you the first attorney on this case?
I am, Judge, but there have been a lot of discoveries that have come in over time. And I think that's one of the reasons why things have been delayed.
And yeah, just for the discovery purposes, the CPS information just became relevant or actually given notice to us and actually just developed in probably the last couple months or so. And then he does have a co-defendant that was set before him that ended up fleeing and he's pending sentencing. So that may have complicated issues.
Okay.
So that might be some of the.
All right, because I'm looking at the time that he's been on the docket. He's actually been on the docket for what I consider to be a long time, but now that has cleared that up.
Right. And then I think one other thing was it came in as tampering as opposed to the murder.
And and it's still listed.
Right, it's still listed as tampering, and that was one of the issues that I had to contend with my client, because he kept arguing that he's only charged with tampering. And I was like, no, there's also a murder.
Well, and actually, I believe my understanding is that it's a 3-count indictment. It's murder and tampering, and also I believe deadly conduct or something like that.
Yes, and then there's a burglary of a habitation. Well, no, there's a discharging of a firearm at a habitation. So, sir, you actually have 3 counts in your indictment. You have a murder count, you have a discharging of a firearm into a habitation, and then
A tampering.
and a tampering.
May I speak?
Sure.
Es lo que no entiendo yo eso, porque desde los primeros 3 meses que me llegó el indictment, tenía yo el caso de muerte. Después desapareció y me pusieron temporary evidence por más de 16.
All right.
That's what I don't understand. In the last 3 months, they told me that they gave me the indictment and it showed the murder, but then it was the tampering.
All right, so let me just explain something to you. When they do an indictment, the court receives one, and the court receives the original that's signed by the foreman of the grand jury. So this is your indictment, and there are 3 counts in it. Now, sometimes what will end up happening, for some reason, when a case is indicted, instead of the higher level felony being listed first, they list the lower felony. And then people will think, oh, I'm just charged with a 3rd-degree felony tampering with evidence. But there are other counts in it. So whenever you see something, when they're bringing you over from the jail and what you're charged with, they don't list all 3 counts that are in your indictment. They'll just list one offense. And so in your case, that's why I always get confused when I see you, because in your case, on the court's docket sheet, it'll just say tampering with evidence. That's why I was looking at both of them. How can a tampering with an evidence case take 5 days or a week? But then when I go back and I remember and I look at your indictment, and 1 count, you're charged with murder, and another count, you're charged with discharging a firearm at a habitation, which means a place that's occupied and somebody's living. And then the third one is tampering with the evidence. So when they indicted you, they just took one general case. And they, under that one case number, they put all 3 counts. If they wanted to, they could have said, you know what, we're going to charge him in 3 separate cases. You have 3 separate cause numbers. One cause number will be the murder case. One cause number will be the discharging at a habitation, and the other one will be tampering with evidence. But they just decided to put it all in one indictment. Do you understand?
Yes,
Ahora, le pido por favor.
I ask you, please.
Por eso ya tengo más de 1 año y medio diciéndole al abogado que quiero ir a juicio.
It's been more than a year and a half that I've been telling my attorney that I want to go to trial.
Porque lo que por eso quiero ir a juicio para que el jurado me escuche y también la juez me escuche, porque aquí no me dejan hablar cuando yo vengo.
That's why I want to go to trial, in order for the judge to listen to me, the jury to listen to me, because when I come here, nobody allows me to speak.
Y luego, para lo que me están acusando de muerte, que me están acusando que le disparé a una habitación, y lo otro, por eso quiero que me enseñen las pruebas de que tengo, porque yo sé que yo tengo mi mente limpia, que yo no hice nada. Quiero que me enseñen.
And then they're telling me that, you know, there's the case of murder and then the discharge of a firearm. So what I want is for, you know, to be able to see all the proof and everything that they have.
All right, so let me explain something to you. Sometimes the length of time that it takes you to go to trial is outside your attorney's control. The way I say we can't do 2 cases at the same time for jury trial, we came close one time. We had a jury deliberating and started another trial. But your attorney can't be in 2 places at the same time. And I guarantee you, Mr. Garcia, I know him. He's never been to my house for dinner, so I don't know him that way. But what I can tell you is, I know for a fact that he's been in a jury trial since your case was pending. And if he's in a jury trial somewhere else, he can't be in a jury trial here, because nobody can be in 2 places at the same time. And then when we're in a jury trial, we can't have your trial. So then your case will get pushed back to another day. So the fact that this is your setting day is not your attorney's fault. It's not my fault. It's not the state's fault. It's just that your case is not the only case on his docket, on the state's docket, and my docket. If your case were the only case that was pending in all of the cases that I have, and I think I have over 1,000 or something, we would try your case right now. Today, I would bring a jury in, but that's not what we have. Now, with regards to your viewing the evidence, I've been a defense attorney, I've been a prosecutor. What I can tell you is sometimes people, when they're charged with a case, they don't look at their evidence objectively. They want something, and they want their attorney to tell them something different than what they're seeing. Your attorney can show you the evidence, you look at it, and then you make an informed decision on whether or not you want to go to trial, or whether or not you want to reach an agreement with the state. I will tell you what I tell everyone here. I've had people come to me before bench trials. I found some people not guilty. I found some people guilty. Whatever evidence is presented to me, this is a murder case. For me, I would listen to the evidence and I'll base my decision on the evidence that presented to me. I'm not going to say, oh, the state didn't prove their case, but this is a murder case. Let me find somebody guilty. For me, it's a murder case. Did the state prove their case beyond a reasonable doubt? Even on a murder case, if they didn't prove their case beyond a reasonable doubt, I'm going to find you not guilty. If they prove it beyond a reasonable doubt, I'm going to find you guilty. Do you understand?
Yes.
Now, if you want a bench trial, I can get you in here sooner. But in order for you to be entitled to have a bench trial, the state has agreed to waive the jury, and you have to agree to waive the jury. So if you want a bench trial, then we can do it sooner. If you want a jury trial, the earliest I can have you in here is that December 9th date. If something falls through, the state can call your attorney, the coordinator will call your attorney and say, we have an earlier date open. Do you understand?
Entiendo.
Ah, fíjate, yo no le estoy echando la culpa a ellos de que el juicio, ¿cómo se llama? Que se está tardando nada de eso.
I'm not
Simplemente
blaming them
yo no,
that the trial is taking long or anything.
yo no me estoy guiando a lo que ellos me están diciendo, que me dicen que una fecha y luego otra y otra y yo estoy esperando.
I'm basing myself on what they're telling me. You know, they give me one date, they give me another day, they give me another day. You know what I mean?
The reason why is because when you are given a jury trial date, if there's a case that is older than yours, that is on the docket as well, then that case will go first. In your case, you had a co-defendant. The co-defendant decided to enter into a plea. So once he or she entered into a plea, then your case became next. Your number ends in the letter B. So the person whose number ends in the letter A goes before you.
Okay.
Y otra, no es porque no, no,
Thank you,
no,
maybe
quiera ir,
excuse.
nada, simplemente que en más de 27 meses no me lo he visto 2 veces por aquí nomás.
Well, and the thing is, not that I don't like him or anything, but in the 27 months, I've only seen him like twice.
All right, so here's the thing. Let me just tell you another thing. Sometimes defendants want to see their attorneys. They would love to see them on a daily basis because I know this is an extremely important case to you, right? But some attorneys, if they don't have any new information to give you, their whole thing is, why am I seeing you? I don't have any information to give you. I'm going to show up and say, hey, we're waiting on this discovery. I don't have it yet. Now, I will tell you, when I was a defense attorney and I was starting out, and this is how you get burned out, I would see, if I had a client in jail, I would see them once a week. I would take the via bus, go to the jail, and I would see my clients on Saturdays and Sundays. And I would come and I would tell them, hey, I'm just letting you know that I'm still working on your case. I'm still waiting on this. Because sometimes the only visitor that your client will have is their attorney. Now, I would do that. I didn't have to do that. And your attorney doesn't have to do that. If they don't have any new information to impart to you, there really is no reason for them to see you. Because at the end of the day, in the words of John Wayne, we're not here to make friends. We're just here to do a job. Right? So that's where we are. Now you're saying you haven't seen something. He said he hadn't seen what the state has against him.
Nomás me enseñaron un video que tienen en contra mía, que según estuve presente, y es lo que he visto yo nomás. De
The
100,
only thing I've seen is a video that they showed me where I was supposed to be there. That's all I've seen.
de 100 videos que trae el investigador, nomás me han enseñado
So
uno.
let me ask you this.
The 100 videos that the investigator has, they only showed me once.
All right, so here's the thing. My question is, have you seen the police report?
No me enseñó nada.
They have not shown me anything.
All right, so Mr. Garcia, I understand what's going on. But if you could just grab the state's file and let him read the police report.
I'll do it again, Judge. I've done it in court
I know
many
you have.
times. My investigator spent countless, I mean, a lot of hours showing him tons of video, reading him all of the reports. My investigator speaks Spanish perfectly, and that's why we have that done so that there's no problem. It's much harder here in the court, but I'll go through it again.
All right, so they're gonna go over the police reports with you again. It's gonna be whatever is in the state's file, and your attorney will look at that. And after looking at that, if you change your mind about anything, just let the court know. But your court date is gonna be December 9th.
Thank you, Judge.
Thank you.
Muchas gracias.
Yes, thank you very much.
De nada. That's all I know, really.
Oh, here's a copy of the.
Yo tengo uno, yo tengo como 3 videos.
May I approach on the floor, Lieutenant?
Yes, just give me one moment. All right, if you can have them pull the file. And is the co-defendant out here?
No. Still upstairs, we're trying to. He couldn't come up.
Okay. Oh, it's a PSI?
Yes.
Okay.
He is sentencing judge, but I believe he's going to be a witness for the state of Texas.
All right.
So this is why I need to.
If you can
He's aware of it.
talk to the state and make sure that he's going to be a witness, you need me to sign.
I just spoke to Mr. Garrett.
Thank you so much.
My pleasure. I spoke with Mr. Garcia and I told him that if he needs help, just give us a call. Oh, for your
My
client.
client is.
All right, so here's the thing.
Okay.
With regards to your client, he's reading a couple of things, so I don't know, he may decide to change his mind. So if you could come back by 11:30, are you able to come back?
Yeah.
All right. She's gonna come back at 11:30 for her client, Deputy Laura, so you don't have to bring him up now. Okay, thank you.
Thanks. Thank you, Judge.
You're welcome. Who is here on Fernando Trujillo? What is his status?
He's still in federal custody, Judge. We just came back to check on that.
Oh, I've already reset that. I still don't know why it's on the docket. It's been reset for August 25th because my understanding is that his federal case is reset for August 18th.
Fantastic.
All right,
I'll
thank you.
make sure the firm updates the calendar.
All right, thank you.
What date again was that, Judge?
It is August 25th, and let me
August
just
25th.
check the calendar, just 1 second. Yeah, August 25th.
Great. Thank you very much, Judge.
You're welcome. Yes. Sure. Norma Trujillo shouldn't be on the docket. Well, we reset that for August 25th. I think I already put that in the system. Put down David Huff. All right, if you'll come forward. Probation, this is an application. All right, counsel, you on this side. Court is calling 2025 CR 003649, State versus David Wayne Huff. Can I have parties announce?
Matthew Finch for David Huff, Your Honor, ready.
And are you Mr. Huff?
Yes, ma'am.
Counsel, have you received all discovery?
I have, Your Honor.
Did you review it with your client?
We have.
Court will find that the state is in compliance with discovery. Mr. Huff, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do waive, Your Honor.
State, are you proceeding on the indictment as presented?
Yes.
All right. Did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram, within 1,000 feet of a playground, and that makes it a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Huff, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 years in the prison. The state recommends community supervision. They will take in consideration 2025 PF 06925. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. Did you understand that's a recommendation from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plea?
No contest.
State any evidence.
State offers exhibit 1 and attachments, Judge. We've reviewed those, Your Honor. We have no objections.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor. We waive PSI today.
Anything you wish to say on behalf of your client?
Your Honor, my client is motivated. He's accepted responsibility today. He's asking the court to follow this plea bargain. We would ask that you sentence him accordingly and follow our recommendations to the court as well.
All right, so how long have you been using?
About 10 years.
All right, why did you start? What happened in your life?
My mom, my dad, and my stepdad was killed in the car wreck.
I'm sorry to hear that.
Kind of messed me up, but
So are you, if you were tested today, what would the results be? All right, positive for what? And what else? All right, so here's the thing, where you're starting at now today, it's the court's hope that this probation, you'll improve and you'll get clean and sober and you stay clean and sober. So do you have any support system?
yes, ma'am. They want me to go to treatment.
Right, so I mean, do you have, where are you, who do you still with?
I got my own house. I stay in Asheville Road. But,
Okay, so do you live by yourself?
Yes, ma'am.
Do you have any children?
No, I got 2 kids, but they live in West Texas.
And what are their ages?
My son's 24 and my daughter's 18.
All right, do you have any grandchildren?
No, yeah.
Okay, are you working at all? What do you do?
I work for, right now I work for People Ready.
I'm sorry, what?
For People Ready as an electrician.
Okay.
So.
All right. This is what the court will do. The court will sentence you to 6 years in the prison, suspended and probated for 6 years. There's to be no contact with Veronica Renee, Renee Trevino. There's to be proof of employment within 30 days. No employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. Field visits 1 time per month until further notice. There's gonna be 200 hours of community service restitution, 120 sober meetings in 120 days, a referral to felony drug court, TAP evaluation, out of custody, follow TAP recommendations, probation. Is there anything else he needs? And I'm sorry, taking consideration 2025 PF 06925.
Judge, may I approach?
Yes. Is there anything else you need from the court in order to be successful?
No, ma'am, I appreciate it.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right. In this court, to be successful on probation, communication is key. So if there's an issue, talk to your probation officer. If you feel as though they're not addressing it, you can always come back to court. And nobody can help you, and we can't help you with your drug addiction if you don't want to help yourself. Now, I've ordered that you have a TAP evaluation out of custody. They're going to give you a date for that. If you miss that date, what's going to end up happening is a motion to revoke is going to be filed. You're going to be taken into custody. Either you'll make bond or you won't make bond, and I'll hear that motion to revoke. So if you need to get an appointment booklet, get an appointment booklet and put your dates down. You understand? And when you leave here today, other than following their instructions, you need to go to a sober support meeting. Those are the NA meetings, so you can get your life back on track. Because if you continue to use, only two things going to happen. Either you're going to end up in prison, right? And you're going to lose everything. You're going to lose your house. You're going to lose even more time with your children. Or either somebody's going to have to come down and identify your body. You understand? All right, good luck to you.
Thank you.
Thank you. Yes. Just have him remain in custody to speak with probation. Yes.
Herrera on the docket.
Mhm.
With the state, we have an offer, but they want to find out what the restitution is.
Okay, I mean, I'll do that. Just, yeah, it's over here. Yeah, I'm going in order. I just have to put this in the system. Thank you. Eduardo Hernandez, Paul Garay. Custody, Tammy Franks. Thank you. Orlando Medellin, custody, David Wayne Huff. Thank you. Isaac Valle. Omar Herrera. Eduardo Hernandez, custody, Humberto Alara, thank you. Randall Mobb, Anthony Moran. Shaina Gonzalez.
Electronically monitored, Judge.
All right. Shaina Gonzalez. Shaina Gonzalez. Justina Salcedo, custody. Fernando Trujillo. Fernando Santos Trujillo. I think he's in federal custody. Lazarus Carrillo, custody. Marco Marino Vasquez, custody. Millard Cummings. Millard Durrell Cummings. Camillus Galvan. Leslie O'Bannon. Andre Moody. Christian Reyna. Fabian Rodriguez. Vanessa Rubio. Adis Hernandez Rivas. Brandon Bowman. Felix All right, Omar Herrera. Omar Herrera. Where's your attorney? All righty. Who is here on Roberto Avalos Jr.? And probation, there's no application. Court is calling 2024 CR 012312, State versus Roberto Avalos Jr. Can I have the parties announce?
Megan Galloway for the state.
Yes.
All right, good luck to you.
Thank you, Judge.
You're welcome. All right. Omar Herrera.
Morning, Judge.
Good morning. Yes. Oh. So on this case, where are we on discovery?
Judge, I think we've gotten all the discovery and there are just a couple of issues that we're just trying to figure out.
Okay.
And that's restitution on each case. The state's gonna need a little time just to reach out to the complainants.
All right. How much time do you need, state?
30 days.
All right, Ms. Ferguson, I need a plea deadline date for 30 days. All right, June 12th is your plea deadline date. Is there anything else?
No, Your Honor.
All right, thank you for dressing appropriately for court. Just have a seat. Once you sign the reset form, you'll be excused.
Thank you, Your Honor.
Thank you.
Bail bonds. They're saying they didn't get off the bond, but I guess there were some early problems like back in January where they were behind.
All right, so he should be free to go then.
Okay.
All right, thanks.
Thanks.
You're welcome. All right, who's here on Lazarus Carrillo?
Daniel de la Garza and Mark.
Are they're in the hallway. Can you peep out in the hallway and tell them, come on down? Yes, no, yes, for the bond hearing. And then if they can do whatever they want on the bench trial, I mean, if they wanted to. Yes, oh, I'm sure the state will agree. Yes, and if you all want a bench trial.
Judge, the state is just gonna tell you maybe, I guess. So I don't know if that's a yes or a no.
I'm sure it'll be a yes. Just figure out what date you all want your bench trial. It should be a day.
Okay.
All right, they're gonna bring your guy back from the back. My understanding is that the bondsman is on his bond. All right, so where is Lazarus
Right here.
Carrillo? Come down, please.
Yes.
All right.
Have a good day.
Okay, my understanding that this came from another court. It's been on the docket since August 2024. So this is what we're gonna do. Y'all are not seeking the death penalty, is that correct?
Correct, Your Honor.
All right. So I'm going to give you all, do you have all of the discovery? Do you know if you have all discovery?
That's what I think we're gonna have to go over, and that's why we're asking for 45 days, because of the two places, and just make sure that she's got it and that we've gotten it from her.
All right, Miss Ferguson, recall this. I'm gonna recall this for 60 days. Say, at that time, you'll need to be prepared to tender an offer to the defense.
Yes, sir.
All right. All right, July 14th. On that date, what's gonna end up happening in this court, I like for things to move, for progress to be made. So on July 14th, your counsel is gonna have all the discovery. The state is gonna tender an offer. After that, you're gonna get a 30-day reset, and that's gonna be your plea deadline date. And on that date, you need to let the court know whether or not you've reached an agreement with the state. If you have not reached an agreement, your next court date is going to be a jury trial. And for jury trials, the court does not consider any plea bargain agreements without good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes, ma'am.
All right. Is there anything else?
Not from the state, Your Honor.
Nor the defense.
All right, thank you. Then the deputies will take him back.
Thank you, Judge.
You're welcome.
Lord.
And Norma, did you call down a Justina Salcedo custody, Fernando Trujillo, Fernando Santos Trujillo? I think he's in federal custody. Lazarus Carrillo custody. Marco Marino Vasquez custody. Millard Cummings, Millard Durrell Cummings. Camillus Galvan, Leslie O'Bannon, Andre Moody, Christian Reyna, Fabian Rodriguez, Vanessa Rubio, Adis Hernandez Rivas, Brandon Bowman, Felix Acuna, custody. Is there anyone whose name? Vashawn Rubio is recalled for June 5th. Marco Marino Vasquez. We need an interpreter. Are they here?
Yes, Judge, I called him already. They said they were on their way.
All right, so once the interpreter comes, you can give me the file.
That's a weird one. I've never seen that before.
Well, good luck. I love when I see attorneys, fighting for their clients. So that's always great.
Yeah. Every now and then, we're gonna take the ones when we can get them.
Okay. All right, who's here on Marco Antonio Marino Vasquez? All right, thank you.
Morning, Judge.
Good morning. So counsel, do you have all discovery now?
I do. We've gone through it. The state had recently given me some new discovery. I've gone through it with my client. He also provided videos, which I've gone through that I don't think my client needs to see, but they are potential Brady that we can use later if we need. So I think we need a trial date.
Yes, we do. Does he want a jury trial or a bench trial?
Jury trial.
With the jury.
All right. All right. How long do y'all expect this trial to last?
I would say at least a week.
I would think so.
There's a few videos. in it.
Oh, okay.
I mean, it has security surveillance that might be a little bit longer than the normal.
All right. If you all will speak with Ms. Ferguson on a jury trial date and then come back to me with the date that you all agreed upon.
Thanks.
Do you have any questions, sir?
And we did,
No.
We've sort of narrowed it down, Judge.
Judge, I mean, just looking at our schedule, the only dates that I see that if it's getting one of this year
Everyone, please whisper.
would be December, the Monday's the 8th, but December 9th is a Tuesday. That's, I mean, because everything else sort of has.
It's booked.
Well, yes, Your Honor, unless you want to get it to January, then that's entirely up to you.
All right, this is what we'll do then. Mr. Marino, in this court, we're in trial every week. I don't like for people to have to wait for their jury trial. But the state can only try one case at a time. And I try to make sure that trials are placed on the docket as quickly as possible. The earliest date that we can give you is December 9th. Now, if for some reason there is an opening that opens up sooner, we can let your attorney know and we can have you brought over sooner. Do you have any objections to the December 9th date?
Well, for me, the sooner the better.
All right, let's go on the record. Court is calling 2023 CR 4371B State versus Marco Antonio Marino Vasquez. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
David A. Garcia, attorney for Marco Moreno Vasquez.
And are you Mr. Marino Vasquez?
Yes.
All right, if I can have the interpreter, if you can raise your right hand. Do you solemnly swear or affirm do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand. So, as I was stating off the record, Mr. Vasquez, we try to get cases set in jury trial as quickly as possible. If I had 20 prosecutors in this courtroom, we could still only do one jury trial a week because I have other cases that I have to attend to as well. I know your case has been on the docket since July of 2024. There have been several issues that are outside. Oh, excuse me, just one second. Are you the first attorney on this case?
I am, Judge, but there have been a lot of discoveries that have come in over time. And I think that's one of the reasons why things have been delayed.
And just for the discovery purposes, the CPS information just became relevant or actually given notice to us and actually just developed in probably the last couple months or so. And then he does have a co-defendant that was set before him that ended up fleeing and he's pending sentencing. So that may have complicated issues.
Okay.
So that might be something.
All right, because I'm looking at the time that he's been on the docket, and he's actually been on the docket for what I consider to be a long time, but now that has cleared that up.
Right. And then I think one other thing was it came in as tampering as opposed to the murder.
And and it's still listed.
Right, it's still listed as tampering, and that was one of the issues that I had to contend with my client, because he kept arguing that he's only charged with tampering. And I was like, no, there's also a murder.
Well, and actually, I believe, my understanding is that it's a 3-count indictment. It's murder and tampering, and also, I believe, deadly conduct or something like that.
Yes, and then there's a burglary of a habitation. Well, no, there's a discharging of a firearm at a habitation. So, sir, you actually have 3 counts in your indictment. You have a murder count, you have a discharging of a firearm into a habitation. And then
A tampering.
and a tampering.
May I speak?
Sure.
Es lo que no entiendo yo eso, porque desde los primeros 3 meses que me llegó el andamiaje, tenía yo el caso de muerte. Después desapareció y me pusieron tempo whatever por más de 16.
All right, that's what I don't understand. In the last 3 months, they told me that they gave me the indictment and it showed the murder, but then it was the tampering.
All right, so let me just explain something to you. When they do an indictment, you know, the court receives one and the court receives the original that's signed by the foreman of the grand jury. So this is your indictment and there are 3 counts in it. Now, sometimes what will end up happening for some reason, when a case is indicted, instead of the higher level felony being listed first, they list the lower felony. And then people will think, oh, I'm just charged with a 3rd-degree felony tampering with evidence. But there are other counts in it. So whenever you see something, when they're bringing you over from the jail and what you're charged with, they don't list all 3 counts that are in your indictment. They'll just list one offense. And so in your case, that's why I always get confused when I see you, because in your case, on the court's docket sheet, it'll just say tampering with evidence. That's why I was looking at both of them. How can a tampering with an evidence case take 5 days or a week? But then when I go back and I remember and I look at your indictment, and one count you're charged with murder, and another count you're charged with discharging a firearm at a habitation, which means a place that's occupied and somebody's living. And then the 3rd one is tampering with the evidence. So when they indicted you, they just took one general case and they, under that one case number, they put all 3 counts. If they wanted to, they could have said, you know what, we're going to charge him in 3 separate cases. You have 3 separate cause numbers. One cause number will be the murder case. One cause number will be the discharging at a habitation, and the other one will be tampering with evidence. But they just decided to put it all in one indictment. Do you understand?
Sí.
Yes,
Ahora, le pido por favor.
I ask you, please.
Por eso ya tengo más de 1 año y medio diciéndole al abogado que quiero ir a juicio.
It's been more than a year and a half that I've been telling my attorney that I want to go to trial.
Porque lo que por eso quiero ir a juicio para que el jurado me escuche y también la juez me escuche, porque aquí no me dejan hablar cuando yo vengo.
That's why I want to go to trial, in order for the judge to listen to me, the jury to listen to me, because when I come here, nobody allows me to speak.
Y luego, para lo que me están acusando de muerte, que me están acusando que le disparé a una habitación, y lo otro, por eso quiero que me enseñen las pruebas de que tengo, porque yo sé que yo tengo mi mente limpia, que yo no hice nada. Quiero que me enseñen.
And then they're telling me that, you know, there's the case of murder and then the discharge of a firearm. So what I want is for, you know, to be able to see all the proof and everything that they have.
All right, so let me explain something to you. Sometimes the length of time that it takes you to go to trial is outside your attorney's control. The way I say we can't do 2 cases at the same time for jury trial, we came close one time. We had a jury deliberating and started another trial. But your attorney can't be in 2 places at the same time. And I guarantee you, Mr. Garcia, I know him. He's never been to my house for dinner, so I don't know him that way. But what I can tell you is, I know for a fact that he's been in a jury trial since your case was pending. And if he's in a jury trial somewhere else, he can't be in a jury trial here, because nobody can be in 2 places at the same time. And then when we're in a jury trial, we can't have your trial. So then your case will get pushed back to another day. So the fact that this is your setting day is not your attorney's fault. It's not my fault. It's not the state's fault. It's just that your case is not the only case on his docket, on the state's docket, and my docket. If your case were the only case that was pending in all of the cases that I have, and I think I have over 1,000 or something, we would try your case right now. Today, I would bring a jury in, but that's not what we have. Now, with regards to your viewing the evidence, I've been a defense attorney, I've been a prosecutor. What I can tell you is sometimes people, when they're charged with a case, they don't look at their evidence objectively. They want something, and they want their attorney to tell them something different than what they're seeing. Your attorney can show you the evidence, You look at it, and then you make an informed decision on whether or not you want to go to trial or whether or not you want to reach an agreement with the state. I will tell you what I tell everyone here. I've had people come to me before bench trials. I found some people not guilty. I found some people guilty. Whatever evidence is presented to me, this is a murder case. For me, I would listen to the evidence and I'll base my decision on the evidence that presented to me. I'm not going to say, oh, the state didn't prove their case, but this is a murder case. Let me find somebody guilty. For me, it's a murder case. Did the state prove their case beyond a reasonable doubt? Even on a murder case, if they didn't prove their case beyond a reasonable doubt, I'm going to find you not guilty. If they prove it beyond a reasonable doubt, I'm going to find you guilty. Do you understand?
Yes.
Now, if you want a bench trial, I can get you in here sooner. But in order for you to be entitled to have a bench trial, the state has agreed to waive the jury, and you have to agree to waive the jury. So if you want a bench trial, then we can do it sooner. If you want a jury trial, the earliest I can have you in here is that December 9th date. If something falls through, the state can call your attorney, the coordinator will call your attorney and say, we have an earlier date open. Do you understand?
Yo no le estoy echando la culpa a ellos de que el juicio, ¿cómo se llama? Que se está tardando nada de eso.
I'm not
Simplemente,
blaming them
yo no-
that the trial is taking long or anything.
Yo no me estoy guiando a lo que ellos me están diciendo, que me dicen que una fecha y luego otra y otra y yo estoy esperando.
I'm basing myself on what they're telling me. You know, they give me one day, they give me another day, they give me another day. You know what I mean?
The reason why is because when you are given a jury trial date, if there's a case that is older than yours, that is on the docket as well, then that case will go first. In your case, you had a co-defendant. The co-defendant decided to enter into a plea. So once he or she entered into a plea, then your case became next. Your number ends in the letter B. So the person whose number ends in the letter A goes before you.
Okay.
Y otra, no es porque no lo quiera ir nada, simplemente que en más de 27 meses no me lo he visto 2 veces por aquí nomás.
Well, and the thing is, not that I don't like him or anything, but in the 27 months, I've only seen him like twice.
All right, so here's the thing. Let me just tell you another thing. Sometimes defendants want to see their attorneys. They would love to see them on a daily basis because I know this is an extremely important case to you, right? But some attorneys, if they don't have any new information to give you, their whole thing is, why am I seeing you? I don't have any information to give you. I'm going to show up and say, hey, we're waiting on this discovery. I don't have it yet. Now, I will tell you, when I was a defense attorney and I was starting out, and this is how you get burned out, I would see, if I had a client in jail, I would see them once a week. I would take the via bus, go to the jail, and I would see my clients on Saturdays and Sundays. And I would come and I would tell them, hey, I'm just letting you know that I'm still working on your case. I'm still waiting on this. Because sometimes the only visitor that your client will have is their attorney. Now, I would do that. I didn't have to do that. And your attorney doesn't have to do that. If they don't have any new information to impart to you, there really is no reason for them to see you. Because at the end of the day, in the words of John Wayne, we're not here to make friends. We're just here to do a job. Right? So that's where we are. Now you're saying you haven't seen something. He said he hadn't seen what the state has against him.
Nomás me enseñaron un video que tiene en contra mía, que según estuve presente, y es lo que he visto yo nomás. De
The
100,
only thing I've seen is a video that they showed me where I was supposed to be there. That's all I've seen.
de 100 videos que trae el investigador, nomás me han enseñado
So
uno.
let me ask you this.
The 100 videos that the investigator has, they only showed me once.
All right, so here's the thing. My question is, have you seen the police report?
No me enseñó nada.
They have not shown me anything.
All right, so Mr. Garcia, I understand what's going on. But if you could just grab the state's file and let him read the police report.
I'll do it again, Judge. I've done it in court
I know
many
you have.
times. My investigator spent countless, I mean, a lot of hours showing him tons of video, reading him all of the reports. My investigator speaks Spanish perfectly, and that's why we have that done so that there's no problem. It's much harder here in the court, but I'll go through it again.
All right, so they're gonna go over the police reports with you again. It's gonna be whatever is in the state's file, and your attorney will look at that. And after looking at that, if you change your mind about anything, just let the court know. But your court date is gonna be December 9th.
Thank you, Judge.
Thank you.
Muchas gracias.
Yes, thank you very much.
De nada. That's all I know, really.
Oh, here's a copy of the-
Yo tengo uno, yo tengo como tres.
Can I approach on the floor, Lieutenant?
Yes, just give me one moment. All right, if you can have them pull the file. And is the co-defendant out here?
No.
Rick's downstairs, we're trying to.
He couldn't come up. because he's-
Okay.
He is, I need to be-
Oh, it's a PSI?
Yes.
Okay. Has he shown up to court?
Yes. It's been in your judge.
Okay.
Approach, Judge?
Yes.
So I've gone through everything with Marco Moreno Vasquez. He has no further questions. Just want to let the court know.
All righty, Mr. If you can come down, please. If they can pull, give me his file, please. And I'm sorry, what's your client's name again?
Marco Moreno Vasquez.
Can I see the file on Marco Moreno Vasquez, please? All right, so you had a chance to see everything?
Yes.
All right, so we'll bring you back for your jury trial on December 9th. As I said, if there's a opening that's sooner, the state will reach out to your defense counsel and we'll bring you back. Any other questions?
No, it's todo.
No, that's it.
All right, thank you. Thanks,
you, Judge.
counsel.
Thank you. very much.
You're welcome.
Maybe it's good.
Yes. Who's here on Adis Hernandez Rivas? Ah, okay, we'll wait for them.
It is Monica Guerrero.
So, well, on this case,
So yeah, it's gonna get,
reset.
needs to be reset till at least after, so the week after, maybe December 9th. Probably be the 16th or the 15th.
Norma, on this case, move it to December, Millard Cummings, Millard Darrell Cummings. Camillus Galvan. Leslie O'Bannon. Andre Moody. Christian Reyna. Fabian Rodriguez. Vanessa Rubio. Adis Hernandez Rivas. Brandon Bowman. Felix Acuna, custody. Is there anyone whose name was not called? All right, what's your name on the back row here? All right, thank you. Thank you. All right, Yaya, can you make sure you pull those two files
Great, thank you, Judge. May we be excused?
after she signs the reset form?
Thank you, Judge.
All right, thank you. Who is here on Christian Reyna? Christian Escobar Reyna. Is that the reason why I have this file? All right, who's here on ADIS? Oh, we're waiting for the interpreter. Christian Reyna. Are you ready to proceed?
Yes, Your Honor.
Court is calling 2021 CR 9092W State versus Christian Reyna. Can I have parties announced?
Megan Galloway for the state.
Got one.
And are you Christian Reyna?
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand that?
Yes, ma'am.
Are you the same Christian Escobar Reyna who was placed on deferred adjudication in cause number 2021 CR 9092W for the offense of possession of a controlled substance, penalty group 1, 1 to 4 grams?
I am, Your Honor.
All right, state.
Violation of condition number 4. In Bexar County, Texas, the defendant Christian Escobar Reyna did then and there fail to report to the supervision officer as directed for the months of September of 2024 and January and February of 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
Violation of condition number 4 on or about the 4th day of March 2025 in Bexar County, Texas. The defendant Christian Escobar Reyna did then and there fail to report as directed by the court for a compliance hearing in the 187th District Court in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
And then violation of condition number 4 in Bexar County, Texas, the defendant Christian Escobar Reyna did then and there fail to report to the supervision officer as directed for the months of March of 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
We waive and abandon the remainder, Your Honor.
Any objection?
No objection.
Did you understand by pleading true to violations 4, 4, and 4, the court can find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
I understand, Your Honor.
Knowing that, do you still wish to plead true to violations 4, 4, and 4?
Yes, ma'am.
Court will find 4, 4, and 4 true. Is there a proposed agreement?
There is not, Your Honor. The state is asking for revocation and that the defendant be sentenced to 2 years in the prison based on his lack of actively participating in his preferred education.
All right, and what are you requesting?
And Your Honor, I was also with that for a plea of truth, it was TIC a new number 1.
And that's correct, Your Honor. We TIC cause number 2025 PF 15283.
And what is that offense?
It's a possession less than a gram.
All right.
And for that reason, my client is asking for a lifetime recovery, Your Honor, as an alternative to EC. He would like to address the court if the court would allow.
Sure. You want to raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Christian Reyna.
All right, so this is not your first motion to revoke. Your previous motion to revoke was for not reporting. And now we're back here for not reporting. And then the court tried to see what was going on with you. I set it for a compliance hearing and you still did not show. The only thing you've accomplished on this probation is picking up a new number 1. What would you like to discuss?
First of all, I want to say that I have 2 kids.
No, don't bring your children into this because you had 2 children when you were placed on probation. You had children when you were not doing what you're supposed to be doing on probation. So do not use your children to play sympathy and say, oh, my children really need me. You were not a good parent to your children while you were using drugs. So you haven't been in their lives. Don't pretend like you've been seeing them. And if they're in school, that you've been keeping up with their schoolwork and going over homework with them and going to any plays or events or extracurricular activities they've had, because you have not been doing that. Now you want to come to me and you're using your children as a reason why I should continue you. So let's not start there. Let's start by taking responsibility for our own actions.
Yes, ma'am.
So what would you like to say?
I have everything going for me out there. I have a supporting family that loves me and wants me there. And I just have this problem that it's my drug use. And that's all really that's my only problem. I'm a good person. You know, I'm trying to do what I'm supposed to do.
All you have to do is pick up the phone and call probation. I tell everybody who has drug issues to reach out to your probation. If you think you're going to use, reach out to your sober support person. If you can't get in touch with anybody, you can still come back to court. And I tried to have you get back on track by setting it for a compliance hearing, and you still didn't show. So basically what you want to do, it appears to the court, you're not trying to be clean and sober because you're not reaching out to call anyone. You're acting as though you're not on probation. And there, I can't help you. I can't help you anymore because you don't want help.
I understand.
All right. Court is going to find you guilty. The court is going to revoke, taking into consideration 2025 PF 15283. The state is requesting that your sentence be 2 years in the prison. I would sentence you to 4, but I'm going to go along with the state and sentence you to 2 years in the prison. I'll request the therapeutic community. And if you're truly serious about your condition, the therapeutic community will most likely accept you, but you'll have to request it.
Yes, ma'am.
And I'll give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
I did, Your Honor.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
We can go off the record. Here's the thing. I'm gonna reach out my hand to you again. When you're released from prison, if you can't find a place to stay to help you with your sobriety, if I'm still here, you can come back here. I will pick up the phone, get a placement for you. Do you understand?
I understand.
Only 2 things can happen with the path you're on. Either you're going to end up in prison or jail for a majority of your life, or either somebody's going to be identifying your body. You understand?
I do.
All right. Good luck to you. Okay.
Thank
You're welcome.
Thank you, Judge.
You're welcome.
And he does get all his back time, right?
Yeah, he'll get credit for any time that he's been in custody.
Thank you, Judge.
You're welcome. I got no more files. Who's here on Umberto Lera? Oh, yes, come up. All right, what is happening on this case? Where are we on discovery?
Judge, we have
received discovery. We're currently reviewing it.
Okay.
I also have conferred with our client and he has some things he'd like for me to pass on to the state. So we're gathering that information for them as well.
All right, and state on this case was an Leslie O'Bannon, Andre Moody, Christian Reyna, Fabian Rodriguez, Vanessa Rubio, Adis Hernandez Rivas, Brandon Bowman, Felix Acuna, custody. Is there anyone whose name was not called? All right, what's your name on the back row here? All right, thank you. Thank you. All right, Yaya, can you make sure you pull those two files? Summer Mosqueda and Duluth, thank you. All right, everyone, where are we on discovery?
I think probably we have what we need, I would imagine, Judge. There's two issues I'd like to address with the court. One is he was remanded without bond. My client actually came to my office, I don't know, maybe about a month before the trial setting. He doesn't have a phone. He did leave me an email address, I think, or my office got an email address. I tried to send him an email, but it didn't go through. He didn't ever receive a letter or notice in the mail about the trial date. And so he really didn't have any notice of the setting.
All right,
And so I was
so
gonna see if we could get a bond set or get the bond reinstated.
you'd have to.
Yeah,
file-
I'm not evading, I'm
No.
on my way.
You'd have to file a motion, and the soonest we'll be able to hear it is Monday.
Okay.
All right.
Okay, Judge. And I guess the other issue is that I think we need to get a trial date. That if he's not gonna be able to get out.
All right, so what we'll do is we'll recall it on, Norma, recall this for Monday, the 19th. That'll be hear your bond issue, okay?
Judge, is it possible that, is there any other day that, is it start to Monday? Or is Monday the day?
You want the 20th, the 22nd?
The 22nd would probably be better.
All right.
If it's possible.
Sure. Ms. Ferguson, recall this for May 22nd to hear the bond issue.
So the same.
All right, and then if you want a jury trial, you need to decide if you want a jury trial or bench trial. All right, if you want a bench trial, talk to your attorney. And then if you'll confer with the state, we can do a bench trial quickly. So just talk to the state on a date. This is a state jail, I'm assuming?
Yes.
So it shouldn't take that long.
No.
It should be done in a day.
Absolutely.
You're welcome. So just let us know when you would like that.
All right, thank you,
Norma,
Judge.
they're gonna be requesting a bench trial. Thank you. Have a good day. Oh, thank you. God bless you too. Yes. Okay.
And on the other one, they.
All right.
Well, I have a third box on them, so, but the once you verify the bonds are good.
Who's here? I'm Brandon Bowman. Yes.
I'm actually put him up there for some.
I'm sorry, what?
Brought him up, brought this case for you for some edification.
Okay.
It's a big word.
I love the word.
Okay, so
Edification.
he has an MTO on judge that is saying that it's a third-degree felony, and I looked through the court's file. And in all my years, I've never seen a third-degree felony done on a state jail
Paperwork.
paperwork.
Mhm. That has been known to happen in this court.
I didn't know. it-
My guess is that we might have reduced it and maybe and it was not properly titled, maybe.
All right.
It,
let me
it,
see.
and the reason
I
I
haven't
brought
looked at
that
the
up
file
is
yet.
because, Bama told me no, but I'm on for state jail, and that's why I looked through the court file. So
Let
I
me
wanted
just
to
see.
see what was going on.
Oh, it wouldn't be on here because this was, let's see.
Yeah, the judgment says third degree, paperwork says state jail.
But that would be entered by somebody that
Right.
might have just looked at the title of it. But I imagine if there's state jail paperwork, it should be reduced or I can look at the steps and know if for sure,
Okay,
Judge.
I'll let you guys do that. All right, thank you. Harold Adams Raleigh. Who's the attorney on Raleigh?
Yes, Your Honor. Sorry,
He was talking to the phone.
All right.
I'm spinning. a lot
Oh,
of
are you all ready or no?
Your Honor, we need 2 weeks to allow Mr. Riley to get his affairs together and we have an offer. We haven't rejected it. I got appointed from the bench.
Yes.
And there's an offer in there and we're discussing it and we're close to maybe coming to a resolution. He needs to make sure he can get split with some family members before he takes the deal.
All right, on this case, set it for a contested in 2 weeks. I'm sorry, it's not for a contested. This is just a regular case.
Yeah.
Do a plea deadline date and you say May 29th.
Yes.
All right, May 29th. Once you sign the reset form, you're excused.
Okay, yes, ma'am.
All right, thank you.
Thank you, Your Honor.
You're welcome.
Yeah, I'm spinning a lot of plates today, which is good.
Judge, I did look, I actually, and it was, the language was changed. And it does say less than a gram.
All right,
It's
so
written
then
in.
what we'll do is, I'll send an email to Barbara. She'll, y'all can change the judgment. On this, the judgment should reflect that it's a state jail felony. All right. Who's here on Christian Reyna?
That would be
Has he shown up to court?
Yes. It's been in our judge.
Okay.
Hey, Christian.
Yes.
So I've gone through everything with Marco Moreno Vasquez. He has no further questions. Just want to let the court know.
All righty, Mr. If you can come down. Who is here on Brandon Bauman? All right, court is calling 2023 CR 6541 State versus Brandon Bowman. Could I have parties announced for the record for the state?
Reading gallery for Steve.
And is there a motion to correct the motion to revoke?
Yes, Your Honor, ask the court to amend the motion to revoke to reflect that the defendant is on deferred for the state felony offense of possession of controlled substance. UG 1 less than a gram.
Any objection?
No objection.
All right, Mr. Bowman, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Brandon Bowman who was placed on deferred adjudication in 2023 CR 6541 for the offense of possession of a controlled substance penalty 1 less than 1 gram on May 28, 2024 for a period of 4 years? Is that you? State?
Violation of condition number 1 on or about the 21st day of March 2025 in Bear County, Texas. The defendant Brandon Bowman committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
True.
Violation of condition number 1 on or about the 21st day of March 2025 in Bear County, Texas. the defendant Brandon Bowman committed the offensive assault in violation of condition number 1.
How do you plead to that? True or not true? Did you understand by pleading true to violation of conditions 1 and 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 1 and 1?
Yes, ma'am.
Court will find violation 1 and 1 true. Is there a proposed agreement?
There is, Your Honor, it is to adjudicate the defendant guilty, revoke his community supervision, sentence him to 8 months in the state jail facility, and for the court to take into consideration cause numbers 2025.
Just 1 second. 2025?
Yes, 2025 CC 004565 and 2025 DC 004679.
All right. Is that the agreement, counsel?
It is, Your Honor.
Are you asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, the court will follow your agreement. The court will find you guilty, revoke, sentence you to 8 months in the state jail facility, give you credit for any time served, take in consideration 2025 CC 004565, 2025 CC 004679. Is there, and the court will order a therapeutic community. Is there anything else with regards to sentencing?
No.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
You're gonna have to do better in your life because we're off the record. 1 or 2 things gonna end up happening. Either you're gonna end up in jail or in prison for all these drug charges that you keep picking up, or either somebody's gonna have to identify your body. Those are the only 2 choices. Once you're released from custody, if you can't find a place that can help you with your sobriety and help you get your life in order, if I'm still here, I'll pick up the phone and get you the help you need. You understand?
Yes, ma'am. Thank you.
All right, thank you. Counsel, with regards to all right, this is the last case, then the court is going to take a recess and it's Acuna. Counsel, you're on the side.
Oh, yes, sir.
Oh, no, I haven't called it yet. You're still doing great. Leslie O'Bannon, Andre Moody, Christian Reyna, Fabian Rodriguez, Vanessa Rubio, Adis Hernandez Rivas, Brandon Bowman, Felix Acuna, custody. Is there anyone whose name was not called? All right, what's your name on the back row here? All right, thank you. Thank you. All right, Yaya, can you make sure you pull those 2 files? It's Summer Mosqueda and Deleuze. Thank you. All right, everyone. Oh, no, I haven't called it yet. You're still doing great. All right, court is calling 2023 CR 9998 State versus Felix Acuna. Could I have parties announced for the record for the state?
Megan Galloway for the state.
Defense?
Dwight Chumley for Mr. Coon.
All right. And are you Mr. Acuna? Did you review the document entitled Motion to Revoke Community Supervision and State's Motion to Supplement Pending Motion to Revoke Probation? With your attorney, did you understand it?
Yes.
Are you the same Felix Xavier Montoya Acuna who was placed on community supervision in 2023 CR 9998 for the offense of driving while intoxicated with a child under 15 on March 28, 2024 for a term of 2 years? Is that you? All right, state.
Violation of condition number 4 in Bear County, Texas, the defendant Felix Xavier Montoya Acuna did then and there fail to report to the supervision officer as directed for the months of July, August, September, October, November, and December 2024 in violation of condition number 4.
How do you plead to that? True or not true?
Yes, ma'am. True.
State.
Violation of condition number 4 in Bear County, Texas, the defendant Felix Xavier Montoya Acuna did then and there fail to report to the supervision officer as directed for the months of January, February, and March 2025 in violation of condition number 4.
How do you plead to that? True or not true?
We waive and abandon the remainders, Your Honor.
Any objections to the waivers?
No.
Did you understand by pleading true to violations 4 and 4, the court could find it true, grant the motion, sentence you to 2 years in the prison and up to a $500 fine? Knowing that, do you still wish to plead true to 4 and 4?
Yes, ma'am.
Court will find violation of condition 4 and 4 true. Is there a proposed agreement?
There is not, Your Honor. The state is asking that you revoke the defendant's community supervision and sentence him to 2 years in the state jail facility based on the stipulations that he has absconded from probation and the court since going on 10 months.
Your Honor, we have a explanation to, if I might inquire of my client. Your Honor.
Yes, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Yes, Mr. Coon, you're here in front of the judge today, and you've been on probation for a little over a year, maybe a year and a half. Can you explain to the judge, you pled true that you did not report on the various months in 2024. Can you explain to the judge what your situation was and why that did not happen?
My situation was that I was traveling back and forth from San Marcos to San Antonio. And back and forth, I didn't have time to check in. I know I should have picked up the phone, honest to my heart. I know I should have called at least several times, but I didn't. Between work and back and forth traveling, needing transportation to get over there and come back was hard for me. And
So here's the thing, if he was actually living in San Marcos.
No. I was gonna clarify for you. I was explaining to the judge, you were living in San Antonio and working in San Marcos, is that correct?
Yes.
And what type of work were you doing there?
I was doing construction.
I don't understand.
I was doing.
Here's the thing, though. I don't understand why you didn't pick up the phone to call probation. I thought his testimony was gonna be, I was in a coma. I just woke up. Or either I had a serious injury. Or either I was kidnapped by strangers and I just found release. What you're giving me is not a good excuse for not reporting. Because in this court, I always tell people if there's an issue, let your probation officer know. All you have to do is pick up the phone and call somebody. You're telling me you should have known, you should have called somebody and you didn't.
I got busy with work, yes, ma'am.
So I don't know what you want me to do.
Yes, I will, if I might ask, you were required to connect on a interlock device for your vehicle, is that correct?
On my vehicle, yes.
And you did go through the process of doing that, is that correct?
On the homing device.
Okay, and then you had another requirement condition that you met involving the training report, which you explained to me that you had done. You have records of doing.
On the process of me being on probation, I had completed the education program, the DWI education program. And on the other side, I did complete the DWI in involuntary.
We have proof of that?
Impact, the VIP, the impact program, and I also have a certificate for the family, parent, class.
All right, where's the certificate?
I have it at home. I did not, appreciate, I mean, I appreciated that I'm here at court, but I did not know, and I don't have any
Oh,
relatives
did you
here.
ever turn that over to probation that you've completed that?
I sent a message to my probation officer.
All right, probation, do you have proof that he has any of that? All right, is there anything else?
If it makes a difference to you, Judge, I think if you give him a couple days, he's been in custody, how long now? 60 days?
60 days. I am a trustee too, so yeah, 60 days.
I could maybe fetch that stuff for you.
All right, this is what I'm gonna do. I'm gonna revoke you. I'm gonna sentence you to 2 years in the state jail facility, give you credit for any time served. There's a 2-year license suspension. And I'll order the therapeutic community. Counsel, if you're able to provide the court proof that he has done those things, then the court will reconsider, not revoking him, but reconsider the amount of time.
Thank you.
All right.
Appreciate it.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. All right, we can go off the record. So if your attorney is able to bring documentation to the court that you have actually done those classes, I will reconsider the sentence of 2 years. I'm not going to continue on probation. I don't think you're a good candidate for probation, but I'll consider classes that you've completed. Do you understand?
Okay, bye.
All right, thank you.
Yes.
Yeah.
We'll bring it back.
Give me a
Bring it
phone
back,
number.
bring it back.
Yeah. Who do I call? Okay.
Yes, we'll get to you.
478.
Okay.
81.
478.
427. My bad. I'm sorry. 427. 64. 80.
All right, and Melissa,
And her name
on
is,
your case, if you all have already done all of the paperwork, you can appear by Zoom. Okay. All right, Fernando Jimenez. All right, the court is calling 2025 CR 001924 and 2025 CR 000637. State versus Fernando Jimenez. Can I have parties announce?
Rick Pena for the state of Texas.
Melissa Christian for the defendant.
And are you Mr. Jimenez?
Yes, ma'am, I am.
All right, defense, do you have any objection to defense counsel appearing by Zoom?
We have no objection.
I'm sorry, state, do you have any objection? All right, Melissa, you were about to object to yourself. You're like, why is the judge asking me that? All right, Mr. Jimenez, do you have any objection to your counsel appearing by Zoom?
No, ma'am.
All right. Attorney Christian, did you receive all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
There are not.
All right, Mr. Jimenez, did you review the documents
Yes, ma'am, I did.
entitled True Bill of Indictment with your attorney? Did you understand them?
Yes, ma'am.
Counsel, do you waive the reading of the indictment in each cause number?
We do.
State in cause number 2025 CR 001924, you're proceeding on the indictment as presented?
No, Your Honor, they will be proceeding on that case with regard to only count one, we'll waive count two, and we will waive the repeat offender enhancement.
No objections.
And then in cause number 2025 CR 000637, are you proceeding on the indictment as presented?
Your Honor, we will waive the repeat offender enhancement with that case as well.
No objection.
All right, Mr. Jimenez, did you review the documents entitled Court Admonishments with your attorney? Did you understand it? And
Yes,
did you sign it in all the appropriate places?
yes, ma'am, I did.
You're charged with evading arrest, detention with a vehicle and assault family household member with a previous conviction. Those are each third-degree felonies. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, I do.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. Did you understand by entering into these plea bargain agreements, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes, I did.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Jimenez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am, I am.
Are you a U.S. citizen?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, I do, and I did.
All right, according to the plea bargain agreement, punishment is to be assessed at 6 years in the prison. In one cause number, there's a $1,500 fine. There are no applications in either cause number. The cause numbers are to run concurrently. The state will take in consideration 2025 CC 002355. And the cause number ending in 37, there's an affirmative finding of family violence and there's to be no contact with the complainant. Did you understand that to be your plea bargain agreement in each cause number?
Yes, ma'am.
Defense, is that the plea?
That is.
State?
It is the plea, Your Honor.
Did you review the waiver of appeal paragraph in each of the cause numbers with your attorney? Did you understand it and sign it in both places?
I did, yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
Motions have been filed, but none heard, Judge.
And cause number 2025 CR 001924, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right. And just so the record can be clear, in cause number 2025 CR 000637, did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
And did you understand that also with an affirmative finding of family violence, you cannot be designated as primary custodial parent?
Okay.
No, not okay. Do you understand that?
Yes, ma'am.
All right. Knowing those things, do you still wish to proceed with this plea?
Yes.
All right. Then in cause number 2025 CR 000637, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, and each cause number, is there any evidence to support the defendant's pleas?
Yes, Your Honor. With regard to both cases, they will offer each evidence as exhibits 1 for 2025 CR 001924. And with regard to 2025 CR 00617, in terms of one contest.
Any
No
objection?
no objection in either cause number.
All right, and state in the cause number with the complainant that he is to have no contact with you. I mean, with her, have you had any contact with the complainant?
Yeah.
All right, thank you. You may be excused. In each cause numbers, did you review the document entitled Waiver and Consent to Stipulations of Testimony and Stipulation with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in, the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. State. And Miss Christian, I sent you a text message. Well, not a text message, a chat.
Just answered.
And I just sent you another chat. Do you remember Attorney Barbara Slavin?
Oh, yeah, I do.
That's what she would always write. And I would say, why are you shouting?
Why are you yelling at me?
And she's like, I'm not yelling. Now I understand what she meant. All right, while the state is doing that, in regards to cause number, we're back on the record. In 2025 CR 001924, the court is going to find that there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, please.
All right, and that cause number, the court will sentence you to 6 years in the prison, give you credit for any time served. This is run concurrent with 2025 CR 000637. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because that's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right. And let me give you a copy of your trial court certifications.
Thank you, Judge. Thank you.
You're welcome. Rick, are you able to find it? We're off the record while they're getting that. Here's the thing. This whole, what I've read in the police report, if you think somebody's paying attention too much to somebody that you care for, guess what? Be happy that somebody thinks the person that you're with is attractive, intelligent. But there's no cause for any of this. Now, what's going to happen is you're going to prison. You know? And if you think somebody is being unfaithful to you or cheating on you, then you only really have two choices in life. Either you accept it and forgive them, or either you say, I didn't sign up for this, this relationship is over, and keep it moving. But you don't do this because otherwise you end up where you are now, which is going to prison.
I understand, Your Honor. I know I'm in a toxic relationship, right? I did try to file for divorce with her. She doesn't want to file, she doesn't want to sign the papers.
Oh, then you just keep it moving. And you can write a Lifetime movie about how you're such a great guy, so attractive, so intelligent, that this woman cannot leave you alone. But what you did in this, you can't do that. You got to let it go, you know, and move on. And if somebody won't give you a divorce, I will tell you, you can get a divorce from somebody if you really want a divorce, whether they show up or not. I've had people before, they said, I'm not going to agree to service. I'm not going to let you serve me. Guess what? Texas has something where you can actually just serve it by placing it in a newspaper, and they'll put it on a board at the courthouse. And that's your constructive service. So this whole thing where I'm never going to give you a divorce, catch me if you can and get somebody to serve me divorce papers, it's really a bunch of nonsense, because you can get a divorce without having to physically serve somebody.
It's not like not giving the divorce. It's like, I don't know how to go about it, you know? Either it's a financial problem or whatever it means. I don't
Oh,
know.
you can go to the Bear County Courthouse. They actually have somebody over there who will help you. Now, if you're fighting for major property and everything, that's something different.
And well, she has I have a daughter with her, and she holds. See, I pay.
Let me ask you something. And this is just information for me and what I always tell my clients. What I would tell my clients, that person who you say is toxic, who is now acting crazy. Yeah, once in a while, somebody will appear like this great person. You've dated them for 2 years. They've been great. Time when you sign paperwork, they turn in this other person and they're crazy. But usually you have some red flags that there is some crazy in that person, but you just choose to ignore it. We're back on the record. Any objection, Ms. Christian, to the amendment of the state's waivers?
There is no objection.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence in cause number 2025 CR 000637 to find you guilty. The court will find you guilty. Court will sentence you to 6 years in the prison, give you credit for any time served. There's a $1,500 fine, time and money to run concurrent. This will run concurrent with 2025 CR 001924, taking consideration 2025 CC 002355. There's an affirmative finding of family violence. There's to be no contact with the complainant and no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
And did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record, make better decisions. All right? If you have an anger issue, you better take care of it. Because ask yourself, do you want somebody to treat your daughter the way you treat others? I think the answer to that is no. You know what somebody once said? They said a daughter's first boyfriend is her father, because from that person, they learn how they're supposed to be treated in relationships. All right? Good luck to you.
Thank you.
May I be excused, Judge?
Yes, you may. Thanks. Have a good
Thank
one.
you. You too.
Willard Cummings. If anybody else is ready, please just let the clerks know so they can put your file up here. All righty. So we are here for a bond.
Yes, Judge, we have a motion to set bond.
All right, let me just pull up his case very. All right, and did y'all give me the paperwork to sign the dismissal on Fernando Jimenez? The one that was taken in consideration? Okay. Jimenez. They're supposed to contact Dr. Jimenez. All right, Adrian Morales. I was wondering where you are. You just pop up like bam. And you're here.
I slink around, Judge. A lot of training doing that.
I was just gonna say, where is he? I know he was supposed to be here. All right.
Minute or two.
All right, who is here on Paul Garay? And after Garay, it will be O'Banion. And then it will be Morales. Probation, there are no applications in this case. Court is calling 2025 CR 0034660 State versus Paul Garay. Bad parties announced for the record.
Todd Coronado for Mr. Gray.
This is a lot of paperwork for a possession less than a gram. All right, and are you Mr. Garay?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garay, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Yes. Mr. Garay, did you review court admonishments with your attorney? Did you understand it?
Yes, I do.
And did you sign it in all the appropriate places?
Yes.
Did you understand your charge of possession of a controlled substance penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
I do.
If you have a plea bargain agreement with the state, the court does not have to follow that agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
That's correct, Your Honor.
Mr. Garay, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 103 days in the Bear County Jail under 1244, and there's an $800 fine. Did you understand that for you to plea?
I did.
Defense, is that the plea?
That is, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers states one in attachments.
No objections, Your Honor.
All right, state, you may be excused. Did you review the documents and title waiver and stipulations with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
I did.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the following. The court will find that there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, he was basically was in the wrong place at the wrong time that evening, and he wants to put this incident behind him, get on with his life, because he's soon or turning 50 next year, so he wants to put this behind him and move on with his life. Is that correct, Paul?
Yes, ma'am.
All right, the court is going to find you guilty. The court will sentence you to 103 days in the Bear County Jail under 1244. Give you credit for any time served. There's an $800 fine. Time and money will run concurrent. There's to be no contact with the following people: Joseph Lee Angelus, Gregory Lee Green, Jennifer Lee Flores. Let's see. Just one moment. And there's to be no contact with 12350 IH10 West, San Antonio, Texas 78230. Did you review the documents entitled Trial Court Certification of Defendant's Right to Appeal with your attorney? Did you understand it? And did you sign it?
I did.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I do.
All right, we can go off the record. Here's the thing. When you're released from the Bear County Jail, If you need help with your drug problem or to maintain your sobriety, if I am here, you can always come back here and I will pick up the phone and call for a place to help you. Because otherwise, only two things are gonna end up happening to you, right? Either you're gonna end up back and forth out of jail, back and forth out of prison, and your time is gonna start running by very quickly because you're almost 50. So I'm in the same boat as you are, because if I have more of my life behind me than in front of me, unless I'm planning on living to be 200 or something. I hope it happens and I hope I'm in good shape. But if not, it's not gonna happen. So if you don't end up in and out of prison, somebody's gonna end up identifying your body, and you don't want that to happen, okay? All right, good luck to you, all right?
Thank you. That's what the officer Weiss said, the same thing. He said, you're a good guy and you're out there. One of these times it's gonna hit you in the butt, and it did because of being around the facilities.
Oh, yeah. And then you have a lot of things going on. You're homeless, you're living on the street.
Yeah.
You're using needles. You don't know if there's some kind of germ on the needle. And when people are giving you drugs and you're getting drugs, there's no FDA requirement. People are just mixing things. And if you were to die, you know what they say? That's okay. We have another customer. They don't care, right? All right, good luck to you, okay?
Thank you.
You're welcome.
I think I'm maybe excuse.
Yes.
Thank you.
All right, you're ready? Okay, thank you. Random Mob. If you come down, and how do you pronounce your last name? Is it Mab? All right. Court is calling 2025 CR 004527 Stace versus Randall Mab. Could I have parties announced?
James Scott Sullivan for Mr. Mapp.
And are you Mr. Mab? Counsel, you received all discovery. Did you review it with your client?
Yes, I did.
Court will find that the state is in compliance with discovery. Mr. Mab, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, I did.
State, are you proceeding on the indictment as presented? Mr. Mab, did you review the document entitled admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged with offense of theft of property, less than $2,500 with 2 or more convictions as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. Did you understand by entering this plea, you are giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Oh, yes.
Mr. Mab, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 8 months in the state jail facility and there are no applications. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, it is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yeah.
And did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, do you have any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Objection.
All right, state, you may be excused. Did you review the stipulations and waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes.
Yes, Your Honor.
Anything you wish to say on behalf of your client?
I'll let my client address the court. Go ahead, buddy.
Yes.
I wanted to ask you, they said that, he said I had to ask you, I was trying to get deferred, so I didn't have a felony.
Well, I want Gretch you deferred on this because it appears that you can't stop stealing. So there's no need, if you don't want to have a felony on your record, you know, the easiest way not to have a felony on your record, don't pick up felonies.
No, he's ready to be sentenced, Your Honor.
All right, the court is finding you guilty. The court is going to sentence you to 8 months in the state jail facility, give you credit for any time served. There's to be no contact with any quick trip. And they spell it in here as QUICKTRIP. And I'll suggest a therapeutic community. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Oh, and I'm sorry, and there's to be no contact with Amanda Vogt V-O-G-T Martinez. All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you don't have the court's permission to appeal. Because this is a felony conviction, you're not allowed to possess or own any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. How old are you?
36.
All right, 36. And you're out here in the world stealing beer from Quick Trips. Guess what? Quick Trip, these other places that you're committing thefts at, they're trying to run a business. And in running a business, they like for people to pay what they take. So, and you're telling me, I really don't want to have a felony on my record. You are a grown adult. It's not like you're 18 or you're 12 and you keep going into stores, taking items that don't belong to you. And you're going to have to sit and ask yourself this question. As you're doing your 8 months in jail or at the state jail facility, which is day-to-day time for some beer that costs you $13, you need to ask yourself, is $13.50 worth 8 months of my time in the facility? If you think it is, you'll continue on this path. And at some point in time in Texas, people end up getting shot, getting killed for taking things that don't belong to them. And then you know what people say? They say, oh, well, sorry, that's so sad. And they keep moving. So if you don't want that to be you, you need to stop stealing. All right, good luck to you. All right, Shayna Gonzalez, you say she's on GPS, she's not in custody?
Yes, Judge. And I like to let monitor.
All right, Norma, have you got in touch with Mr. Michael Bellevue?
No, I haven't.
No, I want you to call Mr. Bellevue and let him know that his client is supposed to be in the 187th. And since she's not here, a warrant is going to be issued for her arrest. All right, Ms. Abrams, on this one, they said that they had done a MIC evaluation. Thank you. We're going on the record in 2025 CR 0000451, State versus Leslie O'Banion. Could I have parties announced?
That's Dwight Shumley for Miss O'Banion.
Yes. All right. You entered a plea of no contest on May 12th. 2025. According to your plea bargain agreement,
May I give you this, ma'am? Ms. Susan Boyd?
to what point, why are you giving me that?
It's my word.
It's your
for
what?
you, ma'am. It's for you, Judge. Thank you.
No, what is it for? That's what I'm trying to.
Motions That I did.
All right, so here's the thing, you've entered a plea, unless that's a motion to withdraw your plea, that is, it's not appropriate at this time, okay? All right.
It's kind of is. But
Well, I mean,
I would just like to, I did the work. on it.
Your Honor, it's a
It's
writ of
okay.
habeas, it's a writ of habeas corpus.
It's a written motion to reduce state jail felony to misdemeanor.
All right, so the state jail felony is
And
not
writ
being,
of habeas corpus.
all right, the state jail felony is not being reduced to a misdemeanor. All right?
Well,
No, I
You know,
appreciate
because
it.
he's
No,
not
no.
really doing a job. for me.
No. He's actually doing an excellent job for you.
I don't agree, but okay.
Well, I mean.
And that's what I got. So that's what I got to deal with. So I signed up
Well,
probation.
no. Here's the thing, what I'm telling you, and this is what I want
Just
you to
would
hear
like to
me.
go home
I want you to hear,
on probation, and that's what I signed for Monday, right, Ms. Boyd, Ms. Leslie O'Banion? I signed for 3 years deferred.
Mhm.
So I did my cap of balance inside, so I'd like to be released to have probation, ma'am. Thank you. That's what I find.
all right, so let me just tell you right now, that's not what you signed up for. What you signed up for is, there was a plea bargain that was entered into. And guess what happens with plea bargain agreements? I'm the person who sets conditions, and I'm sure your attorney told you that. So whether or not you're released today, it's really up to me. So that's where we are.
Yes, ma'am, thank you.
I don't know why people continue to think that
I
everybody
don't know
can.
why I thought
Here's the thing.
probation's outside the jail, and
All
it
right,
is.
so then what I'll do, if you're gonna continue,
No, ma'am.
if you want to continue to talk over me, then you can do so.
No, ma'am,
But you're
I
gonna
don't
be
wanna.
talking,
So I'm
but
sorry. please
you
forgive
are
me.
going to be talking over me and talking by yourself. And what I will do is I'll just set this for another day. So
I'll quiet.
what I'm telling you
Yeah,
is, I do not understand why everybody thinks that they can be an attorney without a license. If everybody could be an attorney, then guess what? We would not have gone to school for it. So,
God bless you. ma'am.
Mr.
Thank you.
Chumley,
Mhm.
thank you for your patience.
Thank you, sir, and thank you, ma'am.
All right, so this is
Ms.
what,
Judge Stephanie Boyd, please forgive me, and I'm sorry, I'm just very, miss my family very much. So I've been in for 410 days and I would like to see my family. It's my birthday this month. And I miss my family tremendously.
well, here's the thing.
So I
If you
love my
could, if
family.
you
and they love
continue,
me.
if you continue to commit offenses, then that's not showing love for your family, because the reason why you're not with your family now is because you've
I've
committed an
been away
offense.
from my family and I've
And actually, the offense,
suffered very much
the
inside
offense,
Air County Jail, ma'am.
the offense that you have committed is
Okay,
an
cool.
injury to the elderly or disabled
Wow.
person, bodily injury. And that person is an elderly person. So that's why you are here. And what I can tell you is, if I follow this agreement, you are not going back to that location. You're not going to be allowed to be around any of those persons. Do you understand? Maybe she understands, maybe she doesn't. All right, so defense, this is my concern.
Okay.
My concern, have you all both read the MIC evaluation?
I have PTSD.
This is my concern in here. In my concern, she says she doesn't have any mental illness diagnosis, demanded that those be taken off the records, and that she will not be taking medications once she's released.
I have PTSD trauma. I do have that, ma'am. I do not have bipolar. So that seems to be a problem. It's outdated information from when I was 28 years old. I'm 48. I'm gonna be 49 this year. So that's very old medical stuff that's out of date, ma'am. All right.
I'm sorry for that, but that is actually true. I have PTSD, I have anxiety, I have trauma. That's what I do, diagnose it.
All right, probation.
Thank you.
How
Sorry.
are we gonna handle this? She's saying that once she's released, she's no longer gonna take her medications.
I
Is
actually
there
am.
any?
So I have insurance. I'm gonna see my doctor. That's what I told the lady on the Taco Bell, ma'am. So I'd like to finish that, and I'm sorry she didn't put that in there. There's miscommunication happening, and it's really important to me, ma'am. I have insurance and I take very good care of my health. I actually have therapy set up for me already for when I'm released. I did that inside jail for the Rape Crisis Center. That's free therapy for me that I need. And I'm also going to go see my doctor and get on medication when I'm released. I take regular meds for myself and I take very good care of my health. I have health insurance. I'm on disability. So I plan on following up with my doctor I see currently in the Quarry Market. I have a doctor already. I have a pharmacy at Walgreens. So that is not actually true. I'm saying I have to follow up with my doctors on the outside where I take care of my health. And
All right, so
my mental health
probation,
is important to me.
how are we gonna address this issue? How do you suggest we
So
address it?
I'm gonna be taking meds. I will be complying with that. So that is not true, ma'am, and I'm sorry she wrote that. So
All
I
right.
wanted to clarify. Please forgive me,
Thank
but
you
that
for-
is important.
Thank you for your clarification.
Yeah.
Probation, how are we gonna handle this?
I will be taking my meds. So
Judge,
I need to get them adjusted. Thank you. With the proper
Judge.
physician. Mine.
we can
I take meds
get
inside
it.
their county.
We can get an authorization to obtain records to ensure that she is actually
Walgreens,
going
Lincoln
to.
Heights.
All right, just one second. So let me ask you something. Ms. O'Banion,
Yes.
it appears as though maybe you're not medically
They have
compliant
out of
with your
date.
medications. The reason why I say that is because you're not able to control yourself at all. You're speaking over everyone who is talking. I've asked probation a question. You keep interrupting her.
It's,
So
I'm not.
what,
gonna
let me do this. What do you want to say to me? I'm here to listen.
Ma'am, what's happened since I've been incarcerated is they have out of date information. So me trying to update somebody that has old information, like I said, on me when I was 28 years old is so out of date. It is. I'm 48 years old, ma'am. So I've changed my life. I went to prison in Plain State 10 years ago and I changed my life, and that does matter. Okay? So I live a very good and healthy life for myself. I take care of myself and I support my own self. I'm a single woman. I live alone. I have a pet. And that's what I do. I support myself. I don't rely on a man. I take care of myself. And I've lived that way for a long time. I'm very strong, independent woman. That's the way my mom raised me. So I'm blessed to have that. You know, I pay my bills and I always have a pet because I have trauma. I've groomed animals. I'm retired. And so I always have a fur baby. You know, I gave up my son for adoption. And, you know, this was something I forgave my stepdad. I didn't report it. And I felt sorry for him. He's an older man. So it's my fault for that. There is issues there. He is crazy and he has broken my bones in the past, ma'am. I just didn't feel right about doing something against my family. So it's okay if they say I did something to him, and that's fine. So I apologize, but this is what really matters to me is I love my family and I miss my family very much. My brother has my car waiting for me.
They do not want to have any contact with you according to the police report. So
That's fine.
I'm not gonna allow you to
but
have
I've
contact
talked to
with
my brother inside jail,
All right.
and that's my brother. I have other family members, man, and he's married. So that's not my mama.
Okay.
And that I can still talk to my mother. That's my mom. She's married to my stepdad. I'm gonna not talk to my stepdad. That's the person, Danny. Okay, so that's one individual. So I'd like to clarify that. I'm not gonna already get in trouble when I'm not even released out, when I have families. There is toxic issues there. So that is a problem with that man. He has issues. So I will not be seeing my stepdad, period. I can see my mom on my own. She can come to my apartment. And that kind of thing, same with my brother. But, and his wife and kids, the same applies. I'm not gonna be seeing my stepdad though. I've already decided that myself personally. So I'm a strong woman, you know, but I would love my other family. I'm not gonna not see them. They love me.
All right, is there anything else you want to say?
And please forgive me, ma'am. I do take care of my health and I'm sorry that I've tried very hard because it's important to me to update people that had information on me. And it is important because that's about my health. And that's when somebody has old information that's not current, it needs to be updated, just like medical files, you know?
All right, is there anything else you want to say?
And please forgive me, ma'am. I am a very respectful person.
Is there anything else you want to say?
I'm sorry for talking, ma'am, but
Oh, no, you can
This-
talk. I'm giving you time to talk right now. Is there anything else you want to say?
you can call me crazy and say that, but I
Oh,
do
no,
love
I'm
my
not gonna
family.
call- I will
I'm a
not-
very strong
I
woman.
will not call you crazy. Is there anything else you want to
can.
say?
That's fine. I'm used
Well,
to
I
people
will
calling
tell
me
you
that.
this, I refuse to call you that.
Thank you. I don't like the stigma.
All right, so is there anything else that you
No,
want to say to me?
no, ma'am. And I think you're a very awesome judge. You're doing a great job. And you are. And thank you for helping me.
All right, probation.
Thank you.
You're welcome. Probation,
Yes, Judge.
how are we gonna handle the fact that in the MIC evaluation, they're saying that she's not gonna take her medications? What do you
So
suggest?
I am.
All right, so here's the thing. I'm giving you time to speak.
Yes.
I did not interrupt you. I let you talk for as long as you want to talk. So now it's someone else's turn to talk. So do not interrupt them. And I want you to hear me clearly and internalize what I'm saying. If you interrupt them, what's going to end up happening is I'm going to send you back to jail. We are not going to hear this and I will bring you back on Monday. Do you understand? All right, probation. How do you suggest we handle this?
Judge, I think we should probably get an authorization of release so that we can be in contact with the individuals that are taking or prescribing medication, her doctors. We can do a referral for Center for Healthcare Services. I believe the MIC evaluation indicates that she is not eligible for DDRF.
Yes.
However, she is eligible for the MIC caseload, I believe. And we could put her on the MIC caseload.
Okay. Is there anything else you think she would need?
Would you like to send me to DRF instead?
Did not tell you, no more interrupting.
Go ahead.
Yes.
Never let me out. Send me to DRF. Go ahead. I pray every day.
Judge, I really can't think of anything else other than maybe, you know, a life skills course or moral recognition therapy or something like that.
Okay. All right, this is what the court is gonna do. Court is gonna sentence you to 3 years deferred adjudication. I'm sorry. 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, $1,500 fine, time and money to run concurrent. I'm sorry, that will be probated. Take in consideration 2025 CC 000947. There's an affirmative finding of family violence. There's to be no contact with Danny Cox, Timothy O'Bannon. There's to be no contact with 14450 Old Frio City Road in Lytle, Texas, 78052.
Can't ask.
There's to be, she's gonna be placed on the MIC caseload. Referral to Center for Health Care Services. The defendant is to sign a release for mental health information. There's to be anger management course. TAP evaluation. That can be done out of custody, follow recommendations. Field visits 1 time per month until further notice. And there's to be no contact with minors.
I have
Probation, is there anything else?
hate children.
I'm sorry, what?
Like any type of employment or SSI.
Yes. Proof of employment or SSI within 30 days of release, no employment as a home health care provider or with minors.
I hate to ask you to do this, Judge, but can you give me that address again?
Yes.
She live in Bear County. You live in Bear
I'm gonna probably be relocating, I think.
County.
So I
Be right-
reside here now, but I will be relocating and moving my.
You do live in
information
Bear County.
No,
Where do you live?
yeah, I live nowhere right now.
All right, so
I haven't decided, I'm gonna be leaving, so I'll relocate.
you're to remain in Bear County until the court approves you to leave Bear County.
Cool.
If
I'll
you
be
leave-
hiring a realtor.
If you leave Bear County, what will end up happening is a warrant will be issued for your arrest.
I can relocate with something.
All right.
To another. city. Thank you.
Probation, is there anything
Okay.
else? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, counsel, did you review the trial court certification with her?
Yes,
And did you explain it to her?
yes,
And did she place her signature on the document?
yes.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. All right, thank you. State, make sure that you make the complainant aware of what has happened here today and that
Can I have
there's a
copy of
no
my
contact
probation
order.
paper?
Okay,
May I have a copy of probation paper?
you understand?
Yes.
All right, thank you.
My lawyer said it costs money.
Oh, that's hard.
All right, Ms. Abrams. She's to remain in custody until the TAP evaluation. Counsel, if you can approach, please. And do a TAP evaluation and a referral to felony drug court. All right, so based upon what your client said as she was going through the door, I honestly don't think it would be safe for the community or for her to be released from jail now. So we're gonna do a TAP evaluation while she's in custody.
Okay.
Do a referral to felony drug court. And
Yeah.
felony drug court can potentially address any mental health issues.
I think that's wise.
And also, if you want, we can also do a referral to the mental health court, which is across
Yeah.
the way. And state, if you have no objections, if they decide to accept her, because they'll only accept them if they're not on probation.
Right.
If they decide to accept her and you're in agreement with it, we can do a motion for a new trial and I'll grant
Okay.
it so that she can be there.
And I would like to say just some, Your Honor, I did have her psychologically evaluated. She was found competent.
Mhm.
And then these things are fluid, and I understand that, but she's never not understood what's going on. She has ideas of what she wants to see happen, but
Mhm.
I think she needs help, obviously. She needs mental health. So
And there's already a trespass order, a no trespass order in place with her family. I don't know if she understands that or
Right.
not, but.
Thank you, Judge. Appreciate
My
you.
concern while we're here is that if we move her across to the women's health court, my understanding that that's out of custody instead of in custody.
Well, not necessarily. They'll see what is appropriate for her. So if they decide that there's some sort of mental health treatment that she needs to do inpatient, they'll do that.
That's what I prefer. I just wanted her to be like mentally clear to rejoin the community, I guess you could say, because I think she's safe enough to rejoin the community.
Yes.
Thank you, Judge. And be excused?
Yes,
All right,
thank
appreciate
you. Oh, and probation, once the evaluation for felony drug court and TAP evaluation is done, she's not to be released, just have her brought back here.
Okay.
All right, thank you.
Cheers.
Yeah, that's to be done in custody.
Yes.
All right, the people we have left on the docket are
We have another key.
Jeffrey Guerrero,
I haven't had a chance to chat with you.
all right, Felipe Reyes,
I have a client that just, I'm talking to him outside here, but this morning I haven't had a chance to talk.
okay,